have the honour to lay upon the table the report of the Privacy Commissioner concerning the Privacy Act for the fiscal year ended March 31st, 2012. Pursuant to Standing Order 1083H, this document is deemed to have been permanently referred to the Standing Committee on Access to Information, Privacy and Ethics. Tabling of documents, dépôt de documents. Introduction of government bills. Déclaration de
Statements by ministers.
Reports from interparliamentary delegations. The Honourable Member for South Surrey, White Rock, Cloverdale.
Mr. Speaker, pursuant to Standing Order 34.1, I have the honour to present to the House in both official languages the report of the Canadian delegation of the Commonwealth Parliamentary Association respecting its participation in a bilateral visit to South Africa.
Honourable Member for Renfrew, Nipissing, Pembroke.
34.1, I have the honour to present to the House in both official languages the report on the Canadian NATO Parliamentary Association respecting its participation at the Economics and Security Committee's consultation with the Organization for Economic Cooperation and Development, the OECD, held in Paris, France, February 10th and 11th, 2012, and the joint meeting of the Defence and Security, Economics and Security and Political Committees held in Brussels, Belgium, February 12th to 14th, 2012.
Presenting reports from committees. Presentation des rapports de...
Presenting reports from committees.
Thank you, Mr. Speaker. I have the honour to present in both official languages the fourth report of the Standing Committee on Environment and Sustainable Development. In accordance with its order of reference of Wednesday, September 19, 2012, your committee has considered Bill C-370, an act to amend the Canadian National Parks Act, St. Lawrence Islands National Park of Canada, and agreed on Wednesday, October the 3rd, 2012, to report it without amendment. Thank you.
Introduction of private members' bills. Mr. Scott, seconded by Ms. Davies, Vancouver East, moves for leave to introduce a bill entitled An Act to Amend the Criminal Code, Consent. This motion is deemed adopted. The Honourable Member for Toronto Danforth.
Hear, hear. Thank you, Mr. Speaker. I rise with pride to introduce this private member's bill, and I thank very much the Honourable Member from Vancouver East for seconding. I would note that the Honourable Member is the health critic, which is actually very relevant to this motion to introduce the bill. This bill will repeal an outdated provision of the Criminal Code that unconstitutionally discriminates against members of the LGBTQ community. Essentially, the goal is to repeal Section 159 from the Criminal Code, which discriminates against the gay community with regard to sexual activity and the age of consent. As far back as 1995 with the Ontario Court of Appeal and 1998 with the Quebec Court of Appeal, this provision has been deemed unconstitutional. For that reason, this is essentially a constitutional cleanup. This is something that should have happened under successive Liberal and Conservative governments. It has not happened. It's the fourth time that an NDP member has risen to table a bill to repeal this provision. I would like to end by reading a short quote from Jeremy Diaz of JER's Vision, who says, quote, "During the Senate debate of Bill C-22 some years ago, JER's Vision requested equalization of ages of consent for gay sex. The current legislation creates a double standard for gay youth, not only discriminating but also leading to other challenges. One we are seeing is that safer gay sex is not talked about in school. The existing legislation is not reflective or effective of the realities of youth, and Mr. Scott's bill is urgently needed to empower youth and support them in making healthier and safer decisions in their lives." Thank you, Mr. Speaker.
Great work.
Mr. Scott, appuyé par Madame.
Mr. Scott, seconded by Ms. Davies, Vancouver East, moves that this bill be now read a first time and printed. That motion is deemed adopted.
This bill, première lecture de ce projet de loi.
When shall the bill be read a second time? At the next sitting of the House. First reading of Senate public bills. Motions, motion. Presenting petitions, présentation des...
Presenting petitions.
For Thunder Bay, Superior North.
Thank you, Mr. Speaker. I'm very pleased to present a petition today from various Canadians, including from Vancouver Island, who have petitioned to establish a permanent ban on crude oil tankers on the West Coast to protect BC's fisheries, tourism, coastal communities, and natural ecosystems forever. Thank you, Mr. Speaker.
Presenting petitions, l'honorable député de Jonquière.
Honourable Member for Jonquière-Hermont. Thank you, Mr. Speaker. I table a petition today for my constituents from Jonquière-Alma. It concerns development and peace. The government recently cut some projects, so people are asking money to be invested to help people in all the international communities. Thank you very much, Mr. Speaker.
The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. I rise today to present 3 petitions. The first one calls on the government and the Prime Minister and Cabinet to create a special inquiry to ensure that we get to the bottom of who was behind the attempts at electoral fraud in the 2011 election. This comes from residents of Halifax as well as from Vancouver and other parts of British Columbia. The next petition, Mr. Speaker, calls for a legislated tanker ban for the coastal waters of British Columbia from residents of the Vancouver area. This is a critical need as we've had an unlegislated moratorium since 1972. Further, Mr. Speaker, my last petition is from residents of the Victoria area supporting a private member's bill, C-322, to ensure that under the Health of Animals and Meat Inspection Act, we prohibit the importation and use of horses for slaughter for human consumption. Thank you, Mr. Speaker.
Presenting petitions, the honourable member for St. John's East.
Thank you, Mr. Speaker. I rise to present a number of petitions all to the same effect, asking that the Government of Canada reverse its decision to close the Canadian Coast Guard Marine Rescue Subbase Centre in St. John's, Newfoundland and Labrador, reinstate its staff and restore its full services. These petitioners are from St. John's and other parts in and around my riding, Mr. Speaker, but it's noteworthy that there's also a number of signatories from other provinces of Canada, including British Columbia, Nova Scotia, Prince Edward Island, and even Manitoba, and Prince George, BC as well, and Ottawa, Ontario, calling on the government to reverse this decision, noting that this rescue base of the Newfoundland and Labrador region has the highest proportion of distress instances in Canada, and that 600 lives per year have been saved. And each year, 18 lives are lost on average. This is extremely important to these petitioners. Thank you, Mr. Speaker.
Presenting petitions, présentation des pétitions.
Presenting petitions.
Paper, the Honourable Parliamentary Secretary of the Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, I ask that all questions be allowed to stand.
Is that agreed? Agreed and so ordered. Orders of the day, order du jour.
Orders of the day, Government Orders, Government Bills, Commons, resuming debate at second reading stage of Bill C-43, Faster Removal of Foreign Criminals Act.
Resuming debate. East du débat.
Resuming debate.
Or Hamilton East Stony Creek.
Thank you, Mr. Speaker, and I'm pleased to rise today to speak to this particular bill. Mr. Speaker, in a democracy, due process is the very lifeblood of our freedoms, of protecting our citizens' rights. You know, political power as such must rest with this Parliament and not with any given minister, or any move that's seen as usurping the power of Parliament certainly has to be at the very least questioned in this place. So today, as we're talking about Bill C-43, you know, I would suggest that this particular bill, coming on the heels of some very heated criticism of this government and the refugee reform Bill C-31, and also cuts the health care that we hear spoken of in this place, it would seem to us that perhaps this government's trying to change the channel with C-43. You know, their mantra for the last 6 years has been pretty much, you know, tough on crime, and to some extent they've even extended that past the point of reality to a great deal of spin. You know, when the government members speak about the need for C-43, they use some pretty extreme examples of foreign nationals and abusing the immigration appeal process to blow smoke over the fact that this bill is designed to effectively remove checks and balances that permit within our system some flexibility for extraordinary circumstances, Mr. Speaker. Now, I am a believer in due process and the need for the right to an appeal, because not everybody's story is the same, Mr. Speaker. There's a variety of things that can happen, and we'll touch on those as we move forward. But I also support the ability for humanitarian and compassionate consideration to those people who in other terms might be inadmissible on various grounds: security, humanitarian, international rights violations. Organized criminality would be another. There's exceptions to every rule, Mr. Speaker. There are many times that the whole story needs to be truly evaluated in regards to a removal order. We've had situations in Hamilton, for instance, of at least one woman that I'm aware of who have had a number of children born in Canada, and she received a removal order that's been suspended. But had there not been some reconsideration of the facts of that case and a pause for a second look at it, her and her children would have been forced out of this country. They may, in due course, still be forced to leave. But at least, Mr. Speaker, they will have had the benefit of due process and a real evaluation of their situation. And I want to stress that the New Democrats do recognize the need for efficient and responsive judicial apparatus for the removing of serious criminals from Canada. Having said this, we do not support closing the door, though, on an appeal process. There has to be balance. None of us are perfect, nor are the ministers of the government. And the reality is sometimes, some places, innocent people, or maybe not totally innocent people, but inappropriately would be moved out of this country too quickly if they didn't have the option of appeal. We also are concerned, and in my opening remarks I talked about the supremacy of Parliament, and we don't support granting the minister the power to unilaterally prohibit a foreign national from becoming a temporary citizen for up to 36 months based on public policy considerations. Mr. Speaker, this is just simply too vague. You know, and I would suggest unnecessarily too broad as well, of an application of ministerial discretion. We have respect for the ministers of the government, and we understand that in most instances they're doing their due diligence as they see them. But granting extraordinary powers is not going to be in the best interest of Canada and the rights of Canadians. New Democrats stand with newcomers who want the government to focus on making the immigration system faster and fairer for the vast majority who have not committed any crimes and who follow the rules. All of us, practically every member in this place, has the stories of people who, good souls, who waited in line, made the applications, and filled the forms and did all of the things that were required of them to gain access to becoming and eventually becoming a citizen of Canada, to be in almost suspended animation for years, waiting. And so we want to be sure that whatever changes are made are fair. Now, the minister's office, when they speak about this particular bill, they talk about tough but fair measures and repeatedly emphasize it's easy for non-citizens to avoid deportation. Well, the reality is, don't commit crime, and that's understandable. That's certainly something that we support. But C-43 redefines serious criminality for the purposes of access to appeal. And again, Mr. Speaker, I keep coming back to that area of appeal, that area of a last chance. Once we do reach the conclusion of a final deportation order, Canadians would expect that we're absolutely sure of the necessity and the importance of removing that individual. I would suggest that this change merits further committee study. And I haven't said it so far, but we'll be supporting this bill going to committee because we do understand that there is an issue. It's not a circumstance where we're on this side of the House saying we're just going to oppose blindly. We're going to go to committee and we'll offer positive suggestions of change for this bill. We'll offer our hand across this floor to the government to ensure that whatever bill is put forward accomplishes the job at hand but protects people's rights in the course of that effort. The narrowing of circumstances under which humanitarian and compassionate considerations can be taken into account makes the system less flexible and has already raised concerns from groups advocating for people with, for example, mental illnesses who may not have been in control of themselves at the time that crimes were committed. That's right. There has to be some consideration for that circumstance. I have had family members over the years who had various stages of depression or various stages of mental illness, and in one case a close relative was medicated for all of her life and was hospitalized for a 10-year period for a very serious situation. But in that time, she was not in control of who she was. That person, by the way, was my own mother. Many people in the community that feel the broader discretionary powers the C-43 grants the minister to issue or revoke a declaration that would prohibit a foreign national from becoming a temporary citizen for up to 36 months, their opinion is that this goes too far, and I think that that's something for the committee to study, for the committee to give consideration to. Another level is troubling to note that the Conservatives have marketed the bill almost exclusively on its design to speed up deportations of serious multiple offenders. Could that be to draw attention away from the fact that C-43 removes an appeal process and would bestow these extraordinary powers, new discretionary powers, to the minister? This is not a case where decisions should be one-person decisions. Very serious decisions take place relative to removing somebody from our country. You are impacting that person's life, the life of their family and their children. And yes, there are occasions it is absolutely necessary to do, but we want to be sure that those occasions have had the due process, had the appeal process, and that we reach the conclusion that that person must leave. We can do that in clear conscience, knowing the facts, and not relying solely on the judgment of the minister. Now, I'm going to skip through part of my speech here, Mr. Speaker, because I think my time is... How much time do I have, Mr. Speaker? Thank you. I thought I was getting close. So I want to refer to 1999. The Australian immigration system underwent a reordering with striking similarities to what's before us today, and it's often worthwhile to look at another country, particularly a democracy similar to Rome. The mistakes that made in the Australian case were clear, well documented, and for some reason our minister today thinks Canada ought to repeat them. Previous to 1999, individuals were protected against deportation if they were residents of Australia 10 years or more. However, new amendments made the Act gave the minister new powers to dismiss appeals by individuals without judicial review, many of whom arrived in Australia as infants. I mean, that kind of excessive power is what we were concerned about. That's what the NDP is concerned about, that an appeal process was shoved aside and these extraordinary powers were granted to the minister, and the terrible effects that that have on your community and their view of what life is like in a free country. So I see you're giving me the signal I need to wrap up, Mr. Speaker. Thank you very much. I appreciate the chance to speak on this bill.
Questions et commentaires.
Questions and comments?
L'honorable député de La Prairie, si la petite patrie.
The honourable member for La Petite Patrie.
Rosemont, excusez.
I'm sorry, Rosemont, La Petite Patrie. Thank you very much, Mr. Speaker. I'm sorry for my colleague. But I would like to congratulate my NDP colleague for the excellent speech that he's just made. And I think that it's a good idea that we start this day discussing a subject that really is fundamental to our Canadian values of solidarity. And I'd like to come back once again to say that, once again, the Conservative government has the bad habit of giving additional discretionary powers to the minister. I find it unfortunate. It's always the same thing. It's more power to the minister to prevent people from entering the country, refusing them access, refusing them admissibility when they want to become temporary residents. So it's giving more and more power to the minister, who can lock the doors to the country, into the country, and I find it worrisome because on top of that, the bill also provides for the minister to lose the power to consider humanitarian considerations. So if someone has fought against a dictatorship like Pinochet's in Chile, for example, why would the minister be free of the consideration of looking at that kind of context? for that particular person, for that temporary residency application.
East Stony Creek.
Well, I want to thank the member for taking the time to take a good, solid look at this bill, because it's very concerning. I've said that protecting Parliament's rights and vested the power that's vested in the Parliament. And a minister is granted the ability to exercise the parliamentary power via bills like this. But if we get to the point where all of the power is vested in the government ministers, our very democracy becomes at risk. I'm not saying that there's not good people sitting in the government benches who would do the best they can. But that won't always necessarily be the case. There are going to be times that we'll have people with less good judgment, for instance, in dealing with cases such as this. Or, for instance, people who could get elected to this place because of ideologies that doesn't match what the real feelings of Canadians are. And so in those instances, if the power is vested with the minister to a degree that there's no appeal process, there's no going back to give that second view of a case, to have the opportunity to give consideration to extenuating circumstances that might not have been even known before, to take that away, I think that does a disservice to Canadians.
Questions and comments? The Honourable Member for Brossard-La Prairie. Thank you, Mr. Speaker. I would like to thank my colleague for his speech.
My colleague is really involved and interested, and he's really passionate about human rights. Actually, he sits on the committee, and I actually thank him for all the work he's been doing on the committee. He also sits on the Finance Committee, so it's someone with a lot of talents. But I know this issue in terms of refugees, in terms of human rights, in terms of Canada being a democracy where we actually have open arms, and we actually try to get people to be part of the country, be part of what we can bring forward in terms of democracy. Can my colleague just explain to us what happens in terms of refugees and what the impact in terms of human rights, in terms of what when they are under attack in human rights in their country, they come here, and how we treat them, how this bill really impacts those people. Thank you very much.
The Honourable Member for Hamilton East Stony Creek.
Well, Mr. Speaker, as you will know, in many instances, people who look at immigration in Canada, the layperson, the person in the street, really don't have an understanding of the process. We have roughly 250,000 immigrants to Canada who are no burden on Canadians at all. They don't cost the government a single penny. They came to this country with sponsors and with some assets and monies of their own, and they're portrayed as somehow being a burden on Canada at some point. Refugees, we get 8,000 to 15,000 a year through the United Nations. Many of these people, Mr. Speaker, live in camps, refugee camps, before they come here. They don't even know what a light switch is. And so for them coming to this country and facing the level of change that they face, there's a lot of stressors. You know, they have a difficulty finding employment because they haven't got the educational backgrounds. There's a variety of things that happen. And our job has been seen in our relationship with the United Nations of protecting people of that nature. So I see you give me the wrap-up signal. The impact of this is, again, if you vest the power in the minister, you're at risk of making serious mistakes, and that would be terrible. Thank you, Mr. Speaker.
Reprise du débat.
Resuming debate, the Honourable Member for Notre-Dame de Grâce-Lachine. Thank you very much, Mr. Speaker. I'm pleased to rise in the House today to speak to Bill C-43, which shows some potential. It amends the Immigration and Refugee Protection Act, and it has several aspects that I find quite troubling, and it merits being studied in committee. These amendments to the IRPA could result in abuses of the system in several ways. Let's begin by the section that allows the minister to concentrate more powers in his own office. This clause gives the minister and not judges or the courts the authority to make a decision on the admissibility of someone to the country. So the minister can arbitrarily decide on how a person could enter the country if they feel it is in a public interest or justified by that. Let's move on with the section that allows the minister to evade the responsibility for looking at humanitarian considerations. My colleague just referred to that. In Canada, we want to give people the possibility of the Minister of Immigration to the country have the possibility of assessing how their situation could be found to be admissible or not. And so this allows the minister to be inflexible even when faced with extraordinary circumstances in the application. Now let's talk about serious criminality. This is a section that deals with extreme cases to defend conservative measures to deal with the fight on crime. Under C-43, the Conservative government is once again introducing new doctrines under its fight against crime. Whether it's C-31 or C-43, it's always the same thing. This bill penalizes all refugees arriving in Canada. Rather than defining and legally dealing with serious crime committed by non-citizens, C-43, being debated in the House today, punishes legitimate refugees, as well as organizations in civil society, lawyers, and other people who try to help them. Michel Bossin, who's a refugee rights lawyer in Ottawa, is of the opinion that the changes being made could see us exporting our social problems in Canada rather than dealing with the root causes of this criminality. The minister will have more power to deal with the removal of criminals. The minister should spend less time, in my opinion, organizing press conferences where new arrivals are painted in a bad light, as we saw the other day, rather than giving the police the assets they need to deal with criminals in every area. Rather than giving too broad and vague powers to the minister, why don't the Conservatives concentrate on making the system fair and faster for immigrants? In my riding, Mr. Speaker, we have a great many immigrants. It's about 1/3 of my population in Notre-Dame-de-Grâce-la-Chine, so I see immigrants every weekend when I go back to my riding. I have to help them deal with a lot of cases, and I have an employee who works full-time just on those cases. All of the problems that we have with immigration are so numerous. These are simple applications. They're applications that are moving forward. People are told that, yes, they're being accepted, but you have to provide this medical certificate. People are waiting for those certificates. It takes months and months before we manage to get any answers. And with all of the changes that have been made in the embassies, it's even worse, Mr. Speaker, because there are many people who are good citizens who have every legitimate right to find themselves here in Canada. They are often people who have come under family reunification policies, people who are coming here to work in a country like Canada, and sometimes have to wait 36 months before they get an answer, even if it's a 26-year-old man we're talking about here who's trying to be reunited with his 25-year-old wife. They're going to work hard here in this country and contribute to society. They're in good health. They would be ideal Canadian citizens, but they have to wait up to 36 months, which in my opinion is too much. So this bill really should deal with the problems that we currently have here, which is the red tape that's involved in the process. And of all of the bills that have been moved by the Minister of Immigration, I've seen nothing that deals with all of that. In the embassies, the problems in the embassies. I just see more and more constraints put on the people who want to come here, and trying to paint these immigrants as criminals. And we're not talking about the legitimate people who are here. It's often an unpleasant process, and it's tedious, it's lengthy. The family that's already in Canada is anxious and upset, and it would be nice to do something for those people. So you would agree with me that most people have not committed crimes. they're not serious crimes, even though there's been something. It's often very minor, and the minister goes looking for that in order to have fewer people here. So I think that what most new arrivals in Canada want is to be treated fairly, to be reunited with the members of their family most of the time. So, Mr. Speaker, Bill C-43, as moved, gives much too new discretionary power to the minister and gives too little importance to human rights. But as I already mentioned, C-43 finally demonstrates a movement forward for the Conservatives by clarifying what the illegal means might be used to enter Canada as a statement for admissibility. The NDP, we in the NDP support the measures to help people who are the victims of human traffickers. And this, in our opinion, shows an opening towards the victims of the NDP. The NDP wants the government to support a legal system that is effective and respectful of human rights. The new legislation here limits the right of a permanent or temporary residence to appeal to the Appeal Division of the Immigration and Refugee Commission, or Board. There are cases where humanitarian considerations for those who would be found inadmissible for security reasons, for example. And in fact, as Mr. Mario Bellissimo, who is a lawyer in Toronto with the Canadian Bar and who deals with immigration, says that it is really prejudicial to designate permanent residents as foreigners. This is certainly a generalization. If people make one single mistake, even if it's a non-violent crime, they will be deported. Mr. Bellissimo is of the opinion that Bill C-43 testifies to the lack of confidence the government has in the Immigration Board and the Canadian judicial system. So why should such important cases really be the victim of such a lack of political will on the part of the Conservative government? Mr. Speaker, these changes to the Immigration and Refugee Protection Act require much more in-depth study. The NDP is convinced that this should be done before the committee. As I said at the outset, it is a good bill. There's potential there, but there remain to be problems solved on the immigration side here. But this has to be studied in depth, and we'll see how we can finally solve this problem. Because when I meet with people in my riding, I find it sad. Often, indeed, people who come to my office who weren't accepted as refugees and who've been asked for all kinds of documentation. And there's a young woman who I won't name, and I won't even name her country of origin, but she has applied here to be accepted as a refugee because she had problems with the police in her municipality. I see your signal, yeah, thank you. And she's being asked to prove that the police is not on her side. And so that's the kind of problem I want to solve, because if you have problems with the police, it's really puts you in a difficult position. The police will just say, well, yes, we've had problems with that person. So there are serious problems that need to be solved, and we'll have to find a way to do so. So in conclusion, the NDP is convinced that we can prevent non-citizens who commit serious crimes from abusing of our process without violating their rights. Let's come back to our Canadian values, and let's work together to build a stronger and fairer Canada. Let's show refugees, temporary residents, permanent residents, and Canadian immigrants that Canada is a welcoming country, as it always has been. Thank you, Mr. Speaker. Questions and comments?
The Honourable Member for Surrey North.
Thank you, Mr. Speaker. Mr. Speaker, I too came as an immigrant to this wonderful country 32 years ago, and I came under the family reunification provisions of the Immigration Act. And I want to ask my member colleague, you know, over the past number of years, we've seen a dismantling of the family reunification, which is a very important component of getting immigrants into this country, or historically. And there has been many constituents in my Surrey North riding who have had difficulty and had to wait long times to unite with their loved ones. Has she had this experience in her writing?
The
Honourable Member for Notre-Dame de Grâce-la-Chine. Thank you very much, Mr. Speaker. I'd like to thank my colleague for his excellent question and also for sharing his story with me. I'm sure that there are many here in the House, people who came to Canada through this process, through family reunification. And yes, it happens often in my riding that I meet with fathers primarily who came 4 or 5 years ago to work because they wanted to bring the rest of their family, who are still back in their country of origin. So they've been here working for 5 years trying to bring their wives and children, sometimes children who were born after they left, they've never even seen. I'm lucky. I have a family that's unified. I knew my parents when I was a month, 2 months, 5 years old throughout my life, and I'd like us to be able to reproduce that in Canada. People come to Canada, they function incredibly well in our society, and they're told that bringing their spouses and children that they haven't even met is such a long process. I'm talking mainly about fathers because that's the case in my riding primarily, but often the father will come and say to me, I have a 2 or 3-year-old child that I've never even seen. I just find that terrible. And I can't see how with this bill this will solve this problem. And I don't see how family reunification will be easier under this piece of legislation. So once again, I want this bill to go to committee so we can really study it properly and talk about that some more. Thank you. Questions and comments?
The Honourable Member for Saanich-Gulf Islands.
Merci, Monsieur le Président.
Thank you, Mr. Speaker.
Bill, it's got a great public relations title, but it goes well beyond faster removal of criminals. It creates broad discretion, unfettered discretion for the minister on his own discretion to decide whether or not to allow someone to become a temporary resident. And I refer my colleague to Section 8 of the Act, which amends Section 22 of the primary piece of legislation, and says, quote, the minister may, on the minister's own initiative, declare that a foreign national, other than a foreign national referred to in Section 19, may not become a temporary resident if the minister is of the opinion, very discretionary, that it is justified by public policy considerations. Further, discretionary, sweeping, without any objective criteria. I'd like my friend's comments on whether she's also concerned the minister is creating the ability to rule not just this minister but all future ministers by fiat.
L'honorable député de Notre-Dame de Grâce.
The honourable member for Notre-Dame de Grâce-la-Chine. Thank you, Mr. Speaker, and I'd like to thank my colleague for her question. As a matter of fact, I did allude to the minister's discretion, and it concerns me when so much power is given to a minister. As my colleague said before, we don't know who future ministers will be. We can't look into the future. So at some point, there could come along a minister who might not make such good decisions. So it scares me a bit. Make no mistake, there are groups of immigrants that are more partisan than others, and I have trouble thinking that that kind of discretionary power could not be used, perhaps, for partisan purposes. So I have questions about that. I'm afraid that this minister or a future minister could use their discretion in a partisan way to favor one immigrant group over another. So I find that worrisome. I find it troubling. All kinds of discretion is being given to the minister, and I don't think it should be the minister. I think the courts should be making that kind of decision. Thank you, Mr. Speaker.
Reprise de débat.
Resuming debate. The honourable member for Brossard-la-Prairie. Thank you, Mr. Speaker. I'd really like to congratulate my colleague on her speech. It's very important. Many of my colleagues here have a lot of immigrants in their ridings, for whom integration is very important. And this bill, C-43, an act to amend the Immigration Act and Refugee Protection Act that deals with removal of foreign criminals, we agree in principle that our legal system has to be effective. It's important to deport serious criminals who are not Canadian citizens. However, I think basically all sides agree on that in principle. There's no problem there. Our problem is with the scope of this bill. A lot of stress has to be put on fairness when it comes to justice, and C-43 is problematic in that regard. One of the major problems we see from the outset, and this has been said a number of times already, the bill gives the minister even more power to deal with temporary residence requests. So it says that the current minister, there may be questions about the current minister, because under current government policy, there's less and less focus on the integration of immigrants. We've seen this. Family reunification is being downplayed. And this affects me, even though I was born in Canada. My parents came from Vietnam, and there are a lot of Vietnamese refugees in Canada. And when you look at how this government, where it's heading, to them, integration and family reunification are less important. What they're really more focused on is temporary workers. So they bring in foreign workers temporarily, pay them less than Canadians would get paid, and afterwards they're sent home without any real recognition of their contribution to Canada. So when you look at this bill, the fact that the minister really has a choice, a decision, the minister can decide whatever he wants when a person's applying for temporary residence, that's worrisome, because when you look at the philosophy or the idea behind this, we really don't know what the government's up to. And when you look at what this government is doing, there's no priority being given to people who really want to come to Canada. So that's one problem we see. Another fairly major problem is when it comes to humanitarian and compassionate grounds. When you look at what's happening around the world, as I said, my parents come from a country that produced a lot of refugees who came here. And at least before this bill, the minister was required to examine humanitarian and compassionate grounds for an application, even if the person was found to be inadmissible on safety grounds. Once again, when I talk about Vietnam, there are people today in Vietnam who are under pressure from the government.
From the violations of human rights in Vietnam from the Vietnamese Canadian Federation. And what's happening is there are arbitrarily, the government is restricting legitimate speech of journalists and bloggers and who are advocating the rights through the usage of the internet, newspaper, and radio. There are some prison sentences for broadcasters and people like that. So the fact that we now, if we take out the right of the minister to actually look at those issues, look at how can we help them come here, even though they're being attacked in their own country, I think we are moving Canada away from what we used to be. We used to be a country that was really open, that believed in human rights, and I think right now with the fact that we're taking out the fact that the minister can actually look at that, that's a serious issue that is of a concern. Another
problem we also see is the discretion that's given the minister when it comes to considering an exemption for a family member who's been considered inadmissible on security grounds. The minister can decide to exclude a person if it's in the national interest. So once again, the minister's being given power. So one individual is deciding. The minister has a somewhat arbitrary choice to make, even though the minister is supposed to make that decision in keeping with the public interest. What are the criteria? So the power is concentrated in the hands of whether it's this minister or a future minister. There is a problem with that. And we see this increasingly with the Conservative government, this tendency. They're moving towards more and more power being concentrated in the hands of ministers. More and more authority and discretion is being left in the hands of one individual, and that's dangerous. It's less and less democratic, less and less open, and increasing reliance is being put on the judgment of a sole individual. So once again, that's an issue that is a bit worrisome to us. Once again, I'll repeat, it's important to deport foreign criminals. We understand that. We understand that if we're to protect Canada and people coming here deserve it, in my riding and in many of my colleagues' ridings, my colleagues opposite, we know that in general, people who come here are good people who participate in Canada's growth and make Canada a better country. So to paint them all with the same brush, put them all in the same basket, the way this bill is drafted, it just goes too far. So that's what we want to discuss. That's what we want to deal with. We want to try to find solutions, concrete solutions, to better integrate newcomers and have less discretion in the hands of the minister and less stigma on immigrants or certain groups of immigrants. We know that between fairness and speed, there can be a trade-off. There are problems with families not being reunited. We see this in a lot of our offices, including my riding office, because I live in a riding where there are lots of immigrants, lots of people who are trying to bring family members here, or even just have a relative attend a wedding. People have to wait for months and months to get a visa, and increasingly those visa applications are being rejected. So there's a tendency with this government. Instead of integrating and accepting immigrants, they're being shunted aside, they're being sent home, and the door is really only open to temporary workers. And then once their cheap labor has been exploited, they get sent back home.
Actually, the NDP knows that Canada must have an effective judiciary to deport non-citizens individuals who are serious criminals. But there are problems with the immigration system that should be addressed, and I just mentioned them. And so we do have serious concerns about the amount of power that is placed in the hand of the minister. One of the things that I can read from you, and it came from a group that is actually talking about what the problems we have in terms of the government not doing enough, or basically taking the right of appeal. And that's also another big issue for us in terms of this bill. The fact that le fait que dans ce projet de loi,
the fact that in this bill there's the discretionary power. An individual can be denied access to an appeal procedure. That's very worrisome. It's very important. As I said, because the minister is given more and more power and the right to appeal is taken away, that's problematic. Mr. Speaker, I see you're signaling that I need to speed up. I just want to mention Andrew Schreck,
Ontario Criminal Lawyers Association, who said the bill raises constitutional issues under Canada's Charter of Rights and Freedom. He says, I am concerned that there is no right of appeal for those being deported. And this is serious injustice in that case, and it should be heard on their own merit. Thank you, Mr. Speaker.
Questions et commentaires.
Questions and comments?
L'honorable député.
The honourable member for Saint-Lambert. Thank you, Mr. Speaker. First of all, I'd like to congratulate my colleague on his speech. He mentioned how important it is to focus on improving the immigration system to make it faster and more efficient in dealing with family reunification files, recognition of foreign diplomas, and foreign workers. This bill redefines in a strange sort of a way the very concept of temporary resident. We have to pay particular attention to this. We saw this with C41, C43. The fact that the minister will now be able to exercise even greater discretion, this is probably dangerous, and we really need to watch out for this. I'd like to ask my colleague, some speakers talked about offenders, first offenders, who could even be deported under this act. These young first-time offenders don't necessarily even know their country of origin. What can he tell us about that aspect? The honourable member for Brossard-la-Prairie. Thank you, Mr. Speaker, and I'd like to thank my colleague from Saint-Lambert, who's the assistant critic in immigration and citizenship. I know she's very aware of this file, of the issues. She's very actively going out across Canada and meeting with people. So she's really seen the impact of the changes the Conservative government has made to the immigration system, the adverse effects of those changes. So I'd like to thank my colleague for her work and for her question. Yes, indeed, changing the definition of crime, of serious crime, and taking away the right of appeal, these will have huge consequences for young immigrants. These can be young people who don't even know their country of origin. Once again, the tendency of this government is just to deport people immediately as soon as they've been criminalized. I mentioned temporary workers who are brought in and then shipped out immediately once they've done their work. We see immigrants as people who make this country a better place. Instead of giving those young people a chance, instead of promoting that vision, the Conservatives are just deporting people at the very first opportunity. Questions and comments?
The honourable member for Brampton West.
Yes, well, thank you, Mr. Speaker. I listened to my colleague's speech with a certain degree of interest, but what I have to say that I find particularly disturbing in the comments that are raised by the people on this side of the House, these wild accusations that somehow we're moving away from a society that cares about refugees and people coming to this country. Nothing can be further from the truth, as proven by our record on many occasions. We have increased the number of resettled refugees by 20%. We will be inviting more than 14,000 additional refugees to settle in Canada, which will give us the highest refugee resettlement rate in the world. So I'd caution my colleague on making careless comments like that. But with respect to the legislation, this legislation will give the minister certain powers, yes. For example, people who want to come into this country and spread hatred. We had a situation like that last year, and people in Canada were saying we shouldn't be allowing these types of people into this country. This legislation will give the minister the power to say those people are inadmissible to Canada. Why won't the members support the minister who can keep people out of the country from spreading hatred?
The honourable member for Brossard-la-Prairie. I'd like to thank my colleague for his question, but I'd just like to remind him that what we're saying is that we go out into the field, we meet with people, and we see how these changes directly affect people. We're seeing these changes now. I would invite my colleague to go out into these communities, meet the people. I know that in my riding, Brossard, La Prairie, there are a lot of people experiencing these problems. But just to quickly answer your question, there are a lot of problems we see with deporting. The problem is not deporting people who've committed serious crimes. The problem is focusing power, concentrating power in the minister's hands, and that the minister could make arbitrary decisions. Thank you, Mr. Speaker. Resuming debate, the honourable member for Beauport-Limoilou. Thank you very much, Mr. Speaker. Thank you for granting me the privilege of taking the floor on this bill that would expedite the removal of foreign criminals. I think it's very important for everyone in the House to have an opportunity to discuss problems related to crime committed by foreigners in Canada. Obviously, we're happy to respond to the government's call to examine shortcomings in the appeal procedure. The NDP would certainly not deny that there could potentially be some problems with the procedure. We just want to cooperate with the government to establish the facts and then, based on those facts, find solutions. But here the government has tabled Bill C-43, and from here, okay, that's a basis. That's our starting point. But the government has to be sensitive to the problems that we've very clearly and concisely set out. And these problems raise perfectly legitimate questions. These are perfectly legitimate questions because, Mr. Speaker, we mustn't forget, we're talking about procedure here, the implementation of a court procedure, and we mustn't forget, Mr. Speaker, that in Canada, our court proceedings come from centuries of tradition. One of the very basic fundamental principles of our legal system is that you can't detain people arbitrarily without reasonable grounds. That's very important. And it's very straightforward. It's very basic, if you will. But that principle, over centuries, has led to a whole apparatus, a whole series of other definitions that also aim to prevent arbitrariness, to prevent innocent people from being condemned or convicted or detained without proper procedure.
You know, Mr. Speaker, C-43 presents measures, among others, to redefine serious criminality when it comes to foreign nationals in order to limit access to the appeal process. Currently, you know, legislation sets out a 2-year threshold, which is somewhat based on federal and provincial distinctions between prisons and penitentiaries, which applies to certain types of crimes, of course, and sentences that are applicable. But here we have 6 months or more, and this expands the possibility to have an increased number of people who are excluded. I say candidates who are excluded. That's a bit strange, but people who may be excluded from this appeal process for categories of crimes that seem to be these categories give some flexibility to allow people to reintegrate society. You know that when someone is convicted of a crime, we must never forget that ultimately, unless they're sentenced to life in prison and they never manage they never manage through the usual process to be freed on parole. These are extremely rare cases. Most people do reintegrate society and do have life after they leave prison and serve their sentence. We're not just talking about their sentence. We're also talking about a suspended sentence that can occur over years. And this person this means that a person who has committed another crime will be returned to court and given the sentence. So this applies here, and we see that there is an international consensus that's very important, so that needs to be respected. And I'd like to bring up another very important point that hasn't been addressed a great deal, I think, with regard to this debate, and that is Canada's place in the world. And I would say this as the good citizen Canada within the community of nations. You know, Mr. Speaker, there are principles within the international community that as a sovereign state is not subject to the other states. In other words, is treated in theory equally and has full sovereignty over its own territory and own jurisdiction. Well, we can ask ourselves then, given the consequences and the measures set out in C-43, whether we wouldn't have to act as a bad citizen by removing en masse criminals and even petty criminals from Canada to elsewhere in the world. It's very important to take this into consideration and to keep in mind the fact that this could occur because, you know, Mr. Speaker, I can understand the government doesn't want to have foreign people from other countries be able to come here and act without being punished. But this bill will also impact people who come and have settled here and been here for a very long time, people who have come and come to Canada when they were very young and depended on their parents and grew up in a Canadian context, and through some unfortunate circumstances may find themselves committing a crime of one sort or another, and perhaps then they would be targeted by this bill because they would not have Canadian citizenship, unfortunately for them. And this kind of double standard can not just hurt these individuals, but also be a problem for the country to which the person is removed for crimes that the individual would have committed in Canada without that individual having committed a crime in their country of origin. What is Canada's legitimacy then of getting rid of this burden and placing that burden on the shoulders of citizens elsewhere in the world? And this is part of the questions that we need to ask ourselves. We must never forget that in Canada, given our privilege and luck of living in this country with a highly developed legal system, that we have a large number of protections, and this means that we have a very safe country that gives everyone the opportunity to be their own person. This is not the case elsewhere in the world, really not. And I remember a comment that one of my colleagues had made who had traveled to Latin America and who, in reaction to measures considered by the Canadian government, had said, well, hey, what do you think you're going to do by sending us the criminals, people who committed crimes in your country? Do you think that we're going to be able to take care of these people? And you have a better developed legal system. What are we going to do in these other countries? When we're talking about delinquents, young offenders, petty crime after having gotten their wrists slapped, These people can often recognize their mistake. They can go through the process and become a good citizen. And this kind of person, a petty criminal, could or might well become bigger criminals because they won't have had any hope for their future. So, Mr. Speaker, this is one of the things we'll have to think about when we talk about C-43. I don't want Canada to become the equivalent of the old Far West in the 19th century, where we tarred and feathered people and removed them from our country in order to resolve the problem. And it doesn't necessarily mean the problem will be resolved, but I'd be happy to continue the discussion with my colleagues and to be able to look at how we can improve Bill C-43. Thank you very much, Mr. Speaker.
Questions et commentaires. Questions and
comments.
The l'honorable député.
The honourable member for Quebec. Thank you, Mr. Speaker. I listened to my colleague from Beauport-Limoilou's speech, and I thought, yes, it is a conservative government that is taking up too much space. I think it's going too far beyond what it should have in terms of powers. We see there these discretionary powers, and we saw C-31, C-43, and C-44. And I know that my colleague has a lot of immigrants in his riding, particularly in Beauport. So I'm thinking of them today. And in light of what we see, in light of what my colleague and his entire team is seeing on the ground in Beauport, and the requests from people, I'd like him to talk to us about this and tell us a little bit about how these people see it when they're dealing with all the bureaucracy. I'd like to hear his comments on this. Thank you. The honourable member for Beauport-Limoilou. I want to thank my colleague from Quebec very much, who also has a lot of immigrants and who will well understand what I'm going to talk about, no doubt. We mustn't hide the fact that, people who come to Canada come to improve their lives, but also because they are fully confident in the state and the institutions of Canada. So we have cases that come to our office, individuals who have permanent resident status, who don't even yet have that status, and they're waiting to get it. And they're looking to bring their spouse and their children here. They come to see us in order to have some hope of seeing a fair and just ruling. That is what we want to do as well, and we don't want to unduly influence the system. However, at the same time, we want to confirm through our actions and our explanations that these people who have come to Canada with great hope were right to have confidence in our institutions and our country. So my colleague brought up a fundamental point. How can people have confidence in Canada if we become unfair and inequitable? Questions and comments?
The honourable member for Winnipeg North.
Yes, thank you. Mr. Speaker, I'd like to somewhat try to simplify in terms of what it is the government is actually proposing to do here. At the end of the day, when they talk about foreign criminals, really what they're talking about is the 1.5 million people that are residing, that call Canada their home, those individuals that are permanent residents. Now, what they're saying is that if, in fact, for example, you are caught with 6 pots of marijuana or 6 marijuana plants, that you're going to get deported, and there is no appeal to that because there's a minimum 6-month jail term. So for having 6 pots of marijuana or plants of marijuana in a home, you might have been living in Canada for 15, 20 years. You could be a parent with 3 children. Your children can stay, your spouse can stay, but you're going to be deported. I wonder if the member can tell me whether or not that is fair in Canadian justice terms.
The Honourable Member for Beauport-Limoilou, 1 minute. Thank you, Mr. Speaker. I want to thank my colleague from Winnipeg North for highlighting the fact that there is one of the dangers, this is one of the dangers associated with C-43. And unfortunately, there is an approach to crime adopted by my Conservative colleagues. I was able to be the standing committee, and we saw what happened with the mandatory minimums being applied to certain types of crime and the strengthening of various pieces of legislation instead of seeking out alternatives for those who commit petty crimes. I'd like to give my colleague an example. In Quebec, there is a group that works to help young people avoid the court system. They're offering police officers an alternative. This means they work more in the area of restorative justice to make the offender aware of their actions. Resuming debate. The Honourable Member for Beauharnois-Salaberry. Thank you very much, Mr. Speaker. Canada has a reputation of being a welcoming country, a host country, but unfortunately problems with our immigration system are only growing under this government. Instead of attacking how slow the bureaucracy is, the Conservative government is coming forward with a bill, yet again, after C4, C31, that will not resolve much and in fact will create other problems of unfairness. Bill C43 seeks to deal with crime and accelerate the removal of immigrants who have committed crimes in Canada, but also permanent residents who have become Canadians. My colleagues in the official opposition and I, as well as other members of other opposition parties, agree about the importance of having an effective and reliable and just legal system. The individuals who are committing serious crimes and who are not Canadian citizens should in fact be sanctioned, but we must not adopt this bill with our eyes closed. Fighting crime is just a pretext here. The real objective of Bill C-43 is to give more discretionary powers to the minister and to take out all flexibility from the justice system, to take out all the autonomy of judges, in short, to politicize even further our immigration system instead of making it fair and more effective. The bill makes a number of amendments to the Immigration and Refugee Protection Act, and I will talk about a few of those. It would amend the appeal process in some cases, which goes against a fundamental law. Permanent residents, refugees, and illegal immigrants who get a sentence in Canada of over 6 months will no longer be allowed to appeal their deportation. It would also mean that we would prevent from entering Canada those who pose a risk to Canadians, and the bill would force judges of the federal court to impose some conditions on detention of a person who was declared inadmissible to Canada. It would give the minister more powers, who could decide to refuse a request for temporary residence if it was in the public interest. Unfortunately, the bill doesn't even define what the concept of public interest is. And it would eliminate the right to appeal if the prison sentence imposed is over 6 months. The first problem with the bill is that there's no distinction between a minor offense and a serious crime, which my colleague from the Liberal Party also talked about. For an immigrant who gets a 6-month sentence, it would lead to automatic deportation. Right to appeal is eliminated. Furthermore, the bill redefines the concept of serious criminality, and this includes minor offenses without the right to appeal, and with such a vague definition, we can expect there will be challenges before the courts, and this approach does not respect in any way whatsoever Canadian law. The other problem, which is even more serious, is the discretionary power that the minister would get. He himself would decide whether he would grant a visa or not, but he is no longer required to look at the humanitarian circumstances of a case. It's a double standard, in fact. This gives the impression that the minister is chasing out immigrants and refugees and omits to consider the fact that the vast majority of immigrants and refugees are not criminals. In fact, the bill would eliminate all the controls that would allow the justice system and the immigration system to respond to particular and specific circumstances. Immigration officers and judges would no longer have the possibility of assessing the cases before them. This is quite serious because the judges are the ones who have the competence of judging cases, and they would no longer have this power. The minister instead would impose a uniform model on the system. Here there is a huge risk of abuse of power. If the government commits a mistake, by what means can the person involved ensure that their rights are respected? There would be no way. This is serious. The purpose of the bill is commendable, but all of these factors mean that we have to fear that there is problems with our immigration and justice system. The fundamental issue is this. Do we want such important decisions concerning criminal law to be made by a minister? In a state that respects the rule of law like Canada, the principle of fairness between the judiciary, governmental, and legislative powers is essential. Why make this process so political? What justifies this discretionary power? The Minister of Immigration, in response to that question, recently said, "Oh, we don't have time." And he added that action needed to be taken when foreign nationals were in an airport. That's not always where it happens. It's not always that simple. In fact, it's always more complicated. In fact, if we are too hasty, and the opposite could occur, Mr. Speaker. We could create a system full of abuse, and court challenges would proliferate, and we would not respect our international commitments. The intention behind the bill is good, but the bill itself really needs to be improved in order to ensure that it respects basic laws. In fact, the entire immigration system needs to be reformed, and it's certainly not with the radical measures being proposed by this Conservative government. Our system is full of bureaucratic issues and arbitrary decisions. Since the Conservatives came to power, over 1.5 million immigration applications have been delayed. Parents and grandparents are waiting to be reunited with their loved ones and families and are waiting on average 7 years before getting a response. Qualified workers have to wait about 4 years. These are qualified workers, skilled workers. Some spouses and children whose files should have been dealt with faster are waiting perhaps 3 years to get an answer. Instead of accelerating application processing, the government has cut programs for refugees. The cuts announced in the federal interim health program are depriving some people of health care services. The Conservatives are proud of this. The Conservatives say that they support the economy, but in reality, it's quite the opposite. A number of immigrants are waiting for their diploma or their foreign experience to be recognized. The federal government could create mechanisms in order to recognize previous degrees and allow qualified and skilled workers to contribute to our economic growth. Conference Board estimated at $4 billion a year the financial losses related to this failure to recognize these diplomas. And what about the partisan appointments to the Canadian Immigration and Refugees Board? Files submitted by applicants are not always dealt with in the same way, and the criteria are not always applicable in a uniform manner. Why is the government tolerating this arbitrary process?
This partisanship projects a very poor image of Canada and deprives immigrants of a fair and just system. This government deals with immigrants and treats them like disposable objects. They increase the number of temporary workers by 200% while allowing employers to pay them 15% less than what a Canadian worker would earn. In order, or rather than encouraging integration long-term of immigrants, they treat them like second-class citizens. As the daughter of refugees, I can tell you that the contribution that men and women make in establishing themselves here is exceptional. New arrivals often have less formal education, but they have a very highly developed business sense. They are entrepreneurs, and they therefore create jobs and enrich our society in terms of culture. We mustn't forget that these people help to build our country. Why not improve our system? Rather than doing that, the government is canceling 280,000 files for skilled workers. We shouldn't forget that this country was built by people who came from all corners of the world and chose Canada as a welcoming country. Rather than improving our system, as I said, Canada is freezing 280,000 skilled workers files and is also freezing sponsorship requests or applications for parents and grandparents. As a member of the NDP, I can tell you that we favor a justice and immigration system that condemns violence, criminality, and fraud. It is critical that we protect our country from wrongdoers, and foreigners who commit violent crimes on our territory should be deported. We must work with the government on this bill. It has to be made legally acceptable. There are certain aspects of the bill that do appear to be constructive to us, but we mustn't punish victims. Why do the Conservatives not put their radical ideology aside and work with us to improve the bill in committee? So it's possible, Mr. Speaker, that Canada would continue to be a welcoming society while at the same time protecting society from criminals. Thank you. Questions and comments?
The honourable member for Winnipeg North.
Yes, Mr. Speaker, I do want to continue along the line with some areas of concern that we have with Bill C-43. Another area is dealing with the power grab from the minister. The minister has demonstrated in other pieces of legislation that he feels that he should take it upon himself to make fairly profound decisions, such as determining which country in the world is a safe country. Such as what grouping of 2 or more people that come to Canada should be listed as irregulars. And now in this particular bill, he wants to be able to say, I want to be able to have the sole authority to ban someone from being able to come to Canada. Now, my question to the member is, does the member recognize the value of putting in checks in place to protect individuals that might want to apply to visit Canada, so that the minister, any given minister, doesn't go on any sort of a power trip because he doesn't like a region of the world or has a bias against some beliefs that some individuals might have. Does she believe that there needs to be a check put into place to prevent the minister from taking actions that would not necessarily be conform to what Canadians would want to see?
The honourable member for Beauharnois-Salaberry. Thank you, and I thank my colleague from Winnipeg North. And I entirely agree with what he has just stated, in the sense that the discretionary powers of the minister in terms of justice makes no sense. It creates different decision-making levels, and it also creates decisions that could be partisan, which is not at all the goal of a justice system. It should be fair and completely independent. It should be non-partisan. So we really need to have a framework. We need clear rules and regulations that cannot be changed by the goodwill or the non-will of a particular minister. And no matter what the file would be, we need to have a very clear and transparent basis to deal with all of these situations, and also have a framework that will allow judges to have total independence so that they can be very flexible in specific cases.
Questions and comments?
The honourable member for Laurentides-Labelle. Thank you, Mr. Speaker. I would like to know what my colleague thinks of the abusive language of the really boring title that this bill has, and the extreme cases that people relied on to create this bill. I grew up in another era when in Canada there were probably a majority of people who saw immigrants and refugees as a threat and as a nuisance. Happily, that time is over, probably around the time that her parents arrived as immigrants. And today, the majority of people consider that immigrants are an asset to our community. They're a cultural and economic asset, and so on. And when I see names or titles like this bill has, it's all motherhood and apple pie and all that nonsense, but they're trying to create a negative way of thinking in the community regarding immigrants. I'd like to know what my colleague thinks of that. The Honourable Member for Bois-Salaberry. Thank you very much, and I thank my colleague from Laurentides-Labelle for this question, which is a very fair one as well. The Conservatives rule through fear rather than attacking problems and finding solutions and alternatives. They are creating new ones. They take rights away from people rather than finding some kind of balance. They're creating a situation where refugees are considered like illegal groups if they arrive here by boat, for example, whereas, yes, there are people. In fact, the majority of immigrants who arrive here in good faith. They want to work. And if I just look at my parents, they arrived here. They had nothing, but they both became nurses. They have set up a business. They've contributed to the economy. And we are now fully integrated into the Quebec and Canadian reality. Resuming debate, the Honourable Member for Richmond-Arthabasca. Thank you very much, Mr. Speaker. I'm pleased to rise today on behalf of the Bloc Québécois on C-43, which is a bill to send immigrants for the faster removal of Foreign Criminal Act. And so looking at the title, it's as if you have to say, well, you can't be against that. It's like not liking apple pie. But, once again, you have to look at the details of such a bill before taking a position on such legislation. So you can't rely on the title before taking some position on it. And I think that for most of what's in this bill, having read through it, it's not very long, but we found all kinds of shortcomings and errors in the bill. So, therefore, the principle of saying that for some criminals who are temporary residents, and if you're talking about people who abuse of the process of our systems here in Canada, we agree that there are things that have to be done, and I think throughout the House of Commons everyone has been saying that, and I've listened to many of the speeches since the bill has been tabled. So I would think that everyone agrees on that point. However, does Bill C-43 really solve these issues? No. Does it create other problems? I think, unfortunately, the answer to that is yes, and that's what I want to speak about over the next few minutes, because there's an ideology behind all of this. My colleagues just referred to it here briefly. There are all kinds of prejudices and cliches that are used by the Conservatives to do what I call some kind of to set the scene, if you will, whether it's in terms of crime or immigration, and often they mix those two things up, as in the case of this bill. They're talking about criminality rather than talking about immigration. It's saying to some people that there is a danger here, there are risks, that if a refugee arrives by boat, then all of a sudden we're to believe that we're going to be overwhelmed by these refugees who come from all over the place. So we don't even call them refugees anymore. They're referred to as criminals. And at that point in time, it's easier for the government to say, no worries, we're going to send them back home. And if you go out into the communities on the weekends, people aren't aware of all of these situations here. They don't know the details. However, they saw the Minister of Immigration hold a press conference and give some extreme examples, which obviously don't occur every day. and an example that we have to indeed use to correct the shortcomings of legislation. But this results in people believing these generalizations. They come to think that those kinds of situations are the rule and not the exception. So we have to slow down and look carefully and make sure that we solve real problems and not just fall into demagoguery and put all of this on the backs of immigrants and people who are grappling with other problems. The Bloc understands that we need to protect society. That has to be part of our immigration legislation. Obviously, a country wants to welcome immigrants who respect the laws of our society, and it's normal that a society wishes to avoid becoming a refuge for criminals who are running away from their own countries. Those people exist. The minister is right to speak out against those people, and we do that as well. But we can't improve the processes by making the process for removals something that is endless. If someone did something, was a member of a street gang back in their country of origin, for example, if they might find some roots in another country. That happens to us here as well. So if the first thing that a person does is not integrate into Canadian society but to become part of a new street gang, then clearly we don't want to keep that kind of an immigrant here. And now people also sometimes abuse of the processes available to immigrants to endlessly delay their removal. And those are the examples that the ministers used to say or to have us believe that everyone is like that, which is clearly not the case. These measures have to be very targeted. They have to prevent criminals from coming into the country, but they mustn't block innocent people at the border. There has to be some proportion here. There have to be effective measures proposed that respect fundamental rights, but not proposing measures that result in the killing a fly with a sledgehammer. I think that there are laudable objectives in this goal, and I think my colleagues spoke about proposing several amendments perhaps at the committee level, but I think indeed to study this bill would be the thing to do. With C-43, we certainly haven't reached the proper balance, with, as I said, even though there's a laudable objective, but it doesn't deal with the shortcomings of the law as it stands. It does away with the right of appeal to the Immigration Appeal Division for people who are unhappy with the original decision. But a permanent resident who is inadmissible on security grounds or for abuse of human rights, serious crime, or organized crime does not, for example, have access to the Immigration Appeal Division as it stands. And serious crime being defined as something that's punishable by 10 years and has resulted in a 2-year sentence is one thing, but this bill restricts it and reduces the criteria for the jail term to 6 months. So here again, I've heard colleagues speak to this point, and I agree. What is serious crime? I mean, obviously, we're all offended by someone who arrives in this country and becomes a highway robber or someone who's guilty of sexual assault and so on, serious crimes. That's one thing. But if, on the other hand, we're talking about someone who's found guilty of simple possession, for example, of marijuana, or perhaps someone who would have in their possession stolen goods worth less than $5,000, someone who's been charged with public mischief. I don't want to give too many examples, Mr. Speaker, but I think that a person can be charged with public mischief if you urinate in the street or in a parking lot. So you can understand there's a great difference between public mischief, and I'm not saying that there shouldn't be some punishment for that people should behave in that way, but that's not sufficient grounds to remove someone from the country. That makes all the difference in the world. And if you compare that, as I said earlier, with someone who is part of a street gang, and it's a totally different story. So simple possession of marijuana is not in the same league. So I think that there's a cumulative effect of these conservative measures. For example, under C-43, 6-month sentence resulting in being stuck with a label of being a serious criminal. So it's too much. They're always adding to sentences that result in crimes that are considered less serious being used as a pretext to deport someone. And, we're talking about people who could really redeem themselves and become good citizens in Quebec and Canadian society. So they keep making mandatory minimums of 1 and 2 years for all kinds of offenses without considering the mitigating circumstances. And we've spoken out against mandatory minimums for every which offense, often in this House here. And what we're saying simply, Mr. Speaker, is that we are tying judges' hands with this. It's saying to them, regardless of what happened, if they were just a chauffeur of the vehicle for the crime that was committed, it doesn't matter. They were there, they were part of the crime, and they, as will be the case for the others, will be stuck with this mandatory minimum, and there's no nuance to what the judge can do. So there's injustices created in terms of that. There are an increasing number of people who will be labeled as serious criminals, and we can think about offenses, like I said, possession of drugs and so on. So just in conclusion, Mr. Speaker, we spoke a lot about the discretionary powers of the minister, and that's another one of the great weaknesses of this bill. We're told that we will act through regulations, but what regulations? We haven't seen them yet, and I hope that at the committee level we'll have some clarifications on that and see that we'll live in a safe world, but at the same time that we won't deport people who don't deserve it. Thank you, Mr. Speaker. Questions and comments?
Questions and comments? The
Honourable Member for Longueuil, Pierre Boucher. Thank you, Mr. Speaker. I'd like to congratulate my colleague from Richmond-Arthabasca for his speech, and particularly for the images that he used. They were really were eloquent. I think back up to what my colleague said from Beauport-Limoilou when he was talking about the image of the criminal who's banned from the village. And I was wondering, with this, what you were referring to earlier, the situation that you referred to earlier, that really we should be worried about our international reputation in the way that we're trying to manage our society.
The Honourable Member for Richmond-Arthabasca. Thank you, Mr. Speaker. I'd like to thank my colleague for his question. The image is that the government's image has been tarnished since it came to office, particularly because of the way this government has behaved and the immigration minister in choosing the type of immigrant that Canada wants to welcome. People with money, people from certain communities. But once we start talking about refugees, it starts getting tougher. And if people are to be sent back quickly for committing crimes, those crimes apparently are less and less serious, so we're not that welcoming anymore, really. I'm thinking of a concrete example. A woman, an elderly woman from France who'd been in Quebec for a long time. Her only family is in Quebec City, her daughter who looks after her. She has some mental health issues. She's become a kleptomaniac. She's shoplifted a few times, and the government, under the current legislation, wants to send her home. But home is in Quebec with her daughter, but they want to send her back to France. This elderly woman needs help. She needs compassion. She doesn't need to be deported to France where she hasn't lived for years and years. Her problems won't be fixed. Questions and comments?
Questions and comments? The Honourable Member from Winnipeg North.
Yes, thank you, Mr. Speaker. One of the issues is the inadmissibility of family members based on the fact that a family member might belong to an organized gang, for example. And there are many gangs here in Canada, quite frankly. And what they're really saying is, and I used an example in one of the briefings I was provided, of Nelson Mandela's wife. And the person had pointed out, well, technically Nelson Mandela's wife had committed some crimes also, so she wouldn't have qualified for a visiting visa. So then I used the example of Mahatma Gandhi. His wife wouldn't be able to apply for a visiting visa. And I think that it just highlights that why are we saying no to individuals that might have a family member that have had some issues, and saying no to that person's ability to be able to visit Canada. And a good specific example would be, if you have two children, one in Canada, one in country X, and the one in country X has some problems in terms of some local gang issues, you're not going to be able to come and visit your child here in Canada because of that. And that's a very real situation that's there today. Maybe if the member could provide comment as to why that's not fair.
The Honourable Member for Richmond, Arthabaska. Yes, I appreciate my colleague from Winnipeg North's comment. I think in his own riding, and he's his party's immigration critic, so he's worked a lot on this type of file, and that's a great example he just gave. He talked about known cases, but for everyone under the current law, if the person traveling with you, your wife or husband, got a criminal sentence in the country of origin, you won't be allowed in. But now it's being toughened up even further. If the person accompanying you, it's quite simple, if they've committed any offense whatsoever, you'll be inadmissible. And the member gave the example of visitors' visas, and that's even worse, Mr. Speaker. I've been here since 2004. I've seen other governments come and go, and I've never seen such a serious degradation in terms of immigration and a degradation of our welcoming capacity, if you will. We're rejecting more and more visa applications, not just for the reasons given by the member, but for all kinds of other reasons. For example, sports teams, for example, can't come to Canada to take part in tournaments for all kinds of reasons. In my riding, there was someone from Haiti who was told, if you go back to Haiti for your mother's funeral, that's fine, but you won't necessarily be let back in. These problems are only getting worse under this bill.
From Vancouver, Kingsway.
Thank you, Mr. Speaker. It's a privilege to rise in this House and speak about an important issue of immigration law and procedure and policy in this country. And before I do, I want to point out the fantastic work being done by my colleague from Surrey, British Columbia, the Honourable Member from Newton, North Delta, doing an outstanding job in showing Canadians a different way, a better way of making immigration policy in Canada, one that actually streamlines our system, makes our immigration system more effective and efficient, but retains the kind of compassion and respect for law and procedure that I think all Canadians cherish and have learned to recognize as a hallmark of our system. You know, it's interesting, Mr. Speaker, the government, of course, controls the House agenda, particularly a majority government like the Conservatives currently enjoy. Focus on the word currently. And they get to choose to bring forward whatever legislation they want. I had the privilege of being our party's immigration critic for a year and represent the riding of Vancouver Kingsway, where the number of new Canadians are riding is among the highest in the country. In fact, well over 70% of the people in our riding represent first, second, or third generation Canadians. And my office deals with thousands of immigration cases every year. So I have, I think, a representative sample of what the major issues and problems are in the immigration system. And so it strikes me as very interesting and fundamentally disappointing that of all the issues in the immigration system that the government could be dealing with right now, they've chosen to focus on the deportation of certain permanent residents. And I'll be getting to what I think should be more important and pressing priorities in a moment. So what's in this bill, C-43? Mr. Speaker, basically this bill focuses on an important but relatively narrow issue of the procedures to be invoked in deporting people who may have committed crimes in this country or otherwise misrepresented themselves. Now, the NDP recognizes and supports the need for an effective and responsive judicial apparatus for removing serious criminals who are not citizens. All citizens, I think, in this country would agree with that statement. We understand the need to be monitoring and modernizing our very slow, on occasion, systems, and we support efforts to do so. But what this bill does is a mixture of good and, I think, very concerning and troubling things. It concentrates more power in the hands of the minister himself by giving him new discretionary authority over the admissibility of temporary residents. It relieves the minister of the responsibility to examine humanitarian circumstances in certain cases. It gives the minister a new discretionary authority to provide an exception to the family member of a foreign national that is declared inadmissible. It changes what constitutes the definition of serious criminality for the purpose of access to an appeal of a determination of inadmissibility. It increases the penalty for misrepresentation, and it clarifies that entering the country with the assistance of organized criminal activity does not on its own lead to inadmissibility. So I think you can see there's a mixture of some positive steps but also some very regressive and negative aspects of this bill. It's a common feature of this government, and in particular the current Minister of Immigration, who seems to constantly want to concentrate discretionary power in the sole single hands of the minister. It seems to be a feature of this government that they want to continue to try to tighten and reduce and restrict the ability of there to be judicial oversight or appeal access to decisions that are often made by single people who are not accountable and are often political appointees. These are very troubling components of this government's approach to the legal system. It's not limited to immigration. I think we see this in their general approach to crime in general. Where the NDP parts ways with the Conservatives is that we believe that we can build and improve our immigration system without trampling on people's rights, without concentrating dangerous discretion and power in the sole hands of the Minister of Immigration, while preserving mechanisms that ensure effective reviews by courts and democratically elected representatives in Parliament, that builds up sufficient flexibility to ensure that due consideration is always given to unique circumstances of every case. And I think Canadians are rightly proud of our fair and compassionate system, and they oppose this government's move towards a cold, mean-spirited, ideological, inflexible, and extreme position on immigration. We've seen serious questions of constitutionality raised in this government's agenda, where we know that the Justice Department gives information advice to the ministers of this government that they're likely pursuing ideologically based legislation that is unconstitutional, and this government says they don't care. There's been 3 cases recently in the last 4 months where courts have struck down as unconstitutional violations of Canadians' charter rights in their ideological blind zeal to pass legislation that makes them look tough, but is not backed up by evidence or respect for courts or a constitution of this land. An example of this government's mean-spirited attitude, and I think one of the reasons that this bill is put before us today, is to change the channel on Canadians' abhorrence and widespread opposition to this government's taking away of health care rights to refugee claimants in this country. And, you can, whenever this government gets in trouble, and it gets in trouble quite often, they try to put forward some tough-on-crime aspect and try to switch Canadians' attention to relatively, to important but relatively minor issues in the grand scheme of things. Now, here are the real problems in the immigration system. The real problems that this government should be putting legislation before this House to deal with are these. There are huge waiting lists for every single type of immigration application there is. Across the board, no exceptions. The fastest immigration application possible is generally when you sponsor a spouse. When a Canadian marries someone who's not a Canadian citizen or permanent resident and wants to, quite rightfully wants to have their spouse with them. That is taking 1 to 2 years. The current waiting list to sponsor your parents was 10 to 13 years. And this government was so inept and incompetent at dealing with that issue that the only way they could handle it was to impose an absolute freeze, a 2-year freeze on any applications by any Canadian or permanent resident sponsored parents, period, which is currently in force. The employers of this country that want to bring skilled workers over routinely complain that it takes 6 months, 12 months, 1 year, 2 years, 3 years, 5 years, 7 years. Most of the time, it takes so long to get a skilled worker over here to satisfy their business needs that by the time they actually get the application approved, it's too late. The question of granting visitor visas is so important. The system is absolutely fundamentally broken with visitor visas in this country. The system is unjust, it's arbitrary, there is no right of appeal. In my neck of the woods, where I have an extensive South Asian population, the refusal rate of visitor visas applying through one of the 2 visa offices in India, the one in Chandigarh, is 53%. More than half of every application through Chandigarh is rejected through that office. Now, what are these applications for? Mr. Speaker, these are for people who want to come to Canada to attend weddings of their family members, births, anniversaries, graduations, visits, so brothers and sisters can reunite who haven't seen each other for decades. The very important events that Canadians cherish and want to share with their family. This government sits idly by while tens of thousands of visa applications are rejected every single year for no reason whatsoever. And every member in this House, from all sides, knows that people come into their office and say, we don't understand why the visa application has been rejected by some faraway anonymous person working in a consulate with no appeal, no way to access them. Mr. Speaker, these are the kinds of issues that this government should be tackling with the current immigration system. These are the broad, general, widespread issues and problems that Canadians face on a day-to-day basis. And I would call on this government and this minister to quit playing politics with the immigration system and trying to look like he's tough on crime and actually solve the actual real problems of the immigration system and produce a modern immigration system that can quickly, efficiently, and fairly process every application. There's no reason that any application across the board shouldn't be processed from start to finish within 24 months, that we shouldn't have a fully computerized system in this country where Canadians shouldn't have accountability from the bureaucrats making decisions. And that's the kind of legislation that this side of the House will support, and we call on the government to table in this House to make our immigration system modern, helpful, and that is so important to Canadians' futures and the economy of our country. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires? The honourable member for Winnipeg North.
Yes, Mr. Speaker, I want to pick up on the actual name of the legislation, C-43, in part states the Foreign Criminals Act. And I pose this question because I know the member is fairly knowledgeable about other legislation that has passed with this particular minister. And in my opinion, it really sends a very negative message in regards to, just Canada being a tolerant society and so forth. What we're really talking about is permanent residents, 1.5 million permanent residents. And it was interesting he made reference to the issue of priorities. And one of the areas that we really need to look at is the processing of citizenships. So what happens nowadays is that we have permanent residents that apply for citizenships, and they're waiting in excess of 2 years before they're granted their citizenship. And I'm wondering if you might want to provide some comment on that aspect in terms of, because they're both related to permanent residents. On the one hand, the government seems to want to punish permanent residents. On the other hand, he's completely ignoring the need to try to speed up the processing so permanent residents can, in fact, become citizens.
The honourable member for Vancouver Kingsway.
Thank you, Mr. Speaker. I'd like to thank the honourable member from Winnipeg North, who I had the privilege and pleasure of sitting with on committee for a period of time, and thank him for his hard work in this area. And he raises an excellent issue. Let's just look at citizenship. Obviously, this bill deals with removal of permanent residents. There's a further level of protection that people get once they obtain citizenship. let's just isolate this one factor of how long it takes to get citizenship. How this government finds it acceptable and finds there to be no need to table legislation in this House to speed up or provide administrative improvements to a process that takes at least 2 years to get citizenship. Now imagine if this was the private sector and you went to a business and you wanted to purchase a good or service and they said, that's fine, we'll provide this for you, come back in 2 years. And this isn't building a bill. I mean, 10-story apartment buildings are built in 2 years. This is simply getting a piece of paper. And this government sits back and has this kind of incompetent administrative inefficiency, and it's not fooling anybody, Mr. Speaker. Canadians deserve better than that. If someone wants to be a Canadian citizen, we should be expediting and facilitating that process, and there's no reason that it shouldn't be granted promptly like it once was in this country.
Questions and comments? Questions et commentaires? L'honorable député.
The honourable member for Algoma, Manitoulin, Kapuskasing.
I greatly appreciate my colleague's comments. I know that he's quite well versed with the issues of immigration as well. And I think that he'll agree with me that I don't think that there's anybody in this House that doesn't, that is supportive of the criminal aspect. And we certainly need to make sure that we have proper laws and legislation in place. However, you know, when we're looking at this type of legislation that the government has put forward, it's obvious, and I'm sure that he'll agree, that they are actually speaking on both sides of their mouth on this here. And he's absolutely right. You know, the judicial process, by providing arbitrary powers to the minister, is the wrong way to go. And maybe he'd like to comment with respect to that, and I'm saying because they speak on both sides of their mouth, maybe he'd like to comment about the Conrad Black issue, where the minister had claimed that he wanted to this matter dealt with independently. Excuse me, Mr. Speaker. So on one hand, he says that he wants more power to intervene to deport criminals, but yet on other criminals, he's saying that we need to have an independent process. So maybe my colleague would like to kind of speak a little bit about that. Thank you.
The honourable member for Vancouver Kingsway, you have about 35 seconds.
Well, thank you, Mr. Speaker. I'd like to thank the honourable member. She raises a number of very important points. I'll just deal with one of them, which is Canadians witness the spectre of gross hypocrisy when this government tries to be tough on crime and is talking about deporting permanent residents who don't have Canadian citizenship easier, in some cases denying them a right of appeal if they've been convicted of a sentence of more than 6 months. But we watched Conrad Black, who was not a Canadian citizen because he renounced it, come back in this country after serving a 4-year sentence for fraud. And I always found it interesting that the Minister of Immigration always said that immediately about hearing of the application, he contacted immigration officials and advised them that they should be handling that at arm's length. And I always wondered, what was the need to make that phone call? Wouldn't you expect that to be the case? Thanks, Mr. Speaker.
Reprise de débat.
Resuming debate, the honourable member for Gatineau. Thank you. I will start with the flowers, the roses, and I'd like to give them to the colleagues from North Delta and Saint-Lambert, who both do remarkable work in areas of files that are not always easy and clear, and I'd like to go along the same lines as my colleague from Vancouver Kingsway with regard to some aspects of this bill. I talked about the roses. We said that we would vote in favor. For our friends opposite, we will vote in favor of this bill at second reading because we want to be able to study it better in committee. And I must tell you that with everything I've been hearing over the past few days, there will be a lot of consideration that needs to be done in committee because there are problems with this bill that we can see just by quickly reading it. So you can imagine when you do an in-depth study what will happen. I'd like to give a little story here because, like my colleague from Vancouver Kingsway said, who has a lot of newcomers in his riding, I am in Gatineau, and I can tell you that Gatineau is a typical portrait of a Francophone riding. 93–94% of it is white Francophone and young families. So it's the opposite. And you'll say, well, there's no immigration problem in that kind of area. There's no problems with refugees. But if I were to tell you that my riding assistants, who I really want to say hi to because I don't see him often, Alan Seguin, who does excellent work in areas that are not obvious and easy. And when we sit down and talk, you'd be surprised to know that in my riding, which is 93–94% white young families, Francophones, well, the majority of our files are in fact files concerning immigration, refugee files, visa files, and I hear things that I don't always know about, and it is quite surprising what I have learned over my years, and of course I have a number of them under my belt, if you will. I would say that be it when I was on the radio or on TV, how easy it is to make people feel better, to make people, and to talk about very serious subjects and make them completely unhuman. And here we're giving various impressions and we're playing on people's fears here. And I was looking just out of curiosity, and I think that my colleague from Winnipeg North mentioned it, but in part because he seemed to be offended, and I too, with the title. And here we're talking about the short title. And I always say it's the details where we see the reality with our friends opposite, because the title of the bill is actually an Act to amend the Immigration and Refugee Protection Act. And I want to insist on this fact, refugee protection, because when we open the bill and we look at the short title, and normally a short title when I was in law school, it was a way of shortening the title that was sometimes overly long. And this is what a short title meant in law. And here we see that the short title often gives us the intent behind what our friends opposite are trying constantly to do with the bill. And this is edifying because the short title just really strikes you, and not by little, because this an act to amend the Immigration and Refugee Protection Act, and I thought, how are they going to shorten it? It's already short enough, and it says what it has to say, but here it's called Faster Removal of Foreign Criminals Act. Wow. There'll be a lot of problems. But what struck me when I read more about the subject was that it's difficult to know how many cases this involves, because why can we never get any information with our friends opposite? It's like going to the dentist and pulling teeth out, and you're trying to extract a tooth every time. And I think that this is a subject that's extremely important, because I always say that when you're here in this chamber, which is a very impressive and imposing chamber, we have a role to play. And I would say this is another law principle, a legal principle that I learned, but I'll need to go back to the law school at the University of Ottawa and say, forget about it. It's not true. A legislator speaks to say nothing, because here in this wonderful chamber, I think that all too often people speak and say nothing. We're creating laws, and I wonder where the problem is. We're inventing problems in order to try to find bills that we could put up in people's faces in order to make the 6 o'clock or 11 o'clock news. And this is really sad, because this perpetuates prejudice, easy prejudice, in fact, because when I was a little girl, I understood, and my parents told me that Canada is a beautiful country, and I was made to be very proud from a very young age of being Canadian, Franco-Ontarian, Quebec. I know that we lived in the beautiful Federation of Canada, and my father often said to me, Canada's beauty is in our three founding people. If I include Quebec, Canada, and our First Nations. And it's a welcoming land. We're seen as a place where we are humane, where we think about not just what's happening within our borders, but also outside of our borders, and without making your hearts bleed. Everybody knows this, Mr. Speaker, but I would say that there are things that are not so great that are happening elsewhere. My father always told me, well, in Canada we have open arms and we welcome people to come here. So I grew up with this idea and this belief, and since I would say the last 10, 15 years, it's as if that tone has hardened, and we're working a lot. Perhaps it's become very mediatized because we have 24-hour news, and it's a war to get the people to watch or listen to your show, and so there's shock stories, and it's easy to take somebody who's not one of you and sort of separate them and make them different. You don't have to share my opinion, but when we talk about immigrants, when we talk about refugees here, this, to me, when I grew up, it was difficult for me to understand the difference when I was a young child, and now what I understand is that an immigrant decides of their own free will to come here, but the refugee doesn't have the choice. They're looking for a place to go because if they stay where they are, they could be killed. So we need to remember this basic concept from the very start that said there are always good people and people who are not as good. There's something of a Jack Layton in me. It means that I'm a bit of an optimist, and I think that the vast majority of people are fundamentally good. And I do believe this still, despite the fact that sometimes it's hard when you get up in the morning to believe it, when you read the news sometimes, but I still believe that. But all that we see here with the bills coming from our friends opposite is a constant attempt to try to denature concepts that are full of humanism and optimism, and to make us instead a society that is mistrustful of the person next to us and everything else. And these are very unfortunate impressions, and there is probably, based on that idea, the worst refugee ever in the land, just in the next corner. And if we don't have the Minister of Immigration, who is the captain of our ship and who is going to really work to ensure that we can live without fear, this person will take the criminal and send them back to where they came from and say, well, go ahead. So I have serious concerns with regard to this bill and with a number of other bills. The only warning that I would like to give here is that, yes, perhaps we're taking away a lot of powers from the appeal section of the Immigration and Refugee Board, and this is being transferred to the minister, who I really like, by the way, but I'm not sure that I would let him do that. But that said, with this kind of bill, when you take away a means of recourse, you create a problem. By having this kind of measure in place, this will mean that there will be court challenges, not on the file themselves. So what I predict in my crystal ball is that we're going to have a lot of court challenges of the minister's decisions, and this will just open another Pandora's box that will be quite unfortunate. So once again, I hope that we'll be able to hear what is being said in committee. The committee will be able to do an in-depth study of the bill, and that they're not going to think on the other side that because they wrote it that it's very good as it stands. Thank you, Mr. Speaker.
Excuse me. Questions and comments? The honourable member for Athabasca Fort McMurray.
Yes, thank you, Mr. Speaker. I was a little bit shocked. I only arrived at the debate about an hour ago, but I've been listening to the NDP talk about minor crimes or issues being minor in the particular circumstances, anything less than 6 months as far as the punishment goes. And I'm just wondering if she could clarify what minor means in her submissions. They've been talking about it, and my understanding, being a criminal lawyer for some period of time, is we're talking about actually minor offences such as assault with a weapon, sexual assault, robbery, break and enter. These are violent offences, and these are offences that Canadians tell me they expect us to put people away in jail. They don't expect those people to be allowed into Canada in the first place, and if they do commit these offences, that they're immediately taken out of the country and not allowed to have the privileges of Canadian citizenship. So is this what the New Democratic Party means by minor offences, things like robbery, rape, sexual assault? Is that what they mean? Because that's what
L'honorable député de Gatineau.
The honourable member for Gatineau. Thank you very much, Mr. Speaker. Well, I'd like to say in English, I rest my case. I think the honourable colleague did not listen to the basis of my comments. That exactly the kind of question. In any case, I appreciate that a Conservative has risen in the House, in fact, to try to show some interest in C-43. But that said, no, that's not what I mean by minor offense. I know that's what the Conservatives constantly try to make people believe, that the official opposition prefers to protect pedophiles and bank robbers and so on and so forth. Here we're talking about changing from 2 years, people who have been found guilty of something and get up to over 2 years in jail, and they're reducing it to 6 months. And what I like to tell my colleague here, Mr. Speaker, is that 6 months, we saw that for shoplifting. We saw that also applicable to other things. And when we talk about minor offenses, sometimes when people are young, they make a mistake, and with help from the legal system, they become very good citizens. So we have to constantly take the most extreme cases in order to try to shove it down our throats and tell us that we're saying something that we're not. No one here in this House, Mr. Speaker, wants to see a refugee in Canada to whom we have opened our arms and who is in fact a hardened criminal, a dangerous criminal who would stay here. That's not the issue. The issue is to make sure that we ensure balance within the bill. Thank you.
Questions and comments? The honourable member for Winnipeg North.
Mr. Speaker, I would like to kind of pick up on that particular point. In real terms, what we're talking about is, imagine you came to Canada 15, 20 years ago. So you're now a permanent resident, but no, you haven't acquired your citizenship. Maybe other members of your family have, but you haven't acquired your citizenship. And if this legislation passes, what's in essence the government is saying is that if you are caught with 6 plants of marijuana in your house, you will be in fact deported, no appeal. Now, it doesn't mean your entire family is. Your 3 or 4 children, of which might have been born here in Canada, your spouse, who could even be a Canadian citizen, is not going to be deported either. It's you. Why? Because you have 6 plants of marijuana in your room. These are the types of things that will, in fact, take place. And I wonder if she could provide comment if that is just punishment for this particular type of individual that would be caught in that sort of a predicament.
The honourable member for Gatineau. Yes, thank you, Mr. Speaker. That's exactly what I was saying to my colleague before. With all the work that's been done on C-10, on law and order, they included so many new mandatory minimum sentences for offences that even colleagues opposite could admit aren't as serious as a theft, violent theft, or major fraud, and this fits with the context of what the colleague from Winnipeg North just said. It's not rare because there are many people who don't think to ask for citizenship who, after those mistakes, after having served their sentence, become excellent Canadians. They just haven't officialized their relationship with our country, so we can wind up with all kinds of situations. But once again, I would send this question back to the government. Based on how many cases are we talking about here? Who are we targeting? But it's always a lack of transparency with this government that was elected on a principle of transparency. Resuming debate, the honourable member for Quebec. Thank you very much, Mr. Speaker. What can I say after my colleague from Gatineau, who gave a very apt summary? I would say that it's with very mixed feelings that I take part in the debate today. First of all, I'd like to say that, yes, we share the government's concerns with regard to serious crimes committed by individuals who are not Canadian citizens. However, we think that it is normal, too, to share concerns with Bill C-43. The consequence of this bill will be to prevent permanent residents and illegal immigrants who get in 6-month or more prison sentence in Canada from appealing their deportation order. People who have been convicted will be returned to their country 12 or 15 months earlier than if they had been able to put their case before the appeal division. Currently, only immigrants sentenced to over 2 years in penitentiary are deprived of that right, according to the Department of Immigration. Rather, over 2,400 people who are convicted are currently have their cases before the Immigration Appeal Division of the Immigration and Refugee Board. The new rule would eliminate half of these cases. Other changes to the legislation are set out. It would no longer be possible for those who are admissible to Canada for serious reasons to remain in Canada for humanitarian reasons. Furthermore, a new power would be given to the Minister of Immigration. Yes, another, you heard right, another power would be given to the Minister of Immigration. Obviously, he didn't think he had enough with everything that happened in C-31, C-44, where he had already gotten more powers. So this minister would then have the power to refuse permanent resident status to an individual based on public policy considerations. And of course, the courts will be overwhelmed, even if that's already the case now. Finally, with C-43, a foreign national would no longer be allowed to remain in Canada if a member of their family is ineligible to be in Canada for reasons related to safety, organized crime, war crimes, and even if the person who committed the crime is not accompanying them. The Minister of Immigration said about Bill C-43 that he's seeking to reorganize the removal of convicted criminals by limiting their access to appeals. The minister indicated that currently many immigrants found guilty of crimes can avoid being removed because they are sentenced to less than 2 years in prison. I think that probably we'll have to talk about a context for the word numerous, because according to Statistics Canada, 86% of prison sentences in 2010-2011 were 6 months or less. We want facts, Mr. Speaker, facts, because nothing else matters. As I already said, this bill seems to be part of a worrying trend by the Conservative government yet again, which is to give discretionary powers, increasing discretionary powers to ministers when it comes to immigration and public safety. The significant discretionary power that C-43 would give to the minister with regard to making or revoking an application would prevent a foreign national from becoming a permanent resident for a period of up to 36 months seems to go too far and must be modified to justify the discretionary powers that the minister would get. The minister said, and I quote, "We don't have enough time." Unfortunately, a little time is sometimes what these immigrants need. And just to fill all the forms, all the paperwork, make all the phone calls, confirm that this document or that document had to be tabled within this time period, and they're cutting, obviously, customer service at Immigration Canada. So I think that a little bit of time really is not too much to ask from the minister. It would really be the littlest thing possible.
Michael Bossin, who is a refugees' rights lawyer in Ottawa, has stated that in his experience, a stint in jail for these young offenders is a lesson to them. They come out, get jobs, they're responsible, they build families, and they pose no further threat to the public. And still, according to Mr. Bossin, under a removal order, a young immigrant acts as though it is a probation period and changes their behavior. So, under the changes being brought under this new law, this would be really an exportation of Canada's social problems without really dealing with the root causes of criminality. So he is, I think, right on saying that, because that is what we should be doing, dealing with the root problems. So once again, coming back to Mr. Bossin, he believes that people who suffer from mental illnesses would be particularly suffering. It would be prejudicial to them, because they would be removed and deported to countries where their state of health was often stigmatized and punished. According to Ms. Lash, another lawyer specialized in immigration and refugee services, she says these changes would affect many more people with psychiatric problems. According to Joel Sandeluk, who's another lawyer, this risks dividing families. He said that it would destroy families that have been in Canada for a long time. If relatives or other members of the family are deported from Canada, this will create irreparable damages. Irreparable because we're talking about the lives of human beings here. Let us never forget that. Moreover, Andres Schreck, who is the Vice President of the Ontario Criminal Lawyers Association, stated that Bill C-43 raised constitutional issues under the Canadian Charter of Rights and Freedoms. Lawyers from across the country are therefore defending the rights of Canadian immigrants, many of whom arrived in Canada at a young age. They were raised, educated, and established families here, as well as businesses. And you have to say that many Quebec businesses indeed were created by immigrants. They've received incredible entrepreneurship awards, and I'm very proud of them. So the government's proposal here is very clumsy, I think, what has to be said. It risks having a significant effect on immigrants who do not have their Canadian citizenship, because the bill would also apply to permanent residents of Canada who've been here for decades. In order to justify this bill, the government gave examples where immigrants committed serious crimes and then, following that, used the system to try and delay their removal for several years. These cases do indeed effectively demonstrate the flaws in the system, and I agree that it's important to discuss and study the issue. But we have to look at what those flaws are and ensure that that is really specifically what we're dealing with. That is why we in the NDP want to see this bill move to the committee stage. And despite the obvious shortcomings of Bill C-43, we would like to hear the experts address the issues in order that we find reasonable solutions to the problems. The NDP believe that it is possible to work with the government in order to prevent non-citizens who have committed serious crimes from abusing our appeal system. But this is possible without abusing of these people's rights. On the other hand, the NDP also supports new immigrants who hope that the government will concentrate on the improvement of the fairness and speed of the immigration system for the great majority of people who do not commit any crimes and respect the rules and regulations. In conclusion, here we are faced with another bill, once again, from the Conservative government. There's nothing we can't do with this majority that we have. We'll just steamroll over the opposition, and particularly over this immigration experts in this domain, and I quoted several of them. They need to stop and concentrate on the root problems here. They need to look much more in-depth at this. And once again, I think this is a bill that is lacking in nuance. It deals with prejudices and ways of dealing with immigrants that really has no class at all, in my opinion. I think that these people are here in our country and they're functioning very well, and very often, in certain cases of people that I've met, there are people who are absolutely wonderful, and they are often models in our society. So I believe that doing away with those models, these people who teach our young people really deep values that are universal, Canadian but universal as well. I think it would be really unfortunate to trample their rights and send them back home in this way. Thank you.
Member for Crowfoot.
Well, thank you very much, Mr. Speaker, and I want to commend this member for a very good NDP speech. It was one of the best NDP speeches I've heard for some time, in that it was an NDP speech. Make no mistake, this speech talked very much about the offender and the rights and model of some of the offenders that she knew were model citizens. That's a good NDP speech. It talked nothing about the victims. That's a wonderful NDP speech. That speech that is light on victims and heavy on the offender. And Mr. Speaker, in my riding, when I go out into my riding, I have individuals that come up to me and say, you know, I saw the newspaper today that so-and-so who came from another country, who immigrated here, who committed armed robbery, is now going through an appeal. Why don't we just send them back home? And that's what we hear. That's what we hear out in our riding. We hear people like Gregoire Capra, over 60 counts of fraud, forgery, conspiracy to commit fraud, obstructing a police officer. He got ranging from 2 to 2 years less a day. He was asked to leave. The removal order was in September 2003, and he began the appeal process. Mr. Speaker, this bill is going to change that. This bill is going to say that you be on your best behavior when you come to our country and you are not a citizen. Keep clean. Be productive. Become part of what we expect here in this Canada. Multicultural, rich heritage. Please be part. But if you're going to be a criminal, you're going home. Why doesn't this care about the victim?
Order. L'honorable député.
Honourable Member for Quebec. Thank you, Mr. Speaker. I'd like to thank my colleague. He was bold enough to make a compliment, but I think if he did compliment me, it's because I made the effort here in the House to bring a nuanced speech to the House here. I didn't want to fall into cliches. I had a conversation with a cab driver who was just, and that was an exquisite conversation. It made me really think. You know, when you open the paper in the morning and you see a case where you say, what a terrible story. It's such a bad story. It's so horrible. It's a drama. It could involve any kind of crime. But at some point in time, that crime has no race or age or sex. It's just a terrible crime. And what I was saying in my speech was that this bill won't change the deal here. There aren't many cases that it will really address. So it's a case, unfortunately, that really to these kinds of old prejudices, and that's not where I want to find myself. I really want us to deal with the flaws where they are. I don't want to kill a fly with a sledgehammer. It's ridiculous. I mean, we're going to destroy all of this because we want to be very certain to be protected. We want to be sure that Canadians' safety and security is intact. At some point in time, it's important to have some nuance here. I think that...
Before I go back to questions and comments, I'd like to remind all honourable members that in the 5-minute question period, there are times for about 2 questions and about 2 answers. And that means about a minute each. And if members pay attention, the chair usually gives you an indication as you're approaching the end of your time. If you ignore that, the chair will cut you off and we'll move on to the next question. So, questions and comments? The honourable member for Winnipeg North.
Thank you, Mr. Speaker. You know, I listened to the member's question, and I want to highlight the fact that there's over 1.5 million permanent residents here in Canada. And a vast, vast, vast majority of those permanent residents are outstanding citizens of this country. And I think the government does need to be reminded of that fact when they label legislation foreign criminals, Mr. Speaker, and the message that they're trying to send. So yes, they want to come across as being tough on crime, but they're also sending a very negative message for that 1.5 million permanent residents that are living here in Canada, calling Canada home. And I'm wondering if the member might want to respond to that aspect of the targeting that is taking place by this government.
L'honorable.
Yeah, honourable member for Quebec. Yes, indeed. I think that everyone supports virtue. I think everyone wants to share those kinds of values. But that's the problem here with this Conservative government, is that they always go much too far into cliches and they exploit it to a degree that makes no sense. That's the problem with the bill. The bill just falls into that kind of conservative argument and makes no sense. And the NDP doesn't support criminals. That I don't know how you could believe that, but honestly, I would never accept that.
Reprise de débat.
Resuming debate.
Resuming debate. The honourable member for Surrey North.
Thank you, Mr. Speaker. It's an honour to speak in this House on behalf of my constituents from Surrey North. And I've been just want to begin by mentioning that I am an immigrant to this country, and I'm thankful for the opportunity that I've had in this country. And there are many other members in this House who are also immigrants to this country. You know, I was hearing the debate all this morning, and you know, the member from Winnipeg is absolutely right. Vast majority of the immigrants that come to this at one point or another, they are good citizens. They contribute to the economy here, the culture here, and they make good citizens. Yes, you know, they are, you know, I'm also a father of a young girl and a boy, and I know which side I'm on. I know which sides I'm on when it comes to rapists, when it comes to criminal murderers. I know which side I'm on. So for conservatives to constantly talk about which side the New Democrats are on, as a father, I know which side I'm on, Mr. Speaker. Mr. Speaker, the bill C-43, an act to amend the Immigration and Refugee Protection Act, in principle, we do agree. We do agree that there are some good aspects to this bill. However, there are many holes that need to be looked at, and we would be supporting at this point to send it to committee so that we can look at some of the holes that are in this bill, and that is where the committee will look at some of the issues. One of the issues that I have with this bill is that it concentrates more power in the hands of the minister by giving him new discretionary authority over the admissibility of temporary residents. Basically, the minister can declare a foreign national admissible for up to 36 months if the minister is of the opinion, notice the word opinion, that it is justified by public consideration. The minister may also at any time revoke or shorten the effective period of declaration of admissibility. So, you know, I have trouble with that word, opinion. What is that opinion? How does that minister form that opinion? Are there criteria set as to how that opinion is formed? Very, very troubling. The second component I have trouble with is also the changes to what constitutes serious criminality for the purposes of access to an appeal of determination of inadmissibility. You know, previously, a conviction in Canada resulting in a prison sentence of 2 or more years constituted an automatic stripping of permanent residency or temporary residence right to an appeal at the Immigration Appeal Division. But Bill C-43 would revoke the right to an appeal of a determination of inadmissibility where there's a conviction of 6 months or more. You know, we've talked about minor offenses. We've talked about young people in this House since this morning where there may be a young person who has committed a robbery and they are put in prison. and their whole family is here, and this person would have no right to appeal to get a fair hearing, and this person may be able to reform themselves and become a productive member of society, yet they will be sent back to a country which they may not be familiar with at all, Mr. Speaker. So that, I do have a problem with that. The bigger issue that the Conservatives are trying to avoid is the whole immigration system that we have in place. There's no doubt that over the past 6 years, it was broken before. The Liberals had a chance to fix it for many years. We've seen lineups and then wait times being increased for family reunification, for spouses, for skilled workers, and that was under the Conservatives, the Liberals. And then the Conservatives said, well, we're going to fix this and we're going to make it all better. What I've seen in the last 6 years is that the dismantling of the immigration system, which is broken, and they're not, that is the bigger issue here. They're not fixing the immigration system so it's fair and it's effective, it's efficient, it serves the needs of Canadians. And we're all familiar with, Mr. Speaker, that Canada has an aging population, and we do need immigrants to fill the jobs that are going to be that are here, that are also going to help government bring in revenues so we can provide services such as education, such as farm or Medicare, other services that Canadians depend on. Yet that's not what conservative concerns are. They're avoiding the whole issue of fixing the system so that it's effective, it's efficient, it's better for our economy. No, they're not doing that. Let me give you some examples, Mr. Speaker. I had a young couple come into my office a few months ago, and I had a chance to sit down with them. And they had gone to another country to look for a caregiver. And they interviewed this person, they liked the person, and this would be somebody who would provide child care for their daughter. Mr. Speaker, they came back to Canada and they wanted to put in an application, and these individuals, one of them, the husband was a business person, and the woman was a teacher in a local school board, and they wanted their daughter to be taken care at home, and also get that live-in caregiver to be sponsored from another country. And what they found out when they submitted their application was that it would take 4 years before they could get the application reviewed by our embassy in this country. 4 years. So you have a 3 or 4 year old daughter, and you're going to have to wait 4 years to get a caregiver to provide service. And these people here are productive members of our society, a teacher and a business person who's providing jobs in our community, and yet one of them will have to stay home to take good care of their daughter. That was their predicament. And that is not right. This system needs to be fixed, and that's broken. That's what they told me, Mr. Speaker. I had another case here. I had a case, a woman who had a stage 4 breast cancer, Mr. Speaker, and she was trying to sponsor her mother from Romania to come here to spend the last 4 or 5 months with her so that she could be surrounded by family. And her mother had come to Canada previously. She had come on a temporary visa and she had returned. And this woman wanted to spend time with her mother. What did the embassy or what does the rules do? She was denied a temporary visa, Mr. Speaker. She was denied a temporary visa. This system is broken. Here's a person who has come to Canada already, and they've gone back. And in the last dying days of her daughter, she's not able to come and take care of her. And this woman that had breast cancer, she was willing to provide financial support, health care insurance for her mother to be here in the last dying days. Another example, Mr. Speaker, I've had a father requesting his son come and visit him in the last dying days of his in a hospital, and this person was denied a visa to come into to Canada to see his dying father in the last days. Not only that, Mr. Speaker, this father died in a hospital, and again, the son applied for a TRV visa, which is a temporary residence visa, to come and visit and see his father for the last time. These are the kind of problems that this government is failing to fix, Mr. Speaker. And, you know, if they were...
Point of order, the honourable member for Oxford.
There's no relevance in the last few minutes of this member's speech to the bill at hand. We're talking about deporting foreign criminals. He's talking about a lot of sad stories. We understand that, but it has no relevance to the matter at hand.
Order. The honourable member from Oxford is correct that there is members are required to speak to the matter before the House, but it's also the practice of this place that significant latitude is given to members, and so I would go back to the honourable member from Surrey North, and he has about 30 seconds left in his time.
Thank you, Mr. Speaker. I believe that this is relevant because the Conservatives have brought in a bill that addresses a small component of the Immigration Act. And yes, we are supportive of that principle. However, the bigger issue is the immigration system that's broken, and they're failing to fix that system, Mr. Speaker.
Questions and comments? The honourable member for Prince George, Peace River.
Yeah, thank you, Mr. Speaker. And I guess just building on what member from Crowfoot was talking about, again, I didn't hear one mention of victims. And I think the whole purpose of what we talked about in this legislation is that there needs to be a mechanism so that people, when they come to Canada, they respect our laws, and if they're not going to do that, simply put, they get sent back. So I'd like to ask the honourable member a question about what he thinks, I guess, in terms of victims, and does it matter to him that the victims and the criminals get deported that should get deported?
The honourable member for Surrey North.
Thank you, Mr. Speaker. You know, Mr. Speaker, in the last year and a half since I've been here, and I've seen Conservatives talk about how they would stand up for victims. The facts are they're not standing up for the victims when it comes to providing compensation for them, taking care of their families. In fact, this particular legislation will create more victims of families whose young people, or if a family is all together, one of the family members is deported for a minor crime, it'll create more victims. If Conservatives wanted to stand up for victims, they should be increasing funding and investing in preventative programs that will eliminate the crime in our society.
Questions and comments? The honourable member for St. John's East.
Thank you, Mr. Speaker. I wonder if the member for Surrey North would like to comment on the fact that this bill talks about foreign criminals, and I know members opposite talk about foreign criminals as a criminal person comes to Canada and commits crime, so therefore they should be sent back home, quote unquote. When the reality, I think, for a lot of people who are in Canada as permanent residents, some of them come here at age 1 or 2 or 3. They could be here for high school. They could be spending all of their lives there. Their home is actually Canada. And if they were actually, coming to a place where we promote the rule of law, we would expect the rights of appeal, etc., to be available to them. If they commit a crime that they get 6 months or more, they are entitled to the rehabilitation provided by the penal system. Can they be considered foreigners who should be sent back home? Is that a realistic way to look at our immigration policy and how we should treat people who come to this country?
The honourable member for Surrey North.
Mr. Speaker, the title of the bill, I also have trouble with that, faster removal of foreign criminals. And we've heard this in this House. This is about permanent residents. These are people that we've admitted to this country, and I was one of them at one point. And we have 1.5 million permanent residents in this country. For one reason or another, they have not taken out their Canadian citizenship. The issue that my good colleagues is talking about is that when we have these members as part of our society, and yes, you know, there may be a minor crime committed. There should be an opportunity for an appeal and also for that young person to rehabilitate in our society, which he may be separated from his family and he may be deported to a country which he has no ties to at all. So certainly, I think we need to look at providing opportunities for cases where a second look is warranted.
Time for a quick question. The honourable member for Brampton West.
Well, Mr. Speaker, quickly I want to say that the only people in here, the members on this side of the House, the member from Winnipeg North, keep saying that somehow we're saying that permanent residents are criminals and this is targeting permanent residents. We on this side of the House and that side of the House, we don't believe that permanent residents are a bunch of criminals who are going to be deported. The only ones slandering permanent residents here are these members and the member from Winnipeg North. And I want to know if they want to apologize to the 1.5 million permanent residents of this country who I think do a darn good job contributing to this country.
Here, here.
The honourable member for Surrey North.
Well, Mr. Speaker, I actually agree with my member that the permanent residents are contributing to this society, this country, economically and in a cultural sense. But I do not agree with the member, and I actually agree with my fellow Liberal member when he talks about 1.5 million permanent residents that are part of this society, and the Conservatives are looking at some very small number of cases where there are people that are in this country and they've committed a serious crime. They should be deported. Of course, we all agree on that. However, they are targeting that $1.5 million. It's very unfortunate they speak on both sides of their mouth, Mr. Speaker.
Resuming debate, the honourable member for Algoma, Manitoulin, Kapuskasing.
Thank you, Mr. Speaker. This is an interesting bill we are looking into today. It is, by all accounts, a bill to allow Canada to deport non-citizens who commit serious offences. This in itself is an eminently supportable goal, but doesn't fully describe the entirety of Bill C-43. As my colleague from Newton North Delta, the New Democratic critic for immigration, citizenship, and multiculturalism, has indicated, New Democrats recognize the need for an efficient and responsible judicial approach to removing serious criminals who are not citizens. I agree that all Canadians want a tough approach to non-citizens who commit serious, often violent crimes in our communities. It is also, I believe, important for us to note that the overwhelming majority of newcomers to this country are actually law-abiding and follow the rules. Those newcomers also support the broader concept that is the stated intention of Bill C-43. We cannot mix up the facts as we consider how best to weed out a small group of offenders that are no more a reflection of any community they come from than any domestic criminal is to their own hometown. Mr. Speaker, we can see there is agreement on intent, but it is not a free pass for the government to do whatever it wants. New Democrats would like to see amendments to the bill that will allow us to arrive at a piece of legislation we can support. Ultimately, our criticism of the proposed amendments to the Immigration and Refugee Protection Act relate to a handful of issues, not the least of which are the concentration of power in the minister and the abandonment of an appeal process. Mr. Speaker, you will see that we do not support slamming the door on an appeal process. Just as we don't support granting the minister unilateral powers to stop a foreign national from becoming a temporary resident for up to 36 months, based on what is being called public policy considerations. Surely we can agree that is a vague and broad definition. I see we can still hear the peanut gallery on the other side. In fact, the manner of which this bill concentrates more power in the minister seems to indicate some kind of disbelief in the system that is in place. some kind of a belief that what the process really needs is a sheriff. In C-43, we see that. Not only can the minister declare a foreign national inadmissible for up to 36 months, if the minister is of the opinion that it is justified by public policy considerations. But the minister may also, at any time, and I repeat, at any time, revoke or shorten the effective period of a declaration of inadmissibility. This may sound like jargon, but there's a bigger problem at play that others will recognize. That is the disturbing trend we see from this government of concentrating more power in the hands of individual ministers. This arbitrary power is granted at the expense of, guess what? Transparency, and clearly define policies that can be consistently administered. You may recall that this is one of the criticisms that was central to the changes to the Fisheries Act in the last budget. Those changes gave the minister discretionary power to determine whether or not a fish species was important enough to warrant protection. This bill continues that unfortunate trend. It is a pattern of behavior that puts the government and their decisions behind closed doors. It makes our government more opaque and quite the opposite of the transparent and accountable administration that Canadians desire and were promised. But there is good news, Mr. Speaker. This is something that can be fixed. If there's a willingness, there's a way. Ministerial discretion can be replaced with clear and effective guidelines that can be publicly administered. Something we hope the government will consider, something we know Canadians want and will support. What is more than a little strange, Mr. Speaker, is the way that C-43 gives the minister discretionary powers to act in the manner of the sheriff I just described, and yet relieves that same person from similar responsibilities related to appropriate discretionary powers at the same time. We see the call for the minister to be given the power to declare a foreign national inadmissible, but in those cases where the minister is actually required to use extraordinary powers to ensure the system is performing to its potential, the Conservatives are begging off that part of the job. As we know, the current arrangement means that on request of a foreign national, or even on the minister's own initiative, the minister is required to examine the circumstances of a person who is considered inadmissible on grounds of security, humanitarian, or international rights violations, or organized criminality. In those instances where the minister feels a compelling case has been made, he or she can grant an exemption on humanitarian and compassionate considerations, taking into consideration the interest of a child directly affected. And my colleague alluded to this a while ago with respect to children who come here with their family and may not have received Canadian citizenship by then. So if they're a permanent resident and they've been here since the age of 6 months or whatever it is, and all of a sudden they find themselves in a dilemma like this here, the minister can now say that you have to go home to a land that you've never really been to. But the new arrangement relieves the minister of this obligation altogether. It is as if the Conservatives cannot fathom that there would ever be circumstances where an appeal might be legitimate or even successful. And let's look at our own criminal justice system. You know, we have had people who have been criminalized, who have been put in jail, and when they've appealed the decision, and sometimes it's taken years, the government has actually even had to apologize for that. And that's why the appeal process is important. It represents a black and white view that doesn't match the reality of the world. It assumes there will never be a miscarriage of justice when we know full well that the potential for mistakes is always present. which is why we have appeal processes in the first place. To recap, Mr. Speaker, the minister wants to be able to act in a decisive manner on a case-by-case basis if they feel it is warranted, while on the other hand, they are asking to be excused of the responsibility of the office in terms of adjudicating what is basically an appeal process. What we have here is an appeal for both a concentration of power and the removal of a check and balance function. And that's about transparency again and accountability. You need a check and balance function. For New Democrats, these items need to be fixed. We have additional concerns about Bill C-43. Those relate to changes in the definition of serious criminality, as well as the intention to accept a decision from foreign courts that may not operate at the same high standard as ours do in Canada. As a bit of an aside, I am sure there are many professionals struggling for recognition of their foreign credentials who are looking on with a sense of disbelief that when it comes to branding someone a criminal, this government is willing to accept the standards of courts from countries whose professional credentials are more vigorously challenged. I am sure that point is not entirely lost on people who are struggling in that front, Mr. Speaker. To be clear, the larger goal of C-43 is not without its merit. New Democrats think this is a case where we can tighten things up, that we can take this bill to committee, roll up our sleeves, and do the work to ensure that Canada comes out of the process with a better Immigration and Refugee Protection Act. But, Mr. Speaker, most of us in this place know there are bigger challenges that we must address as well. We hear it from our constituents, and we see it is in our offices. I'll just leave it right here because you're telling me I'm out of time, and I'll gladly add the rest of my speech to the questions. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Palliser.
Thank you, Mr. Speaker. And very interesting speech by my colleague across the way. I'm a little confused in what I'm hearing, though. I hear the NDP saying that the Prime Minister is very controlling. He doesn't allow any latitude, doesn't allow for decision-making, and yet in the same breath, we're now condemning the Prime Minister for being too loose, for leaving everything open, and the Minister is making all the decisions. I kind of wonder which way we're looking at that, Mr. Speaker.
The honourable member for Algoma, Manitoulin, and Kapuskasing.
Well, I didn't particularly say that the Prime Minister was controlling, but obviously based on the acts that they're taking, it's obvious that they are controlling. And let me just kind of mention, because I think that if this government could have tied, let's see who's really being victimized, for example, immigrants, seniors, Aboriginal people, students. These are the people that are being victimized by this government here. If they could have tied victims, the word victims, offenders, or crime to their changes to OAS, I think they would have done it. So, you know, let's look at the real picture here, is that the services that could help people make sure that they have a good start here in Canada with respect to immigration, to keep them out of trouble, to make sure that things are going smoothly, is the very programs that this government is cutting. So even in places like Algoma, Manitoulin, and Kapuskasing, we are struggling with reduced services from the federal government, which includes the closure of Citizenship's office. And those offices are Sudbury, Sault Ste. Marie, Thunder Bay. Those are all offices that people from different corners of my constituency would have gone to for assistance. And guess where they're coming now? They're coming to our offices because those services aren't available in Northern Ontario anymore. So thank you, Mr. Speaker.
Questions and comments? The honourable member for Winnipeg North.
Yes, Mr. Speaker, there is a victim here. Many would ultimately argue, including myself, that the government is attempting to label those 1.5 million permanent residents that call Canada their home. Many of these individuals, Mr. Speaker, have family members abroad. Quite often what will happen is you will see a child that will leave a country, whether it's the Philippines or India, or a young adult that will leave a country like that. They arrive in Canada, and with this legislation, one of the things it's proposing to do is to deny someone the opportunity to visit Canada if their spouse is not of good character. They themselves could be of great character, good health, no risk of not returning, but they will be denied because their spouse is in good health, even though they'll have a child here in Canada. My question to the member is, does she recognize that as something that is just not fair and in the best interest of public policy?
The honourable member for Algoma, Manitoulin, Kapuskasing.
Thank you very much, Mr. Speaker, and I thank my colleague for his comments on this and his question, and he's absolutely right. I mean, this is a government that's actually really creating a crisis out of a very small amount of people, and we are willing to work with them. Every member of Parliament here is here for a reason, is to make sure that when legislation is put in place, that legislation responds to the needs of Canadians, to the needs of people. And in that respect, we need to make sure that we don't see ourselves before the courts, that we are not causing more havoc to laws here in Canada that are quite problematic. And this is about working together in order to fix a piece of legislation. As we said, we believe that this is a good intent, but at the same time, there are some changes needed. And what we've seen over and over again is very little flexibility on the side of the government to want to improve legislation in order to ensure that it's not to the detriment of people. That really puts people in a really bad way, and it's not a fair way. Thank you very much, Mr. Speaker.
Resuming debate, the honourable member for Parkdale High Park.
Thank you, Mr. Speaker, and I'm pleased to speak on Bill C-43, an act to amend the Immigration and Refugee Protection Act, and I want to thank my colleague from Algoma, Manitoulin, Kapuskasing, who just spoke, and I could feel how passionate she is about this issue. I also want to thank the honourable member from Newton North Delta, who has played such an important role in this House on immigration and refugee issues, and I thank her for her fine work on that. Mr. Speaker, this bill is one that addresses an issue about people who come to Canada and commit crimes, and it's interesting, the timing of this bill, because it is coming on the heels of some very serious, difficult, and controversial changes in immigration and refugee policy that have touched many members of my own community in Parkdale High Park. And I'm speaking specifically about the Refugee Reform Bill, C-31, and also cuts to refugee health care. In my community, part of my community, it's a place where many newcomers first come to Canada, and we've seen waves of refugees come from different parts of the world. There are many religious institutions and places of worship that are amongst the oldest in the city of Toronto, because they are the first stopping off point for many newcomers to Canada. So we have the oldest continuously functioning Jewish shul. We have one of the oldest Hindu temples. We have religious institutions of various denominations. And more recently, we have many refugees coming from places like Tibet and Hungary and other places in Eastern Europe. And something that has been very controversial in our community, and we have joined with health professionals in opposing, were the changes to deny some refugees or refugee claimants health care benefits. I have seen firsthand in my community people who are directly affected by these changes, and it has not been helpful that certain communities, such as the Roma community, have been demonized by this government, and it creates a situation that is unhealthy for them here, even prior to the status of their refugee claim being assessed. So it is interesting that now the Conservatives are introducing a bill to get immigration discussion back into a territory that they feel more comfortable with, and that is a tough-on-crime approach. And so I see that in the political context of dealing with refugee and immigration issues. This bill would give more power, would concentrate more power in the hands of the minister in terms of discretionary authority over the admissibility of temporary residents, and he can declare a foreign national inadmissible for up to 36 months if in his or her opinion it's justified by public policy considerations. The bill also relieves the minister of the responsibility to consider humanitarian considerations, compassionate situations, such as taking into consideration the interests of a child. So the minister no longer has to consider humanitarian concerns at all. It also gives the minister new discretionary authority to provide an exemption to the family member of a foreign national that is, quote-unquote, inadmissible if he or she believes it is against the national interest, specifically examining national security or public safety. There are also changes in this bill about what constitutes serious criminality, and previously a conviction in Canada resulting in a prison sentence of 2 years or more constitute an automatic revocation of a permanent or temporary resident's right to an appeal. This would revoke that right with a conviction of 6 months or more, which has to really be explored and investigated what kind of crimes we're looking at here and who is more likely to be affected. It increases the penalties for misrepresentation, taking them from 2 years to 5 years for inadmissibility for permanent resident status. And one thing that I think is very positive in this bill, it clarifies that if someone enters Canada as part of an organized criminal activity, that on its own would not constitute inadmissibility, which may be important to people who are trafficked into Canada through some kind of criminal organization. So while there is a legitimate concern, and I believe Canadians are legitimately concerned about the issue of non-citizens who commit serious crimes in Canada, we have a concern about concentrating more arbitrary powers in the hands of the minister. The vast majority of newcomers to Canada, and again, I see many, many of them in my community with direct experience, they're law-abiding people, they don't commit crimes, and we believe that the Conservatives ought to spend more time and more effort making sure that these people are treated fairly and quickly and are reunited with their families as quickly as possible. And Conservatives can have it both ways. You can't take someone like Conrad Black and welcome him back to Canada with open arms and claim, as the minister did, that this was independent of politics and handled by bureaucrats, and then introduce a law like this, which clearly is concentrating more discretion and power, discretionary decision-making power in the hands of the minister. Suddenly, he seems to have a conversion on the road to Damascus and wants to deport convicted criminals instead of welcoming them with open arms. So that's quite a change. But I do believe that there are a number of other ways the minister could help, such as maybe no longer appointing his friends to the Immigration and Refugee Board and having a fair process there. So while, yes, the issue of criminal activity and making sure we're not getting the wrong people here in Canada is important, we believe that there are concerns that are not being taken into account. Mental health issues are a big area of concern. I know in my community and in communities across the country. There are people who come here as refugees from war-torn countries. They do not get the kind of mental health support that they need, and we all know that there is a disproportionate representation of people who are mental health survivors in the prison system who desperately need help and would benefit greatly from help here in Canada, including many refugees, and whom deportation will not help. And I think Canada will see people from war-torn countries who are disproportionately rejected from Canada under this bill. So mental health is clearly a huge issue, and also the lack of ability to appeal. And that, of course, is up to the discretion of the minister, but the lack of appeal is something that has been criticized in other immigration initiatives by this government, and is certainly one that I would question here. I see my time is almost up, Mr. Speaker, but I want to say, while of course we support the issue of making sure that Canadians are protected from criminals who would take advantage of our immigration and refugee system and come to this country and commit crimes, that there are problems with this bill. It needs serious discussion, serious investigation, and serious changes in order to do the job that it is meant to do. With that, thank you, Mr. Speaker.
Questions and comments? The Honourable Member for Brampton West.
Thank you, Mr. Speaker. I noticed that my colleague was talking about concerns with increasing the ministerial discretion, and I think it raises an interesting point. I'm sure my friend is aware that in 2011, the Quebec Assembly passed a unanimous motion asking the minister to stop 2 individuals from coming to Canada due to their comments encouraging hate and violence against women and homosexuals. Unfortunately, there was no ability for the minister to stop those people from coming into the country. This bill will address that issue. So I have a couple of questions. Does the member and the NDP agree or disagree with Quebecers in the Quebec Assembly? Do they think that people who promote hate and violence should be allowed into Canada? And if they don't think that they should be coming into Canada, why won't they stand and support this legislation which will give the minister the power to do exactly that?
The Honourable Member for Parkdale High Park.
Well, I thank the member for his question, and I haven't read the bill in question because it's not a bill that's been before this House. Obviously, as champions of human rights and working constantly against anti-racism and anti-sexist behavior, we support those goals. What is a concern is concentrating discretionary power in the hands of the minister through this bill, and also casting a net so wide that it has unintended consequences. Let me just give you one more example quickly. Suppose someone comes to this country as an infant, the child of immigrants or refugees, grows up in this country, spends their life here, and as an adult commits a crime, but has never taken out Canadian citizenship. That person could potentially be sent back to a country where they have no connection, no family, no relationship to, because they've served a sentence of 6 months in a Canadian jail seems extreme. So I would question the broad net of this bill.
Questions and comments? The Honourable Member for Winnipeg North.
Yes, thank you, Mr. Speaker. I think that most people on whole recognize that there is a difference in the types of crimes that are committed. And this goes to the member's response to the last question, and that is in regards to crimes that will ultimately lead to a conviction that would have a person have 6 months or more. Now, when we talk 6 months, we're not just talking of jail time. That can be part of conditional sentences and so forth. It's just a summary conviction that ultimately leads to a minimum of six months. We just passed legislation not that long ago that would say that if you're caught with 6 plants of marijuana, that means you go to jail for 6 months. In that particular application, that would mean that if a person was here for many years, as she's pointed out, 10, 15 years plus, even if they have a family, that one individual could actually be deported because they happen to have had 6 plants of marijuana. Now, it's not a rapist or a murderer or something of this nature, but yes, it is a violation because the law says you can't have 6 plants. I'm wondering if she can maybe provide comment in terms of, does she see that as justice being served in that sort of a situation?
The honourable member for Parkdale High Park.
Well, I thank the member for that question, and it is in keeping with what I've been describing here, is that reducing the rule from 2 years to 6 months could capture far too many people in this wide net someone might be a first-time offender, someone who's lived here all their lives, someone who maybe has a mental illness, or someone who just made a terrible mistake and who would benefit from rehabilitation, would benefit from perhaps other opportunities, could then become a productive and positive member of Canada, but because of one stupid mistake, and my colleague has indicated, a crime of growing some marijuana plants could land them in this situation. It seems overly harsh and overly discretionary to have this kind of consequence for that crime.
Resuming debate, the honourable member for St. John's East.
Thank you. Thank you, Mr. Speaker. And I am pleased to have an opportunity to speak today on Bill C-43 because it's a piece of legislation that deserves consideration. But like much that comes from this government, it has significant flaws in it. When we hear the speakers from the other side talk about this bill, when you start asking questions, for example, will they say, don't you want criminals who should get deported to get deported? Well, the answer to that rhetorical question is yes. Nobody's opposed to that. Nobody's opposed to that. That's why we're actually supporting the bill in principle, that there are certain people who come to Canada, who commit violent crimes, who abuse the appeal process, and they manage to stay here for many, many years and ought to be deported. So the answer to the rhetorical question, should criminals who should get deported? Absolutely yes. Is this the way to do it? Are these measures that are there, are they balanced? Are they fair? Are they reasonable? Do they comply with the rule of law? We have a government who claims that throughout the world we're championing the rule of law. Is it reasonable for a rule of law to say that we have such a broad category that says anybody who maybe get a 6-month sentence for a first offense, having been here in this country for 15 or 20 or 25 years, who've been here since they were a child or an infant, should get deported to their so-called home, as I've heard people say? The home of somebody who's been here since 2 years of age and is 25 is Canada. The fact that of the 1.5 million people who are here as permanent residents, who've been granted the right to live here as permanent residents, the right to obtain citizenship once they apply, this is their home. This is their home. So say that the rule of law doesn't apply, they're going to be deported if they, as the member for Winnipeg North talks about, some person who's convicted of having growing six marijuana plants. That person is treated as a serious criminal, subject to deportation to the country of their birth, without any right of appeal. I don't think that complies with the rule of law. In fact, a number of legal people and lawyers who have talked about this and suggested that this is not going to pass muster with the courts. It's going to face a challenge under the Charter of Rights and Freedoms. Bring it on, someone says. Yeah, well, this is what they want to keep the courts busy challenging their legislation. Lawyers have to challenge. You would think that they would desire to have legislation that meets the Charter of Rights and Freedoms, that does the job it's supposed to do. We've had one other member from the opposite side has raised a couple of times another aspect of this, and my colleague from Toronto, not Danforth, Toronto High Park, has quite ably talked about the potential for arbitrary decisions and broad categories. Well, we have broad categories in this Act, and then they bring up specific examples and say, well, don't you agree that this should happen? We had the member for, just trying to find his riding here now. I'm at a little bit of a loss here. I can look on Brampton West. Brampton West, yes. Sorry, I forgot your riding, member, but he says, the people from this party wanted to prohibit the entry of someone who was promoting hatred. And why doesn't they support a measure that does exactly that? The power that does exactly that? Well, it doesn't do exactly that. It says in a very, very broad language that the minister will have the power to deny entry to anyone for 36 months if the minister is of the opinion that it is justified by public policy considerations. So it might have the effect of allowing that particular thing to happen as a part of this broad category. But so if what you want to do is to prevent people who are coming to Canada on a temporary visit to promote hatred, well, then you say that we're going to give the minister the power to prevent people from coming to Canada to promote hatred. So if you want to do exactly that, do exactly that. Public policy is such a broad consideration that a famous legal case in England, they talked about public policy, making decisions in the courts based on public policy considerations, was they call it an unruly horse. In other words, you couldn't control what would be contained under that considerations. So public policy considerations are so broad as to give the minister almost absolute discretion. And that's where we think this bill goes overboard. That's where we think that this bill gives too much discretion, too much arbitrary power in the face of the minister. We want something that's going to be flexible, yes. We want some flexibility, and we want something that's going to work in terms of making sure that people who commit serious crimes and who are unworthy of continuing in Canada, who would never be made, that we would never allow to become a citizen if they applied. We're talking about people, serious criminals who have been convicted of significant offence. If they applied for citizenship, which they're entitled to do as a permanent resident at a certain point, would they be taken into citizenship? The answer to that question is no. They would not be granted citizenship. And do we want to find ways that are going to force people who should be deported to be deported? Yes. If the appeal process is so long and ungainly and unruly that it can't be, that people can abuse it, well, fix the appeal process. Shorten the time limits. Do something about that. Solve the problem at the root of the problem. Don't create a broad, as one of my colleagues talked, you don't need a sledgehammer to swat a fly. If a less restrictive measure, in other words, one that doesn't affect so many other cases that it shouldn't affect, can be used, well, then that's what should be used. Because I think we're talking here, about the unfortunate type of arbitrariness that applies when you use these broad categories. When you take away the requirement of the minister to consider humanitarian considerations and international rights violations, when you take away that right, that removes the possibility of someone who perhaps ought to be allowed to enter this country. It takes away the ability of the minister, or the requirement of the minister actually, to consider that, at least take it into consideration. Says, no, you don't have to worry about that. This is a significant problem. I mean, the risk that's run here is that we're going to be deporting offenders, and they may be offenders who've been sentenced to 6 months in jail or a year in jail, who've arrived in Canada with their parents at a very, very young age, who may know nothing of the country to which they're deported, to which they're suggested to be deported, and that by doing that, you're leaving at risk people whose only country to which they have an attachment is that of Canada, and these are people who may have been in Canada for many, many years. I want to quote to you some of the comments that were made by a group of lawyers in Toronto last week who are active in immigration law. They are very familiar with the kind of cases, the broad range of cases, and they say that we're talking about many people in the African, Caribbean, Italian, Greek, Portuguese, English, Irish, Scottish communities. They haven't acquired Canadian citizenship despite they've been here for a long, long time. And that the removal of appeals to anyone who's been sentenced to more than 6 months is in fact a terrible omission and a terrible burden when someone ought to be considered, these cases ought to be considered. So removing that opportunity is a terrible thing. A first offender who's been here for 15 or 20 years, is incarcerated, they learn things. They improve their life. Some of them may be, you can go to jail for 6 months for shoplifting if you do it often enough, and perhaps you're a drug addict who needs rehabilitation. These people are going to be treated as somehow or other the dross of society and sent to some potential far corner of the world where God knows what will happen to them. This is the kind of thing that we are opposed to. We support the bill in principle in terms of doing what it should do. We want to see it substantially improved in committee.
Questions and comments? The honourable member for, I should remember this, Prince Albert.
Well, thank you, Speaker, and I listened quite interestedly to the NDP's positioning on this, and it's not surprising the NDP have always been soft on crime and soft on criminals and have always ignored victims, and I find it really astounding that now they're going to be soft on foreign criminals also. But you know, Mr. Speaker, the Canadian Association of Chief Police and the Canadian Police Association, Victims of Violence, have all come out in support of this bill. So can he tell me, does he not support these organizations? Does the NDP not support an organization such as these? Do they or don't they?
The honourable member, St. John's East.
Well, I find that the government and members opposite are very selective when it comes to organizations such as he mentioned, you know, because sometimes they support their legislation and sometimes when they don't. When they don't support their legislation, such as the chiefs of police did not support their destruction of the gun registry, they ignore them. They treat them like dirt. They don't want them to come forward. They don't want to hear from them. They say they don't know what they're talking about. So let's leave these associations out of this, and let's talk about the principles here. The principles here are the principles here. This is not about foreign criminals who come to Canada to further their criminal activity, for the most part. If that's what we're talking about, then the law should be able to get them. What they've done here is painted such a broad categories that they're refusing to allow the rule of law, as we understand it, to actually apply to people who've been in this country since they're 2 or 3 years old, whose lives are here, whose families are here, who may have made a mistake and committed a crime, but who deserve the opportunity to be rehabilitated and not subject, because they've been sentenced 6 months in jail, to deportation to a foreign country to them with no knowledge of it, without having even the opportunity of an appeal. That's wrong.
Questions and comments? The honourable member for Winnipeg North.
Yes, Mr. Speaker, I think that if you averaged it out over the last 10, 15 years, you would find that immigration to Canada is somewhere in the neighbourhood of just over 200,000 people coming to Canada, wanting to call Canada their home. In fact, I would suggest to you that you have in excess of 1.5 million people that are permanent residents here in Canada that want to make Canada their home. Is it not fair to believe that a certain percentage will, in fact, fall on the other side of the law? And in extreme cases, yes, there is very strong argument that we want to expedite and get rid of individuals that do commit these violent crimes. And I don't hear anyone necessarily defending that. My question to the member is, in acknowledging that when you have a population base of 1.5 million people, you will have some people that will fall on the other side of the law. If you take a look at what the legislation is going to do, it is saying that any of the 6-month or more, and there's many examples of 6-month or more, that they will not be able to access the appeal mechanisms. And I would like the member just to provide specific comment in terms of the denying of justice for those individuals that I'm making reference to. And again, it's more of the minor type of crimes. He makes reference to shoplifting. It could be other types of crimes if he might want to make reference to.
The honourable member for St. John's East.
Thank you, Mr. Speaker. If you put this bill in the language that somebody wants to put it in, we want to make sure that criminals who should be deported get deported, then I think we can all agree. But I'm not sure that everybody in this House would agree that someone who happens to have spent 20 or 22 of their 25 years in Canada, who may have, for reasons of mental health issues or whatever, run afoul of addictions, have been caught 2 or 3 or 4 times shoplifting, and end up with a sentence of 6 or 9 months, that person should be sent back to Somalia or to some country that they've never been ever since they were 2 years old, with their family here and everybody. I don't think you'll find, in fact, I don't think you'd find a lot of agreement on the other side of the House for that. I think you'd find some human compassion and say, well, this is a particular case. This is a special case that should deserve some consideration. The problem is this bill doesn't give that person any consideration. That gives the judge no discretion, and there's no right of appeal. That's what's wrong with this bill. It just bills one category so broad and says this is for these dangerous criminals. Well, if it's for dangerous criminals, make it for dangerous criminals.
Resuming debate, the honourable member for Portneuf-Jacques-Cartier. Thank you very much, Mr. Speaker. I would like to congratulate my colleague for his eloquent speech, and I'm very pleased today to rise in this debate on Bill C-43, the bill to amend the Immigration and Refugee Protection Act, Faster Removal of Foreign Criminals Act. This bill, if it is passed as such, will result in several legislative changes that has as a goal to remove people to their country of origin faster, whether they're permanent or residents, if they've convicted a crime. So this accelerated process would avoid, in their opinion, some of the abuses of the Canadian legal system for those who attempt to delay their deportation date. One of the main provisions of C-43 provides for the change of the legal definition of serious criminality with the goal of limiting access to the appeal process for certain decisions. Currently, it is possible for a permanent or temporary resident of Canada to appeal such a decision with the Immigration Appeal Division unless they have been sentenced to a prison for 2 years or more. This sentence would automatically revoke the right of the temporary or permanent resident to appeal the decision of inadmissibility. If Bill C-43 is passed, this right will be revoked as soon as the sentence is 6 months or more. So that wouldn't necessarily be given out or meted out for someone committing a serious crime. I think that my colleagues could see that people could have find themselves sentenced to 6 months for much more minor offenses. So it's not necessarily an issue of violent criminals here. These are people who could still be rehabilitated. Bill C-3 also provides for a greater concentration of powers in the hands of the minister by allowing him to decide on the admissibility of temporary residency applicants. This is a very big power of discretionary power rather that the minister would have. The minister could then decide whether a foreigner would be inadmissible for a maximum of 36 months if he considers that it's in the public interest. But there's no definition of that for the moment, so that's a definition that will be formulated in the minister's mind, quite simply, without any further justification. Furthermore, although Bill C-43 specifies that the act of coming into Canada through criminal activity doesn't automatically make a person inadmissible, because there are people who say could be victims of human traffickers. But this bill would take the power of the minister, take away rather the power of the minister to consider the humanitarian circumstances of that person. So the minister would no longer have to consider the grounds of safety or security, for example, or the existence of organized crime in this when deciding whether or not a humanitarian exemption would be granted to an applicant. Bill C-43 concerns an issue that it's at the heart of Canadians' concerns, their security. For us in the NDP, this is also a priority to ensure that the people who live in Canada feel safe and secure. In the NDP, we recognize the need to have an effective criminal justice system in order to be able to deport the real criminals back to their countries of origins when they're not Canadian citizens. We don't agree with the fact that these dangerous criminals should put Canadian safety and security at risk, and that they should be allowed to stay here. These people should be removed as quickly as possible to ensure that our own citizens are safe. At the NDP, we also believe that we can work with the government to prevent any abuses of our appeal system by non-citizens who have committed serious crimes. And for this reason, I will support this bill at second reading. However, in the NDP, we also believe that it's possible to protect the population and avoid these abuses without violating the rights of people who are not Canadian citizens. The NDP is opposed to the idea of refusing all access for people to a fair and equitable appeal process. We are also against the idea that the minister would have the unilateral power to ban someone from being a temporary resident for 36 months if it's in the public interest without our clearly being able to identify what that public interest is. Currently, as they so often do, the Conservatives are trying to concentrate the issue on the debate on the issue of criminality to try and hide their true objectives with C-43, which could really abuse of the rights of a great number of foreigners and permanent residents. For these reasons, they keep saying that we're soft on crimes, and they're saying that we don't care about victims, and that's completely false. We have to be fair if we're going to carry out our work properly in this House. So for the reasons that I set out, the specific reasons, it seems critical that we study each of the provisions of Bill C-43 in committee and reflect on the potential negative circumstances that could result in its application in its current form without any amendments. At committee, it would be possible to shine a light on the problematic main provisions of this bill in order to bring the necessary nuances to it and to ensure that citizens and non-citizens' rights are respected. Another problem in C-43 that warrants further study is the fact that this bill limits the independence of judges by preventing them from taking into account the nature of the crime committed by the temporary or permanent resident. With the C-43, judges would no longer be authorized to consider the fact that certain refugees coming from countries that have been ravaged by war could suffer from mental illnesses. sometimes foreigners who flee wars in their country too often arrive in Canada with severe psychological and physical repercussions caused by the traumatisms that they experienced in their country of origin. Very often these people go untreated and they commit crimes. Whether or not these people are citizens, they need treatment. And with the necessary resources, they frequently can be rehabilitated. So that won't be the case for all foreign criminals that would be intercepted, but it would be the case for many, particularly if they suffer from a mental illness that is the result of traumatic experiences at home. Mr. Michael Bosson, who's a refugee rights lawyer in Ottawa, states that following a crime, these people are integrated in a system that offers them treatment, medication, and rehabilitation programs. They have the support of their families and their community, and they no longer constitute a threat to anyone. Unfortunately, the amendments to the Immigration and Refugee Protection Act risk affecting a high number of temporary and permanent residents who suffer from psychiatric problems, but that we could help. As it is possible to see, Bill C-43 eliminates several checks and balances that currently exist in the legal system and that ensure that we have some flexibility. This flexibility is absolutely necessary when we are confronted with extraordinary circumstances, such as the right of appeal when there's mitigating circumstances, when we need to look at the possibility of considering humanitarian grounds for those who are inadmissible for security reasons, and others. It is clear that we need to look at people's rights, whether they're admissible or not. Rather than demonizing all Canadians because of a handful of criminals, the Conservatives should spend more time and effort on family reunification and the recognition of foreign credentials to allow new arrivals to find work that will take advantage of their experience and talents.
We all want to get tougher on foreigners who commit serious crimes against Canadians, but we can't forget the fundamental values underlying our court system and the fact that even when we're dealing with people who've broken the law. Thank you, Mr. Speaker.
The Honourable Member for Brampton West.
Thank you, Mr. Speaker. I've heard a lot of speeches today from members from this party criticizing the government for this piece of legislation. What they also do, they repeatedly say over and over again, we support getting tough on crime, but we support cracking down on foreign criminals, but there's always a but. There's always a reason. There's always an excuse to say we can't support this legislation. Mr. Speaker, at some point it becomes clear that the protestations actually show that they don't support cracking down on criminals. They don't support cracking down on foreign criminals and having them removed from the country quicker. So my question to the member is, will she and her party just finally admit they don't support cracking down on crime and they don't support faster removal of foreign criminals?
L'Honorable Député de Portneuf.
The Honourable Member for Portneuf-Jacques-Cartier. Thank you, Mr. Speaker. At times we get the feeling that we're speaking to the walls here because I made a very clear speech. I said I would support this bill at second reading because in the NDP we consider it exceedingly important to protect Canadians from criminals, be they foreigners or not. But cracking down on criminals doesn't mean that you have to be pitiless and unable to take any other factors into consideration. We need to show compassion toward everyone and take into account exceptional circumstances, mitigating circumstances that may explain what a person did. The work we attempt to do in the NDP is we're going to attempt to amend this bill and make it more sensitive so that justice can be more effective, more fair in dealing with criminals that need to leave the country quickly, but without stigmatizing all newcomers to Canada.
Member for Winnipeg North.
Yes, Mr. Speaker, this is indeed a very much an anti-immigrant bill. And I think that we need to start using the term anti-immigrant because we have seen other pieces of legislation in which the government has brought forward, and it does target the immigrant community in a negative way. Even in the verbiage that they use, Mr. Speaker, it is anti-immigrant. The bottom line is that the 1.5 million permanent residents that this bill targets, Mr. Speaker, are outstanding, wonderful participants in Canadian society. And we need to acknowledge that fact. The vast, vast majority. And statistically speaking, Mr. Speaker, immigrants commit far less crimes than Canadians on average. And I'm wondering if my colleague will provide comment on that particular fact, that statistically speaking, that immigrants commit far fewer crimes on a percentage basis than Canadians.
The
Honourable Member for Portneuf-Jacques-Cartier. Well, I'd like to thank my colleague for his question. While it's quite clear, as was mentioned, this is a totally anti-immigration bill. We've seen a lot of this from this government. They attempt to victimize and stigmatize for no valid reason newcomers to Canada, unless, of course, they have enough money to boost our economy, of course. But for everyone else, refugees, people who need help, people who come here to try to build a better life for themselves and their children, they're the ones who are affected by this government's bills.
Tries to set up the immigrants to fail. Pretty much that's what they want to do. And this is what we need to change in this bill.
Reprise de débat.
Resuming debate, the Honourable Member for Gaspésie, Île-de-la-Madeleine. Thank you, Mr. Speaker. Thank you, colleagues, for your interest. I'd like to point out that I support referring this bill at second reading so that we can look at it more closely in committee. There's a lot of debate, a lot of questions around this bill. Once again, the Conservatives are proposing a bill that says you have to be tough on crime, that there's a problem, a crime problem in this country, and it needs to be solved. Statistically, it's quite the opposite. There is less and less crime in Canada. So my first question is, what's the point of this bill? What's the purpose? Instead of talking about how to overcome the problems that immigrants face in this country, they say we're going to really deal harshly with crime committed by immigrants. But as my colleague said earlier, the crime rate among immigrants is statistically lower than the crime rate among Canadian citizens. Secondly, the overall crime rate is on a downward trend. So what's the point? What's the public interest that explains the rationale for this bill? I think the public interest is an issue that's very important. It goes to the root of this bill. Once again, we see increasing ministerial discretion, and this is at the expense of public interest. The minister under the bill could, for a maximum of 36 months, declare a foreigner inadmissible based on public policy considerations. Public policy considerations is not even defined, so it's totally at the minister's discretion. We don't understand why the minister should have this increased power when there are already a number of immigration tribunals that can hear immigrants, hear the arguments why an immigrant should or should not be allowed to come to Canada. I think that those tribunals are already enough. The existing procedures are adequate to allow immigrants to make their cases for why they should be allowed to come to Canada. So we already have a system, we have tribunals. We really don't need another bill to further complicate the process for an immigrant attempting to come to Canada. We make it much harder for immigrants. And once again, there's no definition of public policy considerations. Why is so much discretion being left to the minister under this bill? It's really not fair. Virtually all the Conservatives' bills for some time now have shown this tendency to concentrate power in the hands of the minister, to give the minister the discretion instead of relying on our court system. The history of democracy has been to take discretion away from the king and from ministers. In this House, for a year or so now, they've been doing the opposite, and that's not right. A vibrant, vital democracy should circumscribe the powers of government. And here what the government's doing is increasing those powers, broadening them. Ministerial discretion in the area of environmental assessment, the minister now has the power to decide whether or not there will even be an environmental assessment, to decide whether we even need to consider whether there's going to be any environmental impact. Before, it wasn't up to the minister. Now, it's completely up to the minister whether there will be any environmental assessment. Once again, here we're seeing an increase in the minister's discretion, which, in my view, is unacceptable. Once again, this will benefit from debate in committee. So in spite of this increased power, increased discretion for the minister, I still support the idea of this passing second reading and being referred to committee for more in-depth debate. Another serious problem with this bill, in the past and even today under the current legislation, an immigrant who's sentenced to 2 or more years imprisonment will automatically have their permanent resident status revoked. Under this bill, the proposal is it would be reduced to a sentence of 6 months or more. So any permanent resident convicted and sentenced to 6 months or more would lose their permanent resident status. My colleague a few minutes ago on the Conservative side said, we're talking about foreigners here. And why doesn't the opposition support cracking down on foreign criminals? But we're talking about permanent residents here, not foreigners. We know these people, they came here, many of them work, they're vibrant members of our communities, and now we're saying that if they do something wrong and get sentenced to 6 months or more, their permanent residency is automatically revoked, and we kick them out of the country. That's very harsh, extremely harsh. So I'd like that to be discussed further at committee. I think it really deserves further debate. There are many of our criminal offenses that involve sentences of 6 months or more. For example, not paying parking fines. If you don't pay enough of your parking fines, your parking tickets, you could get a sentence of 6 months or more. A person who hasn't paid their parking tickets, is that reason to kick someone out of the country? I think that's a bit much. So this bill really needs to hear from experts. Unfortunately, those who draft conservative legislation have a tendency to go way too far. Perhaps that's the result of a majority government. Maybe they just can't hold back, especially conservatives. They just can't hold themselves back. Only a small percentage of Canadians might support this type of thing. and might maybe people who are willing to contribute funds to the Conservative Party. But this bill absolutely has to reflect Canadian reality. Once again, I'd like to point out that the crime rate in Canada is on a downward trend. I know the Conservatives a few years ago talked about the need to crack down on crime. They said there was a lot of crime that wasn't reported to police. Well, I'm not into witch hunts. I'm into catching real criminals. I think we need to strike the right balance between protecting Canadians and an immigrant's right to due process, to fair and equitable process. That's a fundamental right in the Canadian legal system. Everyone has the right to be heard and to make full answer in defense. And with the ministerial discretion here, which is being increased with this bill, it seems to me that that discretion is getting to be more and more like the powers of a monarch. This runs completely counter to legal trends in Canada and Commonwealth countries, the right to be heard, to make full answer in defense. This is a fundamental right that's being violated by this bill. So this bill must absolutely go to committee for a full airing, a full hearing, and I hope everyone will keep an open mind to the advisability of amending this bill. Having listened to expert witnesses, this bill absolutely has to be debated and fully thought through so that we can truly, at the end of the day, come up with a bill that's beneficial to Canadians, and so that immigrants will feel that Canada is a country that welcomes them with open arms. In historical terms, Canada's always been very open to immigrants, and I don't want that to change. Thank you, Mr. Speaker.
Order, please. Questions and comments. The honourable member for Crowfoot.
Thank you, Mr. Speaker, and I listened with great intent to the member who gave that speech, and I guess I'm disappointed by much of what I'm hearing. I hear on one hand they're going to vote for it, to move it to committee, but everything about it is disliked. The other thing that bothers me and troubles me is some of the questions coming from the Liberals, the Winnipeg North member, who says this is an anti-immigrant bill. Nothing could be further from the truth, Mr. Speaker. This deals with the criminal element. People like I'm looking at one guy's name, Jehardhan Balagmadarian from Sri Lanka, assault with a weapon, drug possession, drug trafficking, 18 months in jail. The removal order was in 2001. He went into an appeal process, and 7 years later, he's finally removed. Mr. Speaker, we understand the importance of immigrants. We understand the great contribution to Canada. But the very small percentage that comes and commits fraud, sexual assault, another one from Romania, forgery. Mr. Speaker, they're here. They should be on their best behavior. This gives us the opportunity to send these people back to their place of...
The honourable member for Gaspésie, Île-de-la-Madeleine.
Member's interest in criminal matters, and I certainly hope that he's going to present a lot of amendments to this bill and all the other crime bills that this government brings forward, because they can all benefit from more debate at second reading. And frankly, when bills go too far, that's exactly why we're here, to make sure that bills address the real problems of this country and not fabricated ones that the Conservatives keep throwing at us.
Questions and comments. The honourable member for Winnipeg North.
Thank you, Mr. Speaker, and I can tell you that this is indeed an anti-immigrant bill, and the government needs to wake up and recognize that fact, Mr. Speaker, because the 1.5 million plus permanent residents here in Canada today deserve better. And quite frankly, Mr. Speaker, the average immigrant, and if you take a look at the amount of crime that's being committed in Canada, the average immigrant is far less than the average citizen of Canada, yet this government has prioritized labeling by calling them foreigners. You don't hear the Minister of Immigration going out calling permanent residents, you bunch of foreigners. No, but he's prepared to label, Mr. Speaker, in legislation in order to
highlight very much an anti-immigrant bill. My question to the member is, would he not agree that this is indeed, as worded, an anti-immigrant bill?
Good question.
The honourable member for Gaspé, Ile de Madeleine.
I have a hard time believing the Conservatives actually believe in welcoming all immigrants to this country. They seem to have a lot of reserve for an awful lot of them. So in some senses, I totally agree with them. And I hope the member from Winnipeg is going to be as full of vim and vigor through question period. Thank you.
Order. Time for government orders has expired. Statements by members. The honourable member for London West.
Mr. Speaker, those old enough will remember exactly where they were 40 years ago when Paul Henderson scored that iconic goal for Team Canada to give them the game victory and the series against the Russians. Who can ever forget Phil Esposito halfway through the series with our team struggling, putting his team and our country on his back as he challenged Canadians to get behind Team Canada. Today, who can forget Londoner Vito Frisia for his extraordinary generosity and pride of Canada by single-handedly bringing Team Canada back together so we could honour them for their contribution to Canadian sport, Canadian spirit, and Canadian pride. This special team of national heroes came together in Toronto last week to be celebrated and honoured. To see Phil and Tony Esposito, Frank and Pete Mahovlich, Brad Park, Ken Dryden, Bobby Orr, Yvonne Cornwallis, and of course Paul Henderson, to name just some of those superstars, was inspiring. The Prime Minister and I were there, and it's something special when you can say thanks and job well done to your hockey heroes for the memories and pride they instilled in us. Hear, hear. And to Vito Frisia, were it not for you, this would not have happened. You have our sincerest thanks and job well done.
Hear, hear.
The honourable member for Surrey North.
Thank you, Mr. Speaker. This government is in denial about a problem that is affecting unemployed Canadians across this country. Right now, there are approximately 870,000 unemployed Canadians with no EI compensation. This means fewer than half of all unemployed Canadians are receiving EI. People come into my office frustrated from trying to navigate their way through a system that has been crippled by conservative cuts. One man has been waiting for over 2 months for his EI check. On his last box of macaroni and cheese, he had to go to the food bank for the first time in his life, when he should have been receiving the EI he had been paying into for over a decade. New Democrats are fighting for an EI system that's fair, accessible, and effective. Mr. Speaker, it is time for this government to wake up, do something to help unemployed people in this country, and fix the unemployment insurance system.
The honourable member for Kitchener-Waterloo.
Mr. Speaker, I rise today to highlight the Oktoberfest celebration that begins tomorrow in Waterloo Region. Our region benefits greatly from strong German-Canadian roots, and Kitchener, previously known as Berlin, celebrates its 100th anniversary this year. German Canadians were pioneers in the founding of Kitchener-Waterloo and played a significant role in shaping the economic, social, and cultural fabric of our community. We're also proud to host the largest Oktoberfest outside of Germany, which both increases tourism and provides over $1.5 million for local charities. I invite all Canadians to visit Kitchener-Waterloo for this exciting festival to celebrate German history and heritage and share in the traditional food, music, and entertainment. And I know all members of the House will join me in thanking German Canadians for their ongoing contributions to Canadian society. Prost.
The honourable member for Random Burn, St. George's.
Mr. Speaker, I rise today to pay tribute to a young woman from Grand Bank in my riding of Random Burn, St. George's. When Samantha Strubbridge graduated from the Nautical Science program at the Marine Institute in St. John's, Newfoundland, she was awarded that institution's bronze medal in recognition of attaining the highest overall average in the final year of the program. Samantha also won the Governor-General's Award, given to the student who attains the highest academic standing for all diploma-level programs. Her time spent with the local Sea Cadet Corps, RCSCC 71 Atlantic, was instrumental in developing her interest in nautical science and in developing many of the attributes that are helping her succeed in her chosen field. Samantha is a prime example of a new generation of women who are entering fields once dominated by their male counterparts. Undoubtedly, she will have a successful career on the sea, where she aspires to become a master mariner and ultimately captain her own ship. Mr. Speaker, I ask all members to join me in congratulating Samantha Strubbridge and wishing her every success as she continues to build on her accomplishments.
The honourable member for Sarnia-Lambton.
With Thanksgiving weekend almost here, families from across Sarnia-Lambton will make their way to the Brigden Fair, a popular event celebrating 162 years in 2012. The first fair was held in 1850 by the early area settlers on Riley's Farm in Moore Township, today known as St. Clair Township. The fair initially moved from one community to another throughout the township until finally settling in Brigden. The Brigden Fair has become a popular destination on Thanksgiving weekend for those who wish to enjoy some quality time with their friends and family. This year, the opening ceremonies will take place on Friday, October the 5th, with the parade following on Saturday. Admission is free for elementary school-age children, and there will be a variety of entertaining events, including midway attractions, monster truck and helicopter rides, and of course many 4-H events and arts and crafts galore. Congratulations to all the volunteers who make it possible for urban to meet rural. Happy Thanksgiving to all.
Here, here.
The Honourable Member for Gatineau. This month, residents of Gatineau are celebrating the anniversaries of 3 organizations that have made their mark in my riding. First, the St. René Seniors Club, presided by Ms. Lillian Charette, is celebrating its 25th anniversary. Each month, the club organizes games and activities that are very popular with seniors. I have had the privilege to see this regularly. Finally, Entraide Familiale de l'Outaouais is also celebrating 30 years of existence, headed by Diane Tremblay. I greatly admire her. This outstanding organization works tirelessly with people in need and changes lives every day by meeting the needs of the most vulnerable people. Finally, the Gatineau Senior Centre is celebrating its 35th anniversary. Its active and determined team breaks the isolation of seniors by encouraging their autonomy and creativity with arts, well-being, language, and recreational programs. I salute all of these people for their dedication and their passion. These groups are dedicated to helping others in the heart and soul and lungs of life and community in Gatineau. I'm proud to represent them here in the House and to work in partnership with them. Thank you to all of you.
The Honourable Member for Oakville.
Mr. Speaker, I rise today to congratulate Ken Luenza, President of the Canadian Auto Workers Union, his team, CAW members, and negotiators at Ford, GM, and Chrysler for negotiating and ratifying groundbreaking competitive agreements. These agreements will help position the Canadian auto industry to thrive and grow for many years. For the CAW leaders, this trifecta was a long and grueling process that will add hundreds of new, high-quality auto manufacturing jobs in Canada, including 600 in the great town of Oakville, helping to reinvigorate Ontario's ailing manufacturing sector.
Here, here.
Our Conservative government did the exact right thing back in the dark days of December 2008, investing in the Canadian auto industry, and its recovery is complete with spin-offs for a total of 500,000 jobs across Canada. Wow. We celebrate this groundbreaking agreement, which will help ensure that the Canadian auto industry continues to contribute to a superior quality of life for all Canadians.
That's great.
The Honourable Member for Kitchener-Conestoga.
Mr. Speaker, I rise to salute the work being done in the field of mental health and to call attention to the work that remains. This year, the Mental Health Commission of Canada released a groundbreaking report, Changing Direction, Changing Lives, which outlined a mental health strategy for this country. As well, this House overwhelmingly passed legislation on suicide prevention, and I remain grateful for the quality of that discussion. We are making progress in our recognition of mental illness and in our society, but more needs to be done. As individuals, we can and must foster positive mental health in our families and communities. The easiest and most important thing we can do is simply to talk about it. Canadians should not rest until everyone is as comfortable discussing schizophrenia as they are spinal issues, as comfortable discussing depression as diabetes. I want to thank the Canadian Alliance on Mental Illness and Mental Health for coordinating National Mental Illness Awareness Week, for giving Canadians another opportunity to break the stigma surrounding mental health and to talk about these important issues. Thank you, Mr. Speaker.
The Honourable Member for Nanaimo, Cowichan.
Mr. Speaker, derelict vessels are a concern for coastal communities around Canada. As both our commercial and recreational fleets age, this problem will only grow. This summer, there were problems in the Fraser River with the Queen of Sydney ferry, the cleanup of the MV Minor off Nova Scotia, and another barge sinking in Chemainus. There is a legislative vacuum around derelict vessels with nobody taking responsibility unless there is a hazard to navigation or an imminent environmental damage. That's why I brought forward my private member's bill on derelict vessels, Bill C-231, an act to amend the Canada Shipping Act. The bill ensures that regulations are made to establish measures for the removal, disposition, or destruction of derelict vessels or wrecks. It provides that the Canadian Coast Guard shall be designated as receiver of wrecks and requires them to take reasonable steps to locate the owners of the wreck. In Canada, many different agencies and governments are responsible for navigable waters and dealing with hazards. So it is important to clearly lay out which agency will deal with wrecks and derelicts. Last week, the Union of BC Municipalities passed a motion calling for an immediate removal program to deal with derelicts. I encourage the Minister to use my bill as a template to deal with this urgent matter.
The Honourable Member for South Shore St. Margaret's.
Mr. Speaker, today is the 25th anniversary of the Canada-U.S. Free Trade Agreement. Since the FTA came into force in 1989, Canada's annual GDP has risen by $1.1 trillion. Nearly 4.6 million jobs have been created in Canada, and two-way trade with the United States in goods and services has more than tripled. Canadians may remember that the ideological anti-trade, anti-development NDP actually opposed free trade with the United States. The NDP were on the fringes of economic policy 25 years ago, and they remain on the fringes of Canadian economic policy today. Mr. Speaker, it was a Conservative government led by Brian Mulroney that brought in free trade 25 years ago. It is a Conservative government today, under our Prime Minister, that continues to create jobs, economic growth, and long-term prosperity through trade. While the NDP are guided by their out-of-the-mainstream ideological doctrine, our Conservative government will continue to act in the best interest of Canadians.
The Honourable Member for Scarborough Rouge River.
Thank you, Mr. Speaker. The United Nations declared this October 11th the first International Day of the Girl, and I'm honoured to stand here to recognize this day and its importance for girls and young women in Canada and around the world. Too often, the power of girls and young women is overlooked and underestimated. However, their strength should not be questioned. I've seen firsthand what powerful voices girls and young women have. They're energetic, empathetic to the struggles of others, and change makers in their families and communities. However, on this day, we must recognize that gender and age inequalities and discrimination still exist in Canada and around the world. Girls and young women are more likely to suffer from depression, sexual harassment, malnutrition, early marriage, denial of education, violence, intimidation, and trafficking. This International Day is a reminder to no longer undervalue the power of girls and young women, and for us as parliamentarians and members of a global community to work together in defense of human rights and equality for all. Today, I stand with my colleagues to pay tribute to the girls in our lives, the girls of our great nation, and the girls across the globe.
Bravo.
The Honourable Member for Peace River.
Thank you, Mr. Speaker. The brutal and repressive regime of Bashar al-Assad continues to show its disregard for human life following yesterday's attack across Turkey's border, which left 5 people dead, including a 6-year-old child. Canada strongly condemns this attack, and we offer sincere condolences to those who are affected. As the Minister of Foreign Affairs stated yesterday, we continue to stand with Turkey and our other regional partners. The statement from NATO allies speaks for itself. Over the past year, our government has introduced some of the strongest sanctions on Syria in the world, and we continue to call on all countries to bring pressure to bear on Syria for Assad to go. We will continue to work with our international partners to isolate this dangerous and murderous regime and to end the bloodshed of its own people and its neighbours. Mr. Speaker, the Syrian people deserve better than this illegitimate regime. Canada will continue to champion the freedom and human rights of all Syrians.
The Honourable Member for York West.
Thank you, Mr. Speaker. Today, on this National Day of Remembrance, I stood on the steps of Parliament to remember and honour the lives of more than 600 missing and murdered Aboriginal women and girls. I extended our support to families who have been touched by the violent loss of a loved one and called for justice for those affected by this tragedy. Aboriginal women experience rates of violence more than 3 times that of non-Aboriginal women. Young Aboriginal women are 5 times more likely to die violently. The issue of missing and murdered Aboriginal women and girls is of critical importance, and it is time for us to seek justice for the victims and healing for their families. We must put an end to this epidemic. Today I ask all parliamentarians to press for action, establishing a public inquiry on missing and murdered Aboriginal women and girls and developing and implementing a plan to stop this violence are important steps that can't wait. Violence against Aboriginal women and girls is unacceptable, as is any violence against women. We can and must do more as parliamentarians. Thank you.
The honourable member for Brant.
Mr. Speaker, when running for his party's leadership in 2011, the NDP leader promised a carbon tax that will go even further than the NDP's 2011 election platform. The NDP leader's plan would apply a carbon tax to all major sources of GHG emissions, not just the 700 largest industrial emitters envisaged in the NDP 2000 election platform.
That's what he said.
In explaining his reason for expanding the scope of the NDP carbon tax, the NDP leader said Canada can no longer afford to focus only on the worst of the worst. That means even more money taken from Canadian families than the $21 billion the NDP is banking on. The NDP leader opposite can deny it all he wants, but his words are clear. The NDP will hit Canadians with a job-killing carbon tax that will drive up the cost of gas, groceries, and electricity.
For Beaches, East York.
Mr. Speaker, whether it's making up policies or fantasies about commies hiding under their beds, Conservative backbenchers can be counted on for a daily fix of fact-free statements and a trip to the Twilight Zone. Let's review, Mr. Speaker. Since the E. coli crisis began, the NDP have asked 33 questions about tainted meat. Conservatives, not one. What are they talking about, Mr. Speaker? The economy, health care? No. Conservatives have made 32 statements and asked 10 questions about us, the NDP. 1 out of every 4 Conservative questions. So to my colleagues across the way, I ask, is this really what you wanted to do with your life in elected office, indulging the fantasy life of the kids in the PMO? And to the member about to rise, tell us, please, what's going on in your riding? Tell us, please, what do you want to do for Canadians? Take Parliament seriously, we urge you, so Canadians can start taking you seriously.
The honourable member for Calgary North Centre.
Speaker, the NDP leader advocates for an aggressive carbon pricing scheme for the purpose of generating billions of dollars in new revenue. I'd like to remind the NDP leader of a principle that his party fails to acknowledge, that government revenue comes from Canadians, from hardworking families, and from our job-creating companies. And any increase in government revenue, or simply put a tax, has an impact on our constituents' lives and livelihoods. While our Prime Minister's leadership has positioned Canada as one of the best places in the world to do business and one of the strongest job-creating economies, the NDP leader seeks to disadvantage Canadian businesses through an unaligned carbon pricing scheme designed to grab revenue to fuel his plans for government expansion. So, Mr. Speaker, on behalf of my constituents, to the member from Outremont, any way you slice it, a $21 billion revenue grab does have a cost, and as I'm sure they'll remind him in 2015, Canadians are not keen to have NDP hands in their pockets.
Oral questions. Questions orales. The honourable leader of the opposition.
Is the Minister of Agriculture willing to accept responsibility for the self-regulating food inspection system he put in place?
The Honourable Minister of Agriculture.
Of course, Mr. Speaker, there is no such system. The CFAA operates on a professional level on a program called CVS, which was implemented in 2005.
L'honorable chef de l'opposition.
Honourable Leader of the Opposition.
Head of the Canada Food Inspection Agency told reporters that key E. coli testing data had been withheld from government food inspectors by XL Foods. The Minister of Agriculture knew that food safety data was being withheld. He knew that there were unsafe conditions at XL Foods. Why did the Minister of Agriculture withhold that information and endanger the lives of Canadians?
The Honourable Minister Minister of Agriculture.
Mr. Speaker, when the first sign of E. coli showed up on September 4th, CFIA took that seriously. They recaptured that product. They brought it back to the facility. They destroyed it. None of it got into the retail system, Mr. Speaker. Having said that, they began operations on September the 4th. They've been operating every day since. I've been meeting with them on a daily basis to ensure they have the capacity and make sure that they're doing everything they can to ensure Canadian food safety.
The Honourable Leader of the Opposition. The government knew that some XL Food equipment was damaged and not working. The government knew that XL Foods did not have a system in place to find and trace the E. coli bacteria. And the Minister of Agriculture knew that even after the E. coli alert was issued by the American government, XL Foods continued to hide vital information on the safety standards of their facilities. Why did the Minister of Agriculture hide this information on tainted beef? The Honourable Minister of Agriculture.
He'd find a full timeline from September the 4th on, day by day, and exactly what they did and how they did it. What he'll find is a robust system that sought to make sure that Canadian food is safe. We worked together with Public Health Canada, the public health agencies in the provinces, to ensure that we did not have a major problem at that point, Mr. Speaker. As the information became available, we changed our tactics. That's the way the system works, Mr. Speaker.
The Honourable Leader of the Opposition.
The Director of Meat Inspectors admitted that up to 5% of the meat processed by XL Foods was contaminated with E. coli. If Canada had real rules, all of the meat processed during those days where the threshold was surpassed would have been destroyed. But thanks to the Minister of Agriculture, no such rule exists. It's up to the industry to decide what to do. Even worse, the population was not informed of the dangers of this tainted meat. This is a serious breach of ethics and of ministerial responsibility. The Minister of Agriculture has no choice. He should resign. The Honourable Minister of Agriculture.
Speaker, what the member opposite fails to recognize is that the OECD, an international body, has ranked Canada's food safety system right up there at the top. Every other country that we deal with, including Japan with a robust food safety system, looks to emulate ours. We'll continue to do the job, Mr. Speaker. We'll enhance what CFIA has, the rules and regulations that they will work within, the dollars that they will have to hire more inspectors. I'm hopeful that the NDP will support us in those initiatives.
The Honourable Leader of the Opposition.
Key safety equipment damaged and inoperable. No clear testing standards. No monitoring system for tracking high rates of E. coli. Withholding key food safety data. All of this just 4 years after the same Minister of Agriculture presided over another tainted meat scandal that killed 22 Canadians, and he made jokes about it. This time the Minister of Agriculture knew what was going on. He withheld what he knew from Canadians, and he's refusing to be accountable. He's the one who put this self-regulating system in place. He is responsible. Why is this Minister of Agriculture still in his position? He must resign.
The Honourable Minister of Agriculture.
Of course, Mr. Speaker, there's no such thing as a self-regulating system in Canada. CFIA has a number of different jobs that they perform in these plants every day. The particular plant in question has 46 professional CFIA staff, Mr. Speaker. That's a 20% increase over just a few years ago. We take this very seriously, Mr. Speaker. We're working to ensure that CFIA has the regulations that they require and the monetary capacity to get the job done. I'm hopeful that they will work with us in the future.
For Toronto Centre.
Mr. Speaker, I have the timeline that the Minister has referred to, and I'd like him to think back. Since he says he was meeting with the staff on a daily basis, I assume that means he was meeting with the staff on a daily basis after the initial findings of E. coli on September the 4th. On September 10th and 11th, we're told in the timeline that the CFIA identified August 24th, August 28th, and September the 5th as of interest for further investigation. Did that have to do with extraordinary or high levels of E. coli with respect to those particular dates? And can the minister tell us when he himself was informed with respect to those findings on those dates?
Yeah. The Honourable Minister of Agriculture.
Mr. Speaker, my office was fully engaged on September the 5th as CFIA had identified the initial batch of contaminated product both in a secondary facility in Calgary and, of course, at the border by the United States. That product was captured and brought back in. As we strove to work on further, we work with scientific evidence, we work with information that we have available to us to make sure that Canadian consumers are not at risk.
The Honourable Member for Toronto Centre.
Well, Minister, these are troubling facts that the minister, in fact, and the CFIA itself is disclosing. On September the 13th, according to the timeline, the minister himself have said it, is that's the date upon which the CFIA removed XL Foods. That's on the 16th, but on the 13th, the Americans removed XL Foods from the list of establishments eligible to export to the United States. Canada did not take the step of closing the plant until September the 27th. There were recalls on September the 16th and recalls again on September.
Order. The Honourable Minister of Agriculture.
Well, as the member opposite rightly points out, Mr. Speaker, CFIA was acting on the information that they had. They did issue a recall on September the 16th on some potentially dangerous hamburger product, the higher risk product, and that's what they do, Mr. Speaker. They work on scientific evidence. They work on a growing body of evidence to make sure that Canadians are well served by their food safety system.
The Honourable Member for Toronto Centre.
But even Mr. Arsenault, who is the head of the union for the meat part, said that we are not going to pretend that we could have repaired everything.
That's the statement of Mr. Arsenault from the division of meat. I'd like to ask the minister. Americans were protected on September the 13th because no product was allowed to be exported in the United States. All Canadian consumers were not protected until September the 27th, 2 weeks later. Why were Americans better protected than Canadians, Mr. Speaker?
The Honourable Minister of Agriculture.
Of course, I fundamentally disagree with that statement, Mr. Speaker. The member opposite also the other day said that the American E. coli statistics were far more robust than Canada's. Theirs had gone down by some 40%. Canada, in that same time frame, Mr. Speaker, the E. coli incidence went down by 69%, and 2012 is going further in that good, positive way, Mr. Speaker. We'll take no lessons from the Liberals.
The Honourable Member for Welland.
Mr. Speaker, while the minister bragged about what a great job everyone's been doing, yesterday Canadians learned the truth about how slow the process truly is. On September the 6th, CFIA requested critical distribution and testing information from XL Foods. In return, XL took 5 days to respond. This is an unacceptable delay in the chain of information. Mr. Speaker, the minister can't keep running from the question. Why does this minister think that a 5-day lag in the transfer of critical information is acceptable?
The Honourable Minister of Agriculture.
Well, Mr. Speaker, we absolutely agree a 5-day lag is unacceptable. That's why we tabled Bill S11, the Safe Food for Canadians Act, last spring. It gives us more robust powers, a more timely way to assess that paperwork, Mr. Speaker, and we'll continue to move forward in that vein. I'm hopeful that the NDP, I know that bill will be here very, very soon. The Senate went through clause by clause this morning. That bill will be before them very soon. Let's get it passed, Mr. Speaker.
The Honourable Member for Welland.
And I assume that's why he tabled it in the other place instead of here. But on September the 13th, CFIA stopped XL production to U.S. consumers. Yet our agriculture minister didn't shut down Canadian production until September the 27th, 2 weeks later. This massive delay has undermined the public's confidence in Canada's food safety. When consumer confidence fails, it's producers who pay the price. Why did this minister stop XL beef going to U.S. consumers, yet allowed the same plant to ship beef to Canadian families?
The Honourable Minister of Agriculture.
Of course, Mr. Speaker, the member opposite is sort of cherry-picking the timeline. What he will see if he reads it properly is a growing body of evidence that CFIA gathers on a scientific basis. These aren't political decisions, Mr. Speaker. These are decisions made by the professional staff at CFIA. They build a body of evidence. They put out health hazard warnings. They started a recall on hamburger on September the 16th, Mr. Speaker, and they stand by the work that they've done.
There you go.
Not having an update.
The honourable member for Berthier-Masquinongé. Mr. Speaker, on September the 3rd, a shipment of meat from XL Foods was stopped at the American border because of E. coli contamination, and yet the Canadian Food Inspection Agency did not ask the business for the necessary information on the slaughter before September 6th. 72 unnecessary hours of exposure to contamination for consumers. Can the minister tell us why the agency took 3 days to react? The Honourable Minister of Agriculture.
Mr. Speaker, the United States notified Canada on September the 4th, the very same day that we found product in another plant in Calgary. It turned out to be from the same batch. We contained that batch. That batch has been destroyed, Mr. Speaker. Then we began to trace down where we needed to go from there. In that next day time frame, of course, CFIA was in the plant looking for a cause of E. coli. They have to work on scientific evidence. They start to amass the information as it becomes available to them. They asked for documentation from the plant on the 6th to highlight certain issues that they thought might be a problem, and it took the plant some days to get it to them. Bill S-11 will get us beyond that particular timeline, Mr. Speaker, and shorten it down. We need that bill.
The honourable member for Berthier-Masquinongé. Too little, too late. Refusing to assume responsibility for this crisis is not reassuring for consumers or farmers who are worried about the future of their industry. For 3 long days, inspectors from the CFIA did not know what they were looking for. The Conservatives are responsible for having left Canadians in the dark and for having put the public safety at risk. But no one on the other side accepts to be accountable for this fiasco. Mr. Speaker, the minister did not warn consumers from the start. Why not? The Honourable Minister of Agriculture.
Food safety is job number 1 for this government, Mr. Speaker, and it's a priority for CFIA. That's their entire mandate. So we continue to build a robust food safety system. We add dollars, we add inspectors, and we continue to do that to make sure they have the ability to do the job they want. I'm hopeful that the NDP will finally start to work with us and start to pass some of these initiatives that we're putting forward.
Honourable member for Gaspésie, Île de la Madeleine. The minister acts as if there is no crisis. 2 days ago even, he said, follow my example, eat beef. But during this time, producers and consumers are worried. The Canadian Food Inspection Agency asked for corrective measures on the 5th of September. At home in the Magdalen Islands, people have just learned yesterday that tainted meat was sold to them. This is unacceptable. These delays are due to a shortage of frontline inspectors. Why did the agency not react more quickly to this crisis? The Honourable Minister of Agriculture.
On the issue of inspectors, Mr. Speaker, the plant in question has 46 professional CFIA staff on site on a daily basis. These people are doing a tremendous job working through difficult situations. They continue to assess what went wrong. They're building a body of evidence. A recall is just that, Mr. Speaker. It's a notice to the public that there is a possibility of a problem. Please take that seriously. People that have product in their fridges and their freezers, go on the website, check the barcodes, make sure that you're not putting yourself in harm's way.
The honourable member for Nickel Belt.
Ontario farmers are concerned about the impact this massive recall will have on prices. Northern Ontario consumers are worried about the safety of their food. But instead of protecting the safety of Canadians, this minister failed to act on glaring deficiencies in the safe food inspection system. Why did the minister allow XL Food to process beef on August 23rd, 24th, 27th, 28th, and 29th with broken rinse nozzles and an incomplete E. coli tracking system?
The Honourable Minister of Agriculture.
Well, of course, Mr. Speaker, the member opposite should go back to the timeline and see the assessment that was done by CFIA based on science, based on a growing body of evidence, that there were some anomalies on the days that he mentioned. At that time, we continued to amass that information. We have since gone out with recall notices on those days in question because of the anomalies that were noticed.
The honourable member for Edmonton Strathcona.
Mr. Speaker, Canadians are just discovering how widespread this meat recall is. Yet Conservatives only now admit to gaping holes in the rules regulating XL Foods. Still, they persist in saying all is well with the food safety regime, deny responsibility for the E. coli breakout, and when all else fails, blame the CFIA. The crux of this problem is that the compliance verification system is broken. When will this government come clean about the perils of self-regulation and commit to an enforceable compliance regime for the food industry?
Question. The Honourable Minister of Agriculture.
First, the system we have, Mr. Speaker, is robust. It's been adjudicated by a number of bodies around the world, third parties that say we have a good system in this country. We continue to enhance that system. Bill S11 will give us more powers in a more proactive way, a quicker way to bring that product or that information we need to bear as we face situations like this. We continue to build the capacity of CFIA to do their work, Mr. Speaker. I'm hopeful that the NDP, with their new epiphany, will join us in that endeavour.
The honourable member for Parkdale High Park.
The minister is hiding behind the head of the agency in order to sidestep responsibility. Over the last 6 years, the budget allocated to food security has decreased by $40 million, an amount that will continue to decrease until 2015. In the report on plans and priorities, there is no clear increase of food safety staff, despite what the minister claims. Why are the Conservatives inventing stories that are invalidated by their very own documents? The Honourable Minister of Agriculture.
Mr. Speaker, it's very easy to validate. Going back in budgets up until this point, we've increased CFIA's budgetary capacity by some 20%, and we've added 700 net new inspectors to their role, 170 of them dedicated to meat lines.
The Honourable Member for Parkdale High Park.
Speaker, Conservative claims about their spending are simply not supported by the facts.
Hear, hear.
They're denying their own financial documents, but Conservatives like to hide the facts. When the Parliamentary Budget Officer asked about the impact of Conservative cuts on food safety, CFIA said they either didn't know or couldn't say. Why are they denying their own financial statements, and why are they hiding the facts from Canadians?
Hear, hear.
The Honourable Minister of Agriculture.
Of course, Mr. Speaker, there are no cuts to food safety. We've said that often in this place. Somehow the NDP don't seem to be able to add the numbers up in the budgetary process and figure that out. The Parliamentary Budgetary Officer tabled a report. Those are incomplete numbers, Mr. Speaker. He should know that some of those programs sunset and will be picked up again in the next suite of farm programs.
The Honourable Member for Westmount Ville-Marie.
Mr. Speaker, when the E. coli crisis erupted, this is what the government did. First, they said there's no problem. Secondly, they said there are enough inspectors. Third, they said they blame everyone but themselves. This is evasion. These are evasions and excuses. This is what Canadians wanted to hear from a responsible government. Yes, we have a serious problem. Yes, we are going to deal with the problem immediately. And thirdly, yes, the safety of consumers is our first priority, our top priority. When is this government going to act like grown-ups and be responsible? The Honourable Minister of Agriculture.
Mr. Speaker, we constantly say how seriously we take food safety by enhancing the capability of CFIA to do their job. We add dollars, we add human resources to their staff to make sure that they have the ability to do it. I'm not sure where the member's been.
The Honourable Member for Guelph.
Mr. Speaker, there's not a single group in Canada left untouched by the horrible lapse in food safety at XL. Canadians are worried about tainted meat. Cattle producers just getting off their knees from BSC are worried about selling their safe cattle. Dr. Richard Arsenault, CFIA Director of Meat, has said, "We're not going to pretend we got it right." People are sick from E. coli, yet this government continues to pretend nothing's wrong. How many people must get sick before the minister will reverse cuts to CFIA funding and give them the resources they need to keep our food safe?
The Honourable Minister of Agriculture.
Well, again, Mr. Speaker, there are no cuts to the food safety system in CFIA. We continue to enhance the capacity of CFIA from both a budgetary and a human resources perspective to get that job done, to make sure that they have the ability to capture any type of product like you see here. We built a body of evidence in our timeline, and we're looking forward to more recalls coming out, Mr. Speaker. It's the nature of the beast. As things swell out, we're going to make sure that Canadians are well served by a robust recall system.
The Honourable Member for Malpeque.
Mr. Speaker, to the Prime Minister who promised to hold ministers accountable. First, we have the Minister of Agriculture who failed to fully implement the Weatherall report after 23 people died. And now the same minister presides over the biggest beef recall ever, when in fact CFIA did have the authority to act under current law. Yes, and right. Second, we have the Minister of Health who has a responsibility to reassure the public, lay out a plan on such public health matters, and has gone into lockdown. When will the Prime Minister put a stop to this incompetence and protect Canadians' food supply? Yeah.
The Honourable Minister of Agriculture.
Yes. Well, I thank the member opposite for the question, Mr. Speaker. He's absolutely right. This government has job number one is food safety. That's a priority for us. We continue to enhance CFIA to give them the tools they need to work. One of the tools that they're working with quite successfully, Mr. Speaker, is the CVS equivalent program that was brought into play by his government in 2005. I'm not sure why he has a problem with it now, Mr. Speaker.
Member for Nanaimo, Cowichan.
Mr. Speaker, yesterday First Nations chiefs from across the country voted to reject this government's unilateral decisions on education. Not a single penny of the education funding announced this week goes to schools on reserve, where the need is greatest. Chiefs are threatening civil disobedience to force this government to deal with a crisis in First Nations education. Will the minister admit that unilateral decision-making is wrong and commit to investments that actually help First Nations students on reserve?
And the Honourable Minister of Aboriginal Affairs.
Mr. Speaker, that's exactly what we've been doing. I met with the National Chief last week, and I'll meet with him again today to reaffirm our commitment to develop legislation through intensive consultations with First Nations across the country. We already have existing comprehensive First Nation education agreements in Nova Scotia and in British Columbia, which demonstrate improved student outcomes. We are committed to improving educational outcomes for First Nation students across the country. Thank you, Mr. Speaker.
The Honourable Member for Joliette. The First Nations communities have an urgent need for adequate education services for their youth, but the Conservatives are only giving them peanuts. The communities have been waiting for over 10 years for new schools, and only 3 will be built this year. Children of the Atikamekw Nation in Manawan in my riding should not be deprived of education, no more so than any other Canadian child. Mr. Speaker, when will the minister act instead of making empty promises? The Honourable Minister for Aboriginal Affairs.
Many commitments on First Nation education. We made commitments in the Economic Action Plan 2012. I made announcements yesterday that included many more schools than the 3 that were mentioned by my colleague across the way. We've completed construction on 33 new schools since 2006. We've done over 240 upgrades of schools, additions to schools since 2006, and we are continuing with those kinds of investments, Mr. Speaker.
The Honourable Member for Churchill.
Mr. Speaker, Manitoba is hosting a National Aboriginal Women's Summit focusing on violence against Aboriginal women. Yet despite the federal government previously co-hosting such summits, this year they are nowhere to be found. This crisis will not be solved without federal leadership. Today, on the National Day of Action and Remembrance for Missing and Murdered Aboriginal Women, families and communities want to know, when will this government recognize the national scope of this tragedy? Why will they not work with Manitoba? And when will they call for a national inquiry into missing and murdered Aboriginal women in Canada?
The Honourable Parliamentary Secretary.
Mr. Speaker, our government attaches great importance and urgency to addressing the issue of missing and murdered Aboriginal women. Our heartfelt sympathies go out to the grieving families. We have invested significant resources in law enforcement tools needed to locate missing women, while providing on-reserve, culturally responsive policing services. We're also supporting victim services in Aboriginal communities to improve overall community safety. This government is taking significant action to address this serious issue and will continue to do so going forward.
The honourable member for Skeena-Boku Valley.
Speaker, this epidemic of violence against Aboriginal women has shattered families from across Canada. Gladys Raddick from northwestern British Columbia, my home, is here in Ottawa calling for justice. Her niece, Tamara Chipman, disappeared on the Highway of Tears when she was 22 years old. Her story is far too common. We know the solutions: affordable transportation, partnership with First Nations, support for those working to end this violence. Municipalities, women's groups, First Nations families have come forward with real solutions for this government. When will we move from sympathy to action?
The Honourable Parliamentary Secretary to the Minister of Justice.
Well, Mr. Speaker, the NDP just isn't paying attention because we have been taking that action. We're taking action to crack down on murderers who prey on women, and it's this NDP that's standing in our way. This government introduced and passed legislation to repeal the faint hope clause, which was only serving to re-victimize those who have lost their loved ones. We eliminated house arrest for serious crimes such as kidnapping and sexual assault. We created a national website for public tips to help locate missing women. We've boosted victim services. Unfortunately, the NDP, including the member from Churchill, voted against those measures. Shame on
The honourable member for Vancouver South.
Mr. Speaker, our government's record has exceeded expectations when it comes to environmental action. We've been instrumental in implementing a world-class oil sands monitoring program. We've put in place new wastewater regulations to protect the health and safety of Canadians, and we're halfway to meeting our greenhouse gas emission targets. Canada is truly a world leader when it comes to environmental progress. Can the Minister update this House regarding our government's new measures to clean up contaminated sites?
The Honourable Minister of the Environment.
Well, Mr. Speaker, I'd like to thank the Honourable Member for Vancouver South for a terrific question. Our investment today in the renewal of the Federal Contaminated Sites Action Plan demonstrates the balance between the need for a cleaner environment while protecting jobs and economic growth. This program, which is expected to create some 7,300 jobs across Canada, is yet another example of how we're working toward a cleaner and a healthier environment. Unlike the NDP's $21 billion carbon tax, which would increase the cost of everything, our action plan will create jobs, not kill them.
The honourable member for Rosemont-la-Petite-Patrie. Yesterday, the member for Nepean-Carleton once again played the clown. Instead of answering serious questions about influence exerted by the Prime Minister's office, he questioned my love for Canada, for the Rockies, for Gretzky, for Terry Fox, even for the Montreal Canadiens. But his hamming it up does nothing to alter the fact that people close to the Prime Minister twisted arms to get Robert Abdallah appointed to the Montreal Port Authority, the same character whose name cropped up in a corruption scandal. Why was the government so determined to get Abdallah appointed? What was in it for them? The Honourable Parliamentary Secretary to the Minister of Transport.
This is the guy who just keeps, this is the gift who just keeps on giving. In fact, he not only gave once, he gave 29 times to the separatist Québec Solidaire. Mr. Speaker, Canadians are a very forgiving people. They can forgive someone who makes a mistake or makes the same mistake 29 times, but what they can't understand is when someone purports to be a future minister in the government of Canada who can't simply rise and say he believes in Canada.
Order. À l'ordre.
Order.
Order.
The honourable member for Rosemont-la-Petite-Patrie. Mr. Speaker, if my colleague is so determined to talk about that, I'd invite him to speak with Bernard Landry's former councillor, who's in his caucus. It's strange the Parliamentary Secretary denies any involvement, because yesterday someone close to the Prime Minister literally hung him out to dry publicly, saying that the Conservatives were keen on Robert Abdallah. And I quote the Prime Minister's attaché de presse, who said, "To be clear, the federal government did express a preference." What are the Conservatives trying to hide? What were they offered in exchange? Yeah, Honourable Parliamentary Secretary.
Than when a former separatist decides that, after all, he's going to embrace Canada. And that's why, after I learned that over a decade that this particular member donated 29 times to the hardest-line separatist party in Quebec, I gave him repeated opportunities to just rise in the House of Commons and say, you know what, it was all a mistake. I now believe in Canada. Why doesn't he come on over and join the Canadian family? We're a welcoming place. Why can't he just say, I love Canada, I believe in this country, I want to be part of its future?
The Honourable Member for Rosemont-La Petite Patrie.
Order. Order. The
Honourable Member. Thank you.
Order.
The Honourable Member for Rosemont-La Petite Patrie. Thank you, Mr. Speaker. I think at this point, if my colleague continues to act like such a clown, he won't even be asking questions in 2015.
I was never appointed. Well, should we consider ourselves lucky that the Port of Montreal Board of Directors resisted the PMO bullying? Because if the Conservatives had their way, a man whose name is linked to corruption allegations would be managing one of the largest ports of the country. Why did the Conservatives think he was the right man for the job?
The Honourable Parliamentary Secretary to the Minister of Transport.
Mr. Speaker, the question is, why does the Leader of the NDP think that member is the right man for the job of Labour Minister when he can't even state his support for Canada?
Order. I'll ask honourable members to hold off on their replies until the Parliamentary Secretary has finished the response.
The problem is not that he donated 29 times to the Separatists, including 6 times this year while he was in ostensibly in a Federalist caucus. The problem is he cannot stand up in the House of Commons even now and say that he rejects separation and supports Canada. Why?
Order. The Honourable Member for Rosemont-La Petite Patrie. When there are 2 ministers who were former members of sovereigntist movements, you should be careful with that line of argument. There's a limit to how far you can take people for idiots. The Prime Minister's press attaché said that the Conservatives had a preference. Members of the Board of Directors confirmed that Dimitri Soudis attempted to influence the decision. Former Minister Michael Fortier said that people did pressure the Board of Directors. Zampino said he wanted Abdallah. Houssakos and Soudis also wanted Abdallah. Why are the Conservatives, why did they try to pull strings for Abdallah? What role did Houssakos play in this whole story? Order. The Honourable Parliamentary Secretary.
Mr. Speaker, apparently my honourable friend is following the old rule. When you're in trouble, yell. And that's exactly what he's done. I simply ask, given that the member has donated 29 times to a separatist party, why can't he do what literally every member of this caucus is prepared to do, which is to say, stand up and say, I am a federalist, I believe in a united Canada, I want this country to stay together, I want it to have a bright future. Why can't he do that?
Order. The honourable member for Random, Buren, St. George's. Order.
Mr. Speaker, the minister responsible for employment insurance claims that, quote, the vast majority of people who are working while on an EI claim will be better off. This is simply wrong. The government's own report reveals it plans to cut 57% of the funding for the first year of the Working While on Claim pilot project when compared to last year's project. How can the minister honestly claim that the vast majority of Canadians who work while on a claim will benefit from almost 60% less funding?
The Honourable Parliamentary Secretary to the Minister of Human Resources.
Well, thank you very much, Mr. Speaker. Through the Working While on Claim pilot project, our government's aim is to encourage EI claimants to pursue and accept more work while collecting employment insurance. We know that when individuals accept a part-time job, they frequently end up in full-time employment. This government's been focused. We've created 770,000 net new jobs since the downturn of the recession. Unlike the opposition, who either, as the NDP want to, put in place a carbon tax of $21 billion to kill jobs, or the Liberal opposition that just simply vote against every initiative we put forward.
The honourable member for Saint-Léonard, Saint-Michel. Thank you, Mr. Speaker. Let's see if they'll answer if we ask in French. The minister responsible for EI claims that the majority of people working while on claim will be better off. That's simply false. The government is planning to cut 57% of funding for the first year of the Working While on Claim pilot project compared to last year. How can the minister pretend that the vast majority of Canadians will be better off when they're cutting the funding by 60%? The Honourable Parliamentary Secretary.
Mr. Speaker, this is sort of like the movie Groundhog Day, so I'll say it again. Through the Working While on Claim pilot project, our government's aim is to encourage EI claimants to pursue...
Order. Order. The Honourable Parliamentary Secretary has the floor.
...to accept more work while collecting employment insurance. And as I mentioned before, we have a robust plan for helping those that are unemployed have employment. We've created 770,000 net new jobs, unlike the opposition who have voted against all of our initiatives to create jobs, whether that be helmets to hard hats or the $21 billion carbon tax of the NDP.
The honourable member for Trinity Spadina.
5 million Canadians go down to U.S. airports to fly because the flights there are cheaper. Why? Because conservatives treat airports as cash cows and charge huge fees.
Order. Order. The honourable member for Trinity Spadina has the floor now.
As a result, according to the Canadian Airport Council, Canada loses 11,000 jobs and $240 million in tax revenue. When will this minister reduce the job-cutting tax on airports, tell us he loves Canada, and keep the jobs and flight here in Canada?
Order. The Honourable Minister of Transport.
Is asking for use taxpayer dollars to subsidize air travel. It's rich to hear the NDP on this when they want to create a carbon tax of $21 billion. That's with that they want to pay. Here in Canada, we don't use taxpayer money to subsidize this industry. That's a user pay principle system. We'll continue on that way, sir.
The Honourable Minister for Trois-Rivières. The Honourable Member, rather, for Trois-Rivières. Mr. Speaker, we're used to the minister's disregard for opposition questions, but the conference board has the same position we have. So I repeat the question. 5 million Canadians cross the border for flights that are 35% cheaper on average. It's not just our airlines and airports that are losing market share. It's all the businesses that depend on them. 11,000 jobs are lost every year. $240 million in lost revenue. Why do the Conservatives continue to stimulate job growth in the U.S. instead of in Canada? The Honourable Minister. Mr. Speaker, I'm very proud to be Canadian and a member of this government. Very very proud, rather. Mr. Speaker, if we're to continue Canada's economy with the U.S., I think the answer is quite clear. In Canada, We have a system where users pay for airline services. We don't take taxpayer money to subsidize the airline industry, and that's what they want on the other side. They want to create a $21 billion carbon tax. That's how they want to pay for these things.
Honourable member for Prince Albert.
Thank you, Mr. Speaker. 25 years ago, a visionary Conservative government signed the most ambitious trade agreement the world had ever known. Since the Canada-U.S. trade agreement, nearly 4.6 million jobs have been created, and two-way trade with the United States has more than tripled. But the NDP opposed this partnership, and the member from Dartmouth Cole Harbour even called free trade agreements job-destroying. Would the Minister of Foreign Affairs please share with the House how our government's pro-trade plan is bringing long-term prosperity to Canadians?
The Honourable Minister of Foreign Affairs.
Mr. Speaker, 1 out of 5 Canadian jobs depends on trade. That's why this government, this Prime Minister are working hard to have more markets for Canadian goods right around the globe. That means more jobs, more hope, and more opportunity. The NDP, Mr. Speaker, only mentioned the word trade one single time in their campaign platform. And what does it say about trade? Cap and trade revenues by year. $21 billion of new tax that will kill jobs, it will hurt Canadian families, and we won't let it happen, Mr. Speaker.
The Honourable Member for Cardigan.
Mr. Speaker, the Minister of Fisheries' mandate is to manage our fishery and provide services to our fishers. But this government has not got the message. They're downloading logbooks and at-sea observers to our fishers. They have fired over 400 critical DFO employees, and now they want to download the best conservation tool the Government of Canada has. Will the Minister stand up for our fisheries and keep gear tags as a federal responsibility? It's an important conservation measure.
The Honourable Minister of Fisheries and Oceans.
And of course, this government is responsible for the fishery. We are responsible for the fishery and will continue to do so. With regard to gear tags, Mr. Speaker, we believe it is the cost of doing business, and the people that are doing the business should be responsible for their costs. Thank you, Mr. Speaker.
The Honourable Member for Jonquière Alma. Mr. Speaker, 130 workers at the Rio Tinto Alcan plant in Jonquière Alma have been locked out without pay since July 10, 2012. Under obscure EI rules governing labour disputes, these workers are not considered to be unemployed. Will the Minister of Human Resources intervene to solve this problem? Because these workers can no longer pay their rent, their grocery bills, and other bills. The Honourable Parliamentary Secretary.
Thank you very much, Mr. Speaker. The Employment Insurance Program is designed to maintain neutrality and not to interfere in labour disputes. That's why EI benefits are not payable during a labour dispute. Service Canada is working collaboratively with unions as well as employer representatives to resolve this issue as quickly as possible. I encourage affected employees that have already been, but I encourage them as well, that they should apply for their EI benefits.
The Honourable Member for Kelowna Lake Country.
Thank you, Mr. Speaker. Our Conservative government believes any violation of Canada's veterans' privacy is totally unacceptable. That's why we put in place strict measures through the Privacy Action Plan and the announcement of Privacy Action Plan 2.0 to ensure the personal information of veterans remains protected. Can the caring and compassionate Minister of Veterans Affairs please inform the House of the status of the Privacy Action Plan 2.0? Thank you, Mr. Speaker.
The Honourable Minister of Veterans Affairs.
First of all, I'd like to thank the member for Kelowna Lake Country for his sustained interest in veterans, as are all members in my caucus. I'm very proud of that. I'm very proud of my country, by the way.
Veterans Privacy Action Plan 2.0 have been fully implemented. As the Privacy Commissioner pointed out in her report table today, my department has implemented major improvements to better protect the privacy of our veterans, and will we keep on that way, Mr. Speaker. Thank you.
Honourable Member for Montmagny-Lillet, Kamouraska, Rivière-du-Loup. Since August, Ms. Michelle Lajoie, a resident of my riding, has been waiting for a drug produced in Europe, a so-called orphan disease. Her health is deteriorating quickly, and the oncologist treating her said that she urgently needs the drug, but it's being held up because of an administrative conflict between Health Canada and hospitals. The department has quadrupled the usual time it takes to get this drug. We asked the minister for an explanation on Tuesday and are still waiting for an explanation. What's the minister waiting for? Why doesn't she do her job and deliver this drug immediately? The Honourable Minister of Health.
Thank you, Mr. Speaker. Mr. Speaker, our concern is always the health of Canadians. The Special Access Program gives doctors access to medicines that is not available to Canadians. When a doctor makes an application, a request under the program, Health Canada is in contact with that physician within 24 hours. But the first step is the physician himself has to make an application to Health Canada, and within 24 hours, the department will respond to the physician. Thank you, Mr. Speaker.
The Honourable Member for Senate's Gulf Islands.
16 sitting days to go until the Canada-China Investment Treaty is automatically approved without a debate or a vote in this House. It will bind Canada for the next 15 years, giving Chinese state-owned enterprises, indeed the Communist Party of China, the right to sue Canada in secret arbitration hearings. My question is this: was the decision to approve this deal by order in Council in order to keep it from the Canadian people, or to avoid having to force Canadian Conservative MPs for voting for something they don't believe in?
The Honourable Government House Leader.
Mr. Speaker, the Honourable Member's question is way off the mark. This agreement, which is intended to protect Canadian investors, Canadians that are seeking to do business so that their investments in China are actually protected, was tabled in this House of Commons. We have rules that allow it to be debated in this House of Commons should the opposition parties among them decide to have it debated. They've already had 2 opportunities this week. They chose not to have debated. So we have the most open process any government in Canada has ever had for agreements of this type. Unprecedented openness, an unprecedented democratic process, but that's not going to stop us from moving forward to help Canadians invest and create prosperity.
That concludes question period for today. I understand the Honourable Member for Skeena-Bulkley Valley has the traditional Thursday question.
Thank you very much, Mr. Speaker. It's an honour to rise on behalf of the opposition to ask what the government has in store for the House for the remainder of this week and the days following the Thanksgiving constituency week. Last week we heard from the government House Leader that he used his very valuable time to continue to point out Conservative misinformation. Canadians deserve a lot better. This government has added to their impressive and growing record of disseminating these imaginations and falsehoods by recently suggesting that the New Democrats are in fact somehow responsible for the Minister of Agriculture's recent failures because we're holding up a Senate bill on food safety. To suggest that the official opposition has any impact on the progress of a bill in this other place is embarrassing to the government. The bill in question, S11, by the way, is over in the Senate with the government's partisan fundraisers and ex-spin doctors for 119 days, and the House of Commons has yet to see it. If the government wants to get S11 moving, perhaps it should phone some of its friends and ask that they actually do their jobs and move the bill forward. The problem is that Canadians expect something a lot better from this government than spreading misinformation. So I'd ask my friend across the way to set aside his typically partisan and somewhat embarrassing remarks and just stick to the facts of what the upcoming business would be for the House. It would be refreshing for a change and one that would be welcomed by all Canadians. And Mr. Speaker, with that, on behalf of the official opposition and particularly the official opposition New Democrats, I'd like to wish you and your family and indeed all Canadians from coast to coast to coast a happy and peaceful Thanksgiving holiday. Thank you.
The Honourable Government House Leader.
Thank you very much, Mr. Speaker. And I'll firstly start by addressing S11, and that is, of course, the food safety bill that has been introduced by this government in the Senate to bring about changes that will actually strengthen our food safety system further, following the implementation, of course, of the 57 recommendations of the Weatherall report, which further strengthened our system. I believe the comments he's referring to that have been made by members of the Conservative caucus are not to the NDP obstructing the bill in the Senate, rather to statements that had been made by NDP members previously following the introduction of the bill that the NDP would oppose that bill. And that is to clarify what it is. And of course, the issue we're looking forward to is having it passed successfully in the Senate. We hope now that people see the urgency a little bit more clearly, the support of the Liberals, and then, of course, that we will see rapid passage here in the House. And we'd be delighted if we had support to do that very quickly from the NDP and other parties. For the business ahead of us, Monsieur le Président, cet après-midi.
Mr. Speaker, this afternoon we will continue our Safer Streets Act by studying C-43, the Faster Removal of Foreign Criminals Act. During the election campaign last year, the Conservative Party had promised to stop foreign criminals who launch endless appeals in order to defer their removal. So this bill is one of our commitments we made to Canadians. I hope that we will be able to finish it, and then we will thus finish the first 3 weeks of our session by doing so.
Week after which I hope all members of Parliament and staff of this place will have the opportunity to rest and relax. Many of our pages will have their first opportunity to go home since they started the year here. I hope that on our return we will all be ready to be productive and work hard because we have much to do. On Monday, October 15th, before question period, the House will start the second reading of Bill S7, the Combating Terrorism Act. We will also debate this bill on Wednesday and Friday of that week. This, of course, is all designed to continue to make Canada, and in fact the whole world, a safer place. After question period on the 15th, we will kick off debate on Bill S9, the Nuclear Terrorism Act, which shares the same objectives. It implements Canada's international obligations under the Convention on Physical Protection of Nuclear Material and the International Convention for the Suppression of Acts of Nuclear Terrorism. Tuesday, October 16th, shall be the 5th allotted day, which will see the House debate a Liberal motion. We eagerly await the content of that motion. Thursday, October 18th, shall be the 6th allotted day, Mr. Speaker, when we will consider a new Democratic proposal. It is my personal hope that, having given the NDP 3 chances already this fall to articulate to the House and to all Canadians that how they will implement their $21.5 billion job-killing carbon tax, that they will finally choose this as the subject for debate. I hope they will seize that opportunity and let Canadians once and for all know the fine details on their scheme to raise the price of gas, groceries, electricity, and winter heat. Should we have additional time that week upon our return, the House will also consider a second reading of, or even this week if we move quickly, Bill C-37, the Increasing Offenders Accountability for Victims Act, Bill C-15, the Strengthening Military Justice and Defence of Canada Act, Bill S-2, the Family Home on Reserves and Matrimonial Interests or Rights Act, and Bill S-8, the Safe Drinking Water for First Nations Act. Of course, I always am open to suggestions from the opposition. If they're willing to accelerate any of those bills for quick passage, I will call them. Finally, please let me wish all of you here a happy Thanksgiving. I hope that everyone has a productive and hard-working week working with their constituents. Thank you very much, Monsieur le President.
The honourable member for Guelph is rising on a point of order.
I think that if you seek it, you'll find unanimous consent for the following motion, that the Canadian Food Inspection Agency provide the Standing Committee on Ag and Ag Food the names, locations and job descriptions of all inspectors employed by the Canadian Food Inspection Agency no later than Tuesday, October 9, 2012.
Does the honourable member have unanimous consent to the House to propose this motion? There's no consent. Order. The honourable member for Saanich Gulf Islands is rising on a point of order. Yeah, after the member for Saanich Gulf Islands.
Thank you, Mr. Speaker. I'm rising on a point of order related to what I think you may agree with me, Mr. Speaker. We've had a deteriorating quality of SO31s. They're descending into a fairly unpleasant political spin instead of what they're supposed to be. And of course, Mr. Speaker, I don't need to remind you of the rules. They're to deal with issues of national or local importance, and they are never to be personal attacks. I think they're getting really quite, for lack of a better word, despicable. I refer in particular to one from yesterday from the member for Wildrose, who used his SO31 to attack me. In fact, I was flabbergasted by this. Thank you, Mr. Speaker. I think, I'm trying to make more of a generic point that they're going downhill.
The honourable government House Leader is rising.
Well, Mr. Speaker, if you will allow me, for the benefit of the honourable member, I will read to her what Standing Order 31 actually says. A member may be recognized under the provisions of Standing Order 30.5 to make a statement for not more than 1 minute. The Speaker may order a member to resume his or her seat if, in the opinion of the Speaker, improper use is made of this standing order. There is nothing saying that the content must be local. There is nothing saying it must be national. There's nothing saying that it can't touch on policy. There's broad scope and range to it. In fact, there is no limitation whatsoever other than the Speaker's normal ability to determine that something is unparliamentary. So I have failed to see what she's complaining of.
That's a good point, Peter.
I had one final point. I can understand that perhaps having fewer members in some of the other parties, she's frustrated that other people get to say more than hers, but that is not a reason to try and suppress the rights of others to have their say in this place.
The honourable member for Said and Scoff-Islands.
Mr. Speaker, since in point of fact I've spoken more often in this House over the last year than any other member, that's not the source of my complaint. My complaint is that previous speakers, particularly Speaker Sauvé, was very clear in setting out guidelines. I think it's unhelpful for the maintenance and improvement of decorum in this place to have SO31s used for personal attacks or for nonsense such as the non-stop carbon tax ridiculous debate back and forth between the official opposition and the government. That's not the place for SO31s.
The Honourable Government House Leader.
Well, Mr. Speaker, the honourable member says we shouldn't be allowed to speak about a carbon tax in this House now. Every single member of Parliament is responsible to their constituents. Constituents who, if they were faced with a $21.5 billion carbon tax, would have to pay that, would have their personal lives affected by it. Nothing could be more important for a member of Parliament than to stand up for their constituents on issues like taxes. I can't imagine why she would want to shut down that debate other than she doesn't.
Order. There have been previous Speaker rulings on the what SO31 should and shouldn't be used for. I'll go back and look at the particular SO31 that the member has been complaining about, and if necessary, come back to the House and do that after the break when we come back. Now, the member for Winnipeg North was rising a moment ago. Does he still have a... No, he doesn't have a point of order. Okay. Orders of the day, order du jour.
Government Orders, Government Bills Commons, resuming debate at the second reading stage of Bill C-43, Faster Removal of Foreign Criminals Act.
Resuming debate, the Honourable Member for Macorel-Fortin. Mr. Speaker, C-43 was supposed to be a piece of legislation that protected Canadians. It was supposed to be a bill that finally corrects certain errors made in the past. But unfortunately, with C-43, we're seeing the opposite. It is a bill that attacks the civic rights of Canadians. We have never seen such a great disappointment. Here's an example. I will say what Sir Winston Churchill said to an American general who had not been very active. We hoped to throw against the enemy a wild tiger, and instead what we saw was a whale, and in this case the whale is C-43. This is a piece of legislation that does not correspond to what Canada needs, and I will tell you why, for 3 reasons. Canada is a state that respects the rule of law. When someone violates a rule, then they must be subject to justice. Everyone, not with no exception. So for this purpose, we can see that once again the political powers are trying to micromanage immigration matters. And what we were calling for was the contrary. We don't want any further political intervention in immigration matters. There has been too much in the past, way too much, and look at the results. The results are that now we need a new act, not a remake of the former versions of what other governments concocted. Now we are seeing a concentration of power that is more and more arbitrary in the hands of the minister. Now he's not only someone who has political power, he wants to take over legal powers as well. Machiavelli said about that power corrupts, absolute power corrupts absolutely. And in the case of a government that is sticking its nose into matters of immigration and is mixing electoral partisanship with a legal duty, well, that is what qualifies Canada. It should have been corrected, and unfortunately, it's being repeated. Political powers concentrated in the hands of one minister is criticized. It has been criticized by all important legal players. It has been criticized by bar associations and by immigration rights experts. They say it over and over. They are calling on us not to do that. They are calling on us to do the exact opposite. When we say that the minister has a discretionary power to qualify the ineligibility of someone who has been, of the family members of someone who has been deported, well, that you can't get any more discretionary than that. If you had a good media image, if you're interesting in electoral terms, then that's fine. The minister will support you. But if that's not the case, too bad for you, but you will have to suffer all the consequences. In this regard, we say that there is no freedom if the legislative and executive powers are not separated. Montesquieu said that. These basic democratic principles, these very principles that underpin our democracy, say that the legislative and the judiciary and executive powers must all be maintained separate. And here, the government is trying to do the opposite. The government also wants to take away from the minister the power to examine humanitarian and compassionate reasons, or rather remove from the judge the ability to examine that. Now, usually, this is a normal judicial proceeding, and that is what we expected. But no, once again, the government is doing the contrary. They are attacking the most basic and essential and common rights in this regard to such an extent that this hastily cobbled together act is going to be legally challenged, and once again, the government is going to lose, as it always loses. This is a bad law. Was it too much to ask? We just wanted you to defend Canada. And what are you doing instead? The opposite. You are attacking Canadians. You are attacking their very legal concepts. You are attacking their rights to have a fair trial and receive a fair decision. Judicial proceedings are an essential part of the Act, of the law, but in the Immigration Act, under IRPA, there are commissioners who are appointed very hastily based on their ability to fundraise for a particular party, depending on who they're cronies with. That was already the case with a former government under a formal political party, and they're making the same errors.
You should be doing the exact opposite. We need people who are qualified with good legal background to render decisions that can't be criticized. But no, that's not what you're doing. You're doing nothing. You're simply reproducing the mistakes of the past, and it's a disaster. We've never seen anything so pathetic. We have proven to you that the commissioners, in reading the Act, accepted 98% of refugees, and that other commissioners with the same legislation, the same Act, accepted only a few. So that shows that the commissioners weren't, this method of having commissioners wasn't working. Now, there have been cases of fraud taken to the court, and these people have been found guilty beyond a reasonable doubt of corruption. No changes to that. We ask you to appoint judges, people who are independent, with judicial independence. And once again, you appoint friends, public servants, people who we don't know if they have the qualifications. You are not doing it right. And You simply use the same methods of the past with the same flaws and to make them worse, saying that, well, we're going to remedy the situation, but unfortunately, you aren't remedying anything. That leads me to my third point, who you are attacking. Now, all people who weren't born in Canada will feel threatened, and that's a major problem. We expected a Rizzuto law. He's someone who committed murder, who's now in prison. He wasn't born in Canada, but he's coming back to Canada, and everybody knows what he's going to do. Commit more murders. The police know it. All specialists in criminal law know that the individual is going to come back and avenge the murder of his father and son. So we would have hoped that the government, which claims to be tough on crime, would prevent those kinds of people to come back to poison our existence. But no, clearly they're attacking the little people, the little drug traffickers, the little bad guys who've gotten 6 months in prison. Yes, deport them, but don't forget people who are bringing in containers full of cocaine. They're just being ignored. Well, I don't want to shock you. I want you to be shocked, in fact, because Canadians are very shocked to see that those people are coming into Canada with impunity. They're mafia members, leaders who aren't born in Canada. How many of them have been deported? 0. Justice Falcone, an anti-mafia judge in Italy, said crime, organized crime, can't be on the rise without political protection. Did you accept to provide that political protection? Now, we know in the past there's been political protection. We know so well that there was an individual, the RCMP had said, don't bring him in as a minister. He became a minister nonetheless in a previous government. So we're asking you to make an effort to not create situations like Conrad Brack, who give up their citizenship to receive a title, but then once they get out of prison, they come back to Canada. Where's the tough on crime? It's clear, Mr. Speaker, that the government and some of its elected members are simply abandoning their positions with respect to organized crime. They're simply capitulating. Thank you, Mr. Speaker.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Citizenship and Immigration.
Well, thank you, Mr. Speaker. I listened to my colleague's speech from across the way, and I guess he doesn't really understand what Bill C-43 is, fast-tracking foreign criminals out of Canada. He wants to go on and talk about how he thinks Canadian citizens shouldn't be allowed back into the country. If he has a way for those criminals who have committed the crimes he suggested to not come back to the country, I suggest he introduce a private member's bill to do so, because no Canadian citizen is allowed to be barred from Canada. But let's get back to the bill, because he didn't speak very much about it, other than to say, why are we pursuing drug traffickers? Why are we pursuing criminals who have committed serious crimes in this country and are not Canadian citizens? If he's saying that it's okay for drug traffickers to stay here in Canada and we shouldn't be pursuing them, we should be keeping Canadian citizens out of Canada, it's a backwards approach. I'm not sure if he really understands the bill. Perhaps we should just get the bill to committee, Mr. Speaker, because it would actually give us an opportunity to educate this member, and if any of his other colleagues do not understand Bill C-43, it's a perfect place for us to sit down, negotiate, and obviously teach them what the bill is all about.
Député de Marc-Aurèle-Fortin.
The Honourable Member for Marc-Aurèle-Fortin. Canadians fully understand that an individual who's committed murder on behalf of the mafia, who lived his entire life within the mafia, who has poisoned our existence for his entire life, is coming back to Canada. And that you're simply washing your hands of that. That means abandoning your position vis-a-vis the enemy. That enemy is attacking Canada, and you're simply giving him an opportunity to continue. The justice from Italy said there are three types of politicians: the ones who fight against the mafia, the ones who work for the mafia, and the most dangerous of all, the ones who just allow the mafia to do as they see fit. In committee, we are going to look at the legislation. We'll give it some teeth. The teeth that you're not giving it, the teeth you're taking aim at the little people, the ones who can make you, enable you to create some smoke, but not the people who are in charge of organized crime. Order, please. Order, please. I'd remind honourable members that they need to direct their comments through the chair. Questions and comments?
For Winnipeg North.
Thank you, Mr. Speaker. As I've indicated before, this is indeed an anti-immigrant bill. And at the end of the day, Mr. Speaker, if it was just about serious criminals and deporting serious criminals that were permanent residents, I suspect the member would have a lot more, or the government would have a lot more support. But it goes far beyond that, Mr. Speaker. And to illustrate that in the form of an example, that if you are have a family in a country abroad in which one of your children moves to Canada or immigrates to Canada, and then you want to be able to visit that child someday, but because you have another dependent that's involved in some sort of gang activity, you will not, as a parent, be able to come to Canada to visit your child. That's this serious crime bill that this person or the government is talking about, Mr. Speaker. And I'm wondering if the member might want to comment on the fact that this bill does a lot more than just dealing with serious crime of permanent residence.
The honourable member for Marc-Aurèle-Fortin. We had a great deal of hope in this bill. All of the changes to deal with the abuse of the past that we had observed and documented, but unfortunately in this bill, the government's attacking people who make the front page of the newspaper, not the essential aspects of discrimination, for example, that enable the minister to decide who's admissible and who isn't. This bill isn't targeting just criminals. People who are innocent are being singled out, but because they're immigrants, they may be judged as a criminal. We're lumping them all together with people who come to this country to commit crimes, and that's not the case. Unfortunately, Mr. Speaker, that's the problem with this bill. They're singling out people who shouldn't be, and I would have expected a Rizzuto law, a solid law, and that's not what we're seeing here in this bill.
Debate. The honourable member for Windsor West.
Thank you, Mr. Speaker, and I'm pleased to join today's debate on Bill C-43, an act to amend the Immigration and Refugee Protection Act. And of course, they tag it with these new lines: faster removal of Foreign Criminals Act. I think it's unfortunate that these types of titles have now been introduced into legislation that is supposed to be very serious, and this one is very serious. It's a continuation of, I think, our immigration drift in many respects. We are going to support this bill to get to committee because, as New Democrats, we believe our immigration system is fundamentally flawed and broken, and we're open to discussing how to improve it in any capacity. And some of the issues that are in this bill here are going to be raised, and we'll have some good expert testimony at committee to talk about these issues. And it's important to note, Mr. Speaker, our immigration system is necessary in this country for us to function in an economic democracy. We do not have a population that can sustain itself alone, and we have been founded on the principles of multiculturalism and on an openness. And that's changing, Mr. Speaker. It's changing because we are slowly eroding our immigration system. In fact, even in Windsor West, where I represent and have an immigration office, the doors are shut. You cannot go down there to get help on your immigration file. Karen Boyce in my office and Ian Bodden, who has, Karen's been with me for 10 years and is finally going to retire at the end of December, and I thank her for her commitment and all the cases that she has strove through. In fact, many times, Mr. Speaker, on her own time, she would actually get up in the middle of the night to call some embassy somewhere else to try to get paperwork or processing something moving. And she would do that literally all the time. That's how dedicated this person has. She's fought many times to get children pulled off from planes that were going to be deported to countries where they were never actually part of because they were born in Canada and their parents had been denied or their process for humanitarian grounds had not been accepted. And it's unfortunate, Mr. Speaker, because when you look at an economy like ourselves in Windsor, it's critical that we have these processing issues taken care of rather quickly, because we have so many people that cross the border into the United States. And I always use this example because I think it's important. We have a lot of doctors and other professionals who are not recognized in Canada and in Ontario that end up working over in Detroit, Michigan, and bringing that economic income stream back to our area. But ironically, sometimes when our hospitals are full here, or there's a specialty that we don't have, we actually send Canadian citizens over to those hospitals where they could be treated by the doctor that's not trusted over here in Canada. It's ironic. We pay a premium for it. But what's important, Mr. Speaker, is that we have many people that cannot get to their jobs until their actual immigration and processing has been completed. And often, if we don't solve those cases, they can lose those jobs, and those jobs are critical for our economy. The Canadian economy is not having the rebound that we want, and I can tell you I see it every single day on the streets of Windsor. And so any extra employment that we can access into the United States, and it's been a common thing that we've been doing for many, many years, is important. It's one of the reasons we have a strength and a healthy relationship, because there's a symbiotic relationship between the Detroit Greater Region and Windsor and Essex County. In fact, it makes it a good economic strong hub, and part of that is the ability to traverse back and forth, and our immigration system is not contributing to success. Now, some of the features of this bill that gives me some cause of concern is the ability right now is concentration of power into the minister's office. And at any time he can revoke or shorten the effective period of declaration for inadmissibility. That's one of the particular examples. And the reason I do, Mr. Speaker, is because I remember during the debate for C-31, and I listened to the minister and the government members, and the words that they were using. In C-31, it was a refugee act that was changed. And some of the words that they were using about the refugees in general was protection, take advantage, security of population, abuse, crackdown, and bogus. And I thought, you know, Mr. Speaker, with that type of a tone, what are we going to have out of a minister's office that's going to have more capabilities and less control on oversight if that's the general theme and attitude about refugees? And you know, Mr. Speaker, because our refugees, when you look at some of the refugees in Canada, and I want to name a few, I think it's important we have to put a human face on our refugees. You know, there's people like Canine. He was born in Somalia. His child lives in Mogadishu. He lived there during the Somalia Civil War and came to Canada in 1991. Is a person like that a threat? I don't think so. He was a refugee. How about Adrienne Clarkson, former Governor General of Canada? She emigrated from Hong Kong as a refugee in 1942. She came here making her mark and contributing to Canada. How about Fedorchuk, a chess grandmaster? He passed away since then, but he was persecuted in Ukraine. He came to Canada and contributed for many years. Now, here's an interesting one, Mr. Speaker. Sitting Bull, the Sioux chief. He left America for Canada as a holy man, who led his people as a tribal chief during the years of resistance in the United States. Sitting Bull eventually came here to Canada from the United States, where he was a successful citizen. And I think it's important when we're looking at some of these issues, because I want to touch up on one of the points that's been made in this, you know, when you have a criminal activity, and some of the comments that have been made by professionals are really important. Michael Bosson, a refugee lawyer in Ottawa, he's talking about those that have created some type of an offense, and it might be a smaller of less offense that now be deported outside this country, that will put themselves further at risk or further in trouble. But in that context, as a refugee is here, Mr. Speaker, I can tell you I used to work at the Multicultural Council and I had a program called the Youth in Action. And I'm going to talk a little bit about that in a minute. But I want to mention that sometimes when a refugee or a youth, they commit a crime, it's a cry for hope sometimes. Sometimes it's mental health. Sometimes it's just a really bad mistake. Sometimes they don't have medication, and it could be psychological issues that are taking place. And so when they get into programs, that assists those people, they actually become better citizens, and they can be more engaged, and they can be better people and contribute to society on a regular basis. And, you know, the issue over mental health in general in the Canadian public is swept aside, let alone when it's involved in criminal activity or those that have committed criminal activity. It was important to have judges to have actually more flexibility to be able to determine the case. And our judicial system, you know, before I get into a little bit of the work that we used to do, our judicial system has made some terrible, terrible mistakes. It's not perfect. It's not perfect. There are mistakes made when you are making decisions about people, whether maybe information wasn't presented properly, maybe it was inadmissible, maybe information wouldn't even get there because, as you know, you basically, if you've got money, then you go and get the best lawyer that you can because you get the best lawyer because you get the best representation. But if you're a refugee, how many refugees out there in Canada are walking around with a pile of cash and can hire the best lawyer? And often, Mr. Speaker, I've seen this even come through my office, and it's horrible. It's horrible is that people have spent money on lawyers and borrowed it from each other and other people, or they've borrowed it from credit cards and other types of things that they have very difficult to repay because they don't have the economic stream going at the moment right now, and it puts them in an even worse situation. And that's the harsh reality about our judicial system. And thank you, Mr. Speaker. I have 2 minutes to finish. And I just want to talk a little bit about the Multicultural Council program that I ran there. We had 16 to 18 youth at risk between the ages of 18, and it was actually up to 30. I know they call them youth, but it was all the way up to 30. But they were usually in the 20-year range. And we had 8 Canadians that had been there basically all our lives in Canada, who had made mistakes and created some problem or had a minor fine or a penalty or a criminal record. And then we had 8 new people that had just immigrated to Canada. And we mixed them together to create a program called Multicultural Youth in Action. And they did all kinds of community work. They learned all kinds of life skills, interviews. And we had over a 90% success rate for getting them back into school and getting them back into employment. And to think about that, that program ran for several years and was very, very successful. And I want to conclude, Mr. Speaker, because what we were able to do with some of those youth, and we couldn't get them all. We couldn't get them all. But we actually saved taxpayers money because they weren't going back into the judicial system or going into the penal system where they're going to learn more behaviors and have a longer time for rehabilitation as opposed to paying for their price for what they've done and learning to contribute as a citizen.
Questions and comments. The Honourable Parliamentary Secretary for Multiculturalism.
During the last while, a lot of comments about this particular bill. I think there's an attempt by the opposition to confuse some of the issues, to talk about immigration, to talk about refugee, to talk about multiculturalism. What this bill actually specifically talk about are those immigrants, or sorry, those people who are in Canada who have chosen not to be Canadians. They're just permanent residents that have broken our law. When we ask people to come and build this country, we ask them to come here and join in us with our shared values, the same shared values that all Canadians enjoy and also appreciate and abide by. And if you choose to go against them, break our law, I think that is an undesirable element. I mean, I came here, I probably transitioned from an international student to a land immigrant, to a permanent resident, and to a citizen, and eventually to represent my constituent at this job. And I think that's what we're asking for, is people to come here and share and abide by our shared values. Thank you.
Member for Windsor West.
Thank you, Mr. Speaker. And, you know, the reality is that not everybody's perfect out there. And sometimes people do make mistakes. And the question is, what do we do in our society about that? And what do we do about the consequences of the other people that are affected? And let me read from you from my staff, who just had one case that came in today as a 29-year-old gentleman from Serbia that is being deported. All his family live here in Canada now, mother, sisters, and brother. He has been here 6 years and works at 2 jobs, at a restaurant and at a home renovator for a local contract. He has an H&C, this is a humanitarian compassionate ground appeal case in, but again, that will not be seen for at least another 3 years. He has no family in Serbia, and they're deporting him. and we've had more and more of these cases. What possible benefit is going to happen? Let the due process happen first before we send this man out of the country. He's got family here, and we know there's been problems in Serbia before. They're well documented in that region. What benefit is this going to be for our country by throwing this young man out?
Questions and comments. The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. This is, as I said, and will continue to say, an anti-immigrant bill. There are 1.5 million permanent residents in which this bill is going to have an impact on in some fashion or another. Mr. Speaker, I look to the member and, read the bill title itself, Faster Removal of Foreign Criminals Act. Now, the government chose to use the word foreign as opposed to permanent resident. What we're really talking about is permanent resident, those 1.5 million people. I'm wondering if he might want to explain why he thinks that the government has chosen to use, because language is important, why the government has chosen to use foreign criminal as opposed to a permanent resident, because that's really what we're talking about, permanent residents.
Windsor West.
Speaker, and that's why I mentioned some of the people that were refugees before. It's the tone that's being set and the concerns that I have about concentration in the back halls and the dark doors of the minister behind the scenes and what could be said and done. We've already heard some of this stuff come out before in the past. Let me, Mr. Speaker, conclude with this. The fact of the matter is other refugees around the world have played important roles. Look at Bob Marley from Jamaica, for example. He was a refugee. Olivia Newton-John was a refugee, or her grandfather was. Jackie Chan, Jerry Springer, Madeleine Albright, Harry Kissinger, Victor Hugo, Albert Einstein, all refugees. And my concern, Mr. Speaker, is the degree that we can go on this and having complete blind faith in the judicial system that could make a mistake on somebody.
We have time for a brief question.
First of all, I would like to congratulate my colleague from Windsor West for a very good speech, for having told us about human stories that underlie all of these laws. I would like him to tell us more about the type of effect that this commitment has on his own riding office, as well as the cases that he must often encounter in his office riding.
Of people coming in, and really what it is, Mr. Speaker, we're talking about families that are being broken apart. That's what's happening, sometimes involving children, Mr. Speaker, because you got to remember, if somebody has a child in this country, they are Canadian citizens, and it's not their fault that somebody else made other decisions that have repercussions on them. Does that mean that we throw them out? And the answer to that is, Mr. Speaker, is yes, we do, because if they don't, they either become a ward of the state by themselves here, or they have to go with their parents. And it's really horrible to see these cases take place because often it's just processing time. And so what we're focusing our time on this bill and the government's focusing its energy on is the wrong types of things, that we need to be doing, in my opinion. Let's get the processing times in place so that we can make right decisions and fair decisions for people.
Resuming debate. Reprise de débat. Honourable député de Hull-Aylmer.
Honourable member from Hull-Aylmer. Thank you, Mr. Speaker. Please, it gives me great pleasure to stand up today in the House and debate Bill C-43, which proposes amendments to the Immigration and Protection of Refugee Act. As other colleagues have said before me, we support this bill in second reading, but this support is far from unconditional. C-43 has major weaknesses at this time, which we need to correct at the committee stage. On this side of the House, we do wish to collaborate with the government to make C-43 a bill that is more fair and more balanced. Canadians expect us to be able to compromise, Mr. Speaker. Compromise is a fundamental aspect of a democratic system such as we have in Canada. To refuse to compromise is to miss out on one's obligations as democratic people. Our colleagues across the aisle too often have shown themselves unwilling to compromise and to enter into a dialogue since the last election. I truly hope that this is going to change. Mr. Speaker, Canadians want us to impose firm sanctions upon non-citizens who commit serious crimes on our territory. And I am convinced that nearly all the newcomers who do obey our laws, and it's important to remember that, who agree with us on this. But what people of this country mostly ask is for us to guarantee that our legal system and our court system be effective and sufficiently flexible, so that when the time comes to send criminals back to their country of origin when they do not have Canadian citizenship. They especially want the government to invest more energy in ensuring that applications for newcomers be processed more quickly and more efficiently. Conservatives should make more efforts to ensure that these people can, for example, be reunited with family members as quickly as possible. Mr. Speaker, as I said earlier, I have several reservations with respect to this bill. For example, I do not understand why the minister needs new discretionary powers. Were C-43 to be implemented tomorrow morning, the minister would have the power to decide that a foreigner was not admissible for temporary residency if he decided that it was in the public interest. But one of the weaknesses of that proposal is that the public interest is not defined in the Act. This situation opens the door to very different interpretations as to the definition of public interest. We must correct that. I also find it very difficult to understand the presence of a clause that frees the minister of his responsibility from reviewing humanitarian circumstances with respect to a request made by a foreigner who they've decided to be inadmissible. I would like to know why this measure exists. I do not understand why we would fail to review this humanitarian aspect. Is that really the kind of Canada we want to live in? Mr. Speaker, one of the biggest weaknesses of this bill is that it overly restricts access to the appeals process. We all agree that our system of appeal must not be exploited in order to deliberately delay the removal of a non-resident to their own country of origin. But the measures put forward in Bill C-43 should not limit human rights either. Conservatives have promoted their bill by speaking almost exclusively of the fact that it will allow us to remove dangerous offenders more quickly. But C-43 goes well beyond that. It also includes a redefinition of serious criminality. Under the current system, someone who's committed a crime that has led to a sentence of 2 years and over has no right to appeal the decision. C-43 would like to lower the bar and include all crimes that have drawn sentences of 6 months and over, which means to say that many more people will be deprived of the possibility of appealing a decision in their case. Let's understand this properly. I am not fundamentally opposed to refining the definition of serious criminality. It should definitely include crimes such as sexual assaults and armed robbery. That is a good thing. But in my opinion, we must be vigilant and ensure that this new definition does not lead to poorly considered decisions. I'm concerned about the effects that this new regime could have. The new system of minimum sentences as per Bill C-10 on decisions that are made in the cases of removals. Several of the crimes covered under this new system are non-violent crimes. We must be very cautious when we're talking about restricting the right to appeal. The restriction in the Act must not be too broadly applied by Bill C-43. Yes, we must prevent non-citizens who have committed serious crimes from exploiting our appeal system. But we must ensure that we adopt an intelligent attitude with respect to all of that. We truly must ensure a proper balance, Mr. Speaker. We certainly must ensure
that we can guarantee that the proper decision will be made in each removal case. The appeal mechanism is a good tool. Why would we get rid of it? I think we need to look much more closely at this issue once the bill has been sent to committee. Mr. Speaker, so far we have heard the Conservatives say a great deal about all of this and tell us that it's easy for non-citizens to avoid being deported. All they have to do is avoid committing serious crimes. Fine, all and well. But in real life, things aren't so black and white. We all know that reality is far more complex. And C-43 should reflect that complexity. For example, what about delinquents who arrived in Canada, juvenile delinquents who arrived at a very young age and who do not know anything about the country into which they would be deported? Some organizations have raised those concerns with respect to Bill C-43, which does not take that into consideration. Mr. Speaker, the NDP wishes to work with the government in order to prevent non-citizens who have committed serious crimes from abusing our system of appeals. But we do not want mechanisms that allow our system to respond with flexibility to extraordinary circumstances to disappear. Just as does the government, we want our court system to be efficient and effective and allow the removal of non-citizens who have committed serious crimes as quickly as possible. But we do not want an unbalanced and inappropriate system which does not take into account special circumstances. Wanting to send foreign criminals back home is a very good idea in and of itself, but we must not attack human rights through the process that we use to do so. We have, as a society, the obligation of making fair decisions that respect everyone's rights. Mr. Speaker, Bill C-43 is a bill that we can build upon. As I said earlier, we will support it in second reading, but it needs to be reworked. I truly believe we all have much to gain from expert testimony as well as the representatives of organizations that specialize on such issues. Thank you, Mr. Speaker.
Questions and comments? Question, commentaire. Honorable député de Vaudreuil.
Honourable member from Vaudreuil-Soulanges. Mr. Speaker, I think we have to ask the question, how did we arrive at this point? There are three things I would like to raise with the honourable member, and that is international commitments. In the past, we had a cultural commitment with other countries, towards other countries. It was the first step, the first in a meeting of the minds with other countries. Canadian culture was presented. That has now been removed. Secondly, we've taken away all integration resources, especially for integrating professionals who come here, who are trying to integrate properly into our society and help us build a strong country. And thirdly, I see this bill as being a part of a progressive agenda that's moving us towards an anti-immigration policy. Can the honourable member tell us more about the NDP vision as to immigration issues? The honourable member from Hull-Elmer. Thank you, Mr. Speaker, and I thank my colleague for his question. To begin with, let's say that the Conservative bill really has to do with a very small minority, and that those highly sensationalized cases which represent a small minority have been used to advance their own agenda, their own ideological agenda, which is very regrettable. As my colleague said so correctly, we do have a vision of Canada as being an open, fair country that respects laws. And respecting laws means that you have a system of appeals in place that applies to all Canadians and is fair for all Canadians. It may also take into account problems experienced by newcomers who have arrived here. That is the kind of Canada we want as New Democrats. Thank you, Mr. Speaker.
for Windsor West.
Thank you, Mr. Speaker. One of my really big concerns about this bill is how it's going to affect youth, and as well, too, as it has consequences on other family members. What you have happen sometimes with some refugees that come in, if the youth are not busy and active, they can often fall and find themselves in cultural shock. That was part of the program that I ran, was to help mend the fences around the cultural shock, or alternatively, they fall in with other groups and gangs and other activity because they have nothing else. If they're not at school, if they're not out of work, they're in a high vulnerability percentage to be influenced by other people, especially they don't know a new country. So I'd like my colleague to maybe examine a little bit about the issues of vulnerability of youth and families with this bill, especially concentrating so much power in the Minister's office.
Deputy Aylmer.
The Honourable Member from Hull Aylmer. Thank you, Mr. Speaker. My colleague has raised a very important issue with respect to integrating new families. We have highly educated newcomers, and yet their credentials are not being recognized. I understand that this is a provincial issue as well, but the federal government does have a major role to play in all of this. We're creating instability in families, especially families with young children that will suffer greatly from that instability. And there are problems with social integration, which can lead to cases in which youngsters are attracted to gangs and gang activities, which may create problems for themselves and for their environments. So we need to ensure that newcomers are fairly integrated and that they find themselves being trusted and trusting within their new country, their new chosen country. And this is the type of Canada that we want. Questions and comments, Honourable Member from de la Salle-et-Mare.
Thank you, Mr. Speaker. My question has to do with the consequences that my colleague thinks might arise from this type of bill, and especially the type of wording that is used. And I would like her to tell me about what she hears in her riding office. Very human stories that are brought to her by different people that she meets. I'd like her to tell us a bit about that. The Honourable Member for Hull Aylmer. Thank you, Mr. Speaker. And when I talk about my experience in my riding of Hull Aylmer, there are a great many new arrivals. And what I find a shame in this bill is what is the type of responsibility the minister wants to assume, when we know very well that when we refer people to the minister's office for immigration cases, he refuses to get involved. And all of a sudden, he wants to assume this type of power with no kind of appeal, and that will affect everyone. So I find it really a great shame, especially in my riding of Hull Aylmer, where new arrivals would need training, education, and assistance in their new community. And the Conservative budget does not provide for that. Resuming debate, the Honourable Member for Saint-Bruno, Saint-Hubert. Thank you, Mr. Speaker. Bill C-43 that we are debating is a bill that amends the Immigration and Refugee Protection Act. First, I would like to say clearly that the New Democrats realize that this bill must be flexible and effective for those who do not have Canadian citizenship. Canadians want us to take harsh measures against non-citizens who commit serious offenses that are often violent in our communities. New arrivals, the vast majority of whom abide by our rules and regulations, would be the first to support this approach, Mr. Speaker. What I also like about this bill is the fact that the clause that entering Canada because of a criminal network is not sufficient to be declared inadmissible for permanent residence. This is good for victims of trafficking networks who are not criminals. But, Mr. Speaker, there are things in this bill that bother me as well. The first element is the discretionary power that is left to the minister in order to decide whether people represent a menace to national security. In fact, this bill gives more arbitrary power to the minister. For example, Bill C-43 gives the minister broad powers, allowing him to prevent a foreign national from entering or leaving our country, or for declaring people inadmissible for public policy considerations that are not clear to us. We must reinforce the independence of the judicial system rather than giving the minister the possibility of deciding who enters and leaves Canada. The last thing our immigration system needs is to be even more politicized. Canada has an effective and independent system that allows us to rule on the inadmissibility of people coming to Canada, and it is not a good idea to replace this by the whims of the minister. The minister should not be allowed to declare people who are inadmissible simply because they do not agree with the government's policies. It is ridiculous to believe that giving more powers to the minister will solve anything at all. Another problem arises from the fact that the provisions of Bill C-43 would not apply only to people who have been found guilty of serious crimes in Canada, but also abroad. Canada has one of the best justice systems in the world, Mr. Speaker, but other countries are not so lucky. In many countries, simply being a member of the opposition party can lead to a conviction for serious crimes. This makes it clear that it is important to enforce the law regularly and consistently. We must ensure that Canada remains a welcoming nation and a country of hope for those who are fleeing persecution abroad. Now, that being said, Mr. Speaker, I think it is reasonable to ensure that people who are guilty of sexual assault or break-and-enters should not be allowed to roam in our streets. By changing the definition of serious crime from 2 years to 6 months, the professionals who work with immigrants and refugees have expressed concerns, saying that this legislative measure may unjustly punish people, young people, and people with mental health problems. So we must further study the impact of this provision to ensure that the measures truly achieve their objective, that is, preventing dangerous criminals from entering Canada. What also bothers me, Mr. Speaker, in this bill and in the government's more global initiative is the way they are portraying immigrants. These bills are announced as if immigrants were a serious threat to our country, or as if all immigrants were potential criminals, whereas almost all of the immigrants who come to Canada are people who, on the contrary, are coming to seek a better life and a better future, and they want, like all Canadians, to live in a safe environment. I myself am an immigrant. I chose Quebec and Canada to live in and to raise my family, and I'm very happy to be involved in my community of Saint-Bruno-Saint-Hubert. I chose this country because I wanted a safe environment for my Canada, and that is what I found here. Immigrating is not something easy, especially since if one is not joining family who is already settled here. One has to start from scratch, find housing, furniture, a school for our children. We have to have our foreign credentials recognized, and in my case, this was a nightmare, Mr. Speaker. Finding work is also a great challenge. A 2010 study shows that the unemployment rate was 4 times higher among immigrants with a university degree than among university graduates from Canada. The last thing immigrants need is to be stigmatized and to be perceived as potential criminals, because this will limit them even more in integrating into and contributing to Quebec and Canadian societies. The government must stop its rhetoric and putting immigrants, perceiving them all in the same light. People in my riding have told me troubling stories about how they are perceived and how they are treated simply because they come from elsewhere. Now, this being said, we cannot ignore the problems that already exist. All we have to do is react appropriately. As we say sometimes, there's no use killing flies with cannonballs. I know that we can prevent non-citizens who commit crimes from abusing our appeal process without flouting their rights. It is thus important that the government focuses on improving the immigration program to make it more swift and fair for the vast majority of people who do not commit crimes and who follow the rules, Mr. Speaker. Once again, the vast majority of people who come to Canada are not criminals. They are people who aspire to contribute to our society and help to build a better world. And often they are professionals and people with a high level of education. In closing, I would like to point out that the matter of health care for refugees is still very much in the public eye, and it's a very important matter. The government probably wants us to forget its cuts to this program, but I recently discussed this with the Family Doctors College of Canada, and they asked me to continue fighting for health care for refugees. So I would like to remind the government that we and the NDP do not forget. Thank you, Mr. Speaker. Questions and comments. The Honourable Member for Louis Hébert. Thank you, Mr. Speaker. I've heard a number of speeches today, and what I like is that each of the NDP members I hear from bring different things to this debate, and I would like to thank my colleague for her speech, especially when she spoke from the viewpoint of an immigrant, because that gives us a different perspective and sheds new light on the debate. We look at it from the point of view of people who are receiving these immigrants, but we need to hear from people who have arrived, who are coming to Canada. And so one of the things that particularly touched me in her speech, and I'd like to hear her speak more on it, is when she talked about serious crime and the definition of it. How could we improve this bill to ensure that people who are not really criminals, but because of political considerations, for example, how could we improve this definition to treat people who apply to come to Canada fairly? The Honourable Member for Saint-Bruno-Saint-Hubert. I would like to thank my colleague for his very relevant question. He knows about what I went through as an immigrant coming to Canada, all the battles I had to wage to get to where I am now. I can tell you that unfortunately, with this bill, when we hear about removing criminals to their country of origin, well, the perception of immigrants is that they are being stigmatized, and they think that we are considering them as potential criminals, and that is what I want to clarify here in this House. As I have already said, when we immigrate, when someone immigrates, there is work to be done on the end of the receiving nation and by the immigrants who are coming here. Unfortunately, we're not seeing this goodwill. All we see is people stigmatizing immigrants rather than integrating them.
Senator. Well, thank you very much, Mr. Speaker, and I listened intently to my colleague's speech, and I can't begin to count the number of mischaracterizations she used in there to talk about how we on this side feel about immigrants. We're not talking about stigmatizing immigrants as criminals. That's completely hogwash. She talks about not politicizing the process. Well, I'll ask her a question about people who are non-political but have an opinion on the process, and their opinion is professional. And I'd like to ask my colleague if the Canadian Association of Chiefs of Police, the Canadian Police Association, the Victims of Violence, these are among the many organizations that support Bill C-43, and does this member and her party support the views of these organizations on this bill, or would they rather politicize the process and not listen to professionals?
Député de Saint-Bruno Saint-Hubert.
The honourable member for Saint-Bruno Saint-Hubert. Well, perhaps my colleague across the way did not listen to the beginning of my speech, but what I said is that we in the NDP support a serious but flexible judicial system, because it's only logical. It says that this amends IRPA, the Immigration, Refugee and Protection Act. Now, if we're not talking about immigrants here, well, then who are we talking about, Mr. Speaker? I, as an immigrant, I am not defending hardened criminals. I am defending immigrants here in this House. We have to understand that even if there are young people who commit petty theft, for example, we must not allow the discretionary power to be left to the minister, and so that he can decide who is a petty criminal, who is a hardened criminal, and who is a danger to this country, and who must be allowed to enter and who will not be.
Resuming debate, the honourable member for Hamilton Centre.
Thank you very much, Mr. Speaker. I appreciate the opportunity to add my comments and interventions. Again, it's been said that we are supporting sending this to committee. There's obviously a lot more information that's needed. That's come out in the comments already, and I expect will continue for the balance of the afternoon. We have some, as the government has heard, Mr. Speaker, we have some strong feelings about this issue, and we have some further strong feelings and concerns about, well, why the government does this, the way they do it, the language that they use, and what their real intentions are. And that comes from just experience, watching this government in action. And so we will be supporting sending it to committee, and we will be fair-minded, and we will be even-handed, but we will stand by the principles that we believe in on the issue of new Canadians and those that are on the path to becoming new Canadians. And let me just say parenthetically before I get into my the substantive part of my comments, that let's recognize again that every jurisdiction in this country, whether it's federal, provincial, territorial, municipal, regional, townships, counties, they all recognize that attracting new Canadians to our country is not just a Canadian value, which would be enough for most of us on this side of the House, but it's a necessary component of our ability to move forward and have the kind of economy that's going to provide the jobs and quality of life that we've come to enjoy and that we want to continue and we want to make better for our children and our grandchildren. We need to be the country in the world that everybody else looks to and says, there's where I want to go. That's the country I want to go to because of the values of the country, the opportunities it would give me, but more than anything, Speaker, I think it's fair to say most of them would be thinking, that's where I want my children to be raised, my grandchildren, to give them the maximum opportunity. And so it matters when we have these debates. It matters what language we use, because we send messages when we do that. And you know, for the longest time, for the whole time that I've been here, federal Speaker, at the federal order of government, there has been a growing recognition that more and more new Canadians that come here who find that the jobs they were told would be here are not, that the profession they were told that they could continue in is no longer possible, when they saw all the promises that were made were not real, that they, number one, many of them don't stay. Far too many are making the decision down the road after 6, 12, 18, 24, 36 months to say, you know what? Canada's not what I thought it would be. It's not the dream that I thought I was going to live. It's not there. And they're sending that message back to their home country, to their family members and their friends and their colleagues who are saying, I want to come to Canada because that's the place to be. And they're saying to them, well, you might want to just slow down a bit because it's not always that way. Well, Speaker, that kind of messaging is the antithesis of what we need to send out. Again, if we're going to attract the kind of new Canadians that we want to come in here, to be a part of our great nation, and to help us fulfill and finish the job of building the kind of Canada that we want for our children and our grandchildren. This is the wrong message when you use language like this. I mean, they love to throw foreigners, criminals, crack down. You know, I lived through 8 years of that under Premier Mike Harris. Same language, same hot-button politics. It's not a coincidence that up until recently, the Chief of Staff to the Prime Minister was the Chief of Staff to Mike Harris, or that 3 of the senior members of this current government are former senior members of the Mike Harris government. So I've seen and heard a lot of this before. And it took a while. But eventually Ontarians got the message and understood what was really going on behind these names of bills that are the opposite of what they really do, throwing out these hot-button words, trying to create emotions, moving people by emotion rather than reason. These are all good political ploys. But at the end of the day, Canadians do figure it out. And when they did, that premier couldn't even face the electorate in the next election. He was so unpopular, in my opinion. He was so unpopular that he had to step down, and then another fellow stepped in. But people knew by then that it wasn't really just the leader, it was the whole government, and it was the whole approach. And Ontarians threw them out. And according to recent polls, they're not looking to bring them back anytime soon. And so a lot of my concern here is about that kind of thing. I'll have a little bit of time. I've used up a lot of it already. But we'll have a lot more time at committee level to do that, to look into these things. That's why we send things to committee, hopefully to have an intelligent review, bring in experts, let the public hear and read what we're reading, and then make our deliberations and our decisions. Canadians can draw their conclusions and decide whether they want to send each of us back here or not. So, it won't come as a big shock that my first concern is loading up another one of these ministers with even more power. Now, I realize that the concept of benevolent dictator exists, and one can only hope, if that's the structure. But that's all you're left with is hope. That's not really the way we do things in Canada. And removing checks and balances, making decisions unilaterally, pushing more into the political arena. Sometimes these are the right things to do. But we have real concerns about it in this application. And again, Speaker, that's why we want to send it to committee, so that these things can be looked at. But make no mistake, there are an awful lot of Canadians right now who, if you just ask them point blank, would you be in favor of giving the Prime Minister's ministers more powers, yes or no? Some would say yes. I think there'd be a vast majority that would say, if not no, they would say, wait a minute, why? And that's where we are. We're at the why. I'm giving comments that I have some concerns about this and going down that road overall. However, at the committee, we'll have an opportunity to answer that question, why? What are the reasons the government's giving for wanting these increased unilateral powers for the minister to have? And do they hold up against an examination of the problem that they're trying to solve? There are problems everywhere. The solutions, however, can either be appropriate to the problem, or they can be overwhelmingly way over the top, or it can be just a nice little fig leaf to put out in front because in behind there are other reasons why you want these powers. All these things are unknown at this point. We are highly suspicious, and not just because we're the official opposition, but because we know them. But again, we'll send it to committee and let's have a look. And the last one, and I don't have a lot of time left, so I won't be able to go far on this one. In fact, I would just point out that it was the whole idea that suddenly somebody could be removed without an appeal when they went to federal prison. But now we're going to move it down to 6 months. You know, there's a reason deuce less a day exists. There's a reason some people go to provincial institutions on a sentence of 2 years less a day, and other people are sent to the penitentiary where they're going to be there for many years, possibly decades, possibly the rest of their life. Two completely different worlds of criminal behavior. We need to ask the questions, and will ask the questions, why is it necessary to make such a dramatic change, again that results in unilateral action taken against people, removing their right to appeal? That's part of the Canadian way, is to give people their say, let them have their day in court. I didn't have time to get into what they attempted to do and are attempting to do in terms of health care for refugees, or the fact that they can bring in foreign workers and pay them 15% less. There's a whole lot of reasons why we have some serious concerns with what's being proposed, but we will support it going to committee. We'll roll up our sleeves and we'll do the work, and if it's a good idea, we'll support it, and if it's not, we'll take it on with every breath that we got.
Questions and comments? The honourable member for Edmonton Centre.
Well, thanks very much, Mr. Speaker, and I'm always entertained by the member from conspiracy theory over there. And I know he has strong feelings, and that's great, and that's what we need in this place. And we have strong feelings too. When he talked about the real intentions, the real hidden intentions of our government. Well, I'll tell you what our real intention is, and that's to protect Canadians. Canadians who are born here, Canadians who come here. You know, my friend talked about taking away appeals, and that's not the case at all, and he knows that. What we're talking about is limiting the appeals to something less than endless numbers and 7 to 10 years. I'll ask my colleague a question. He talks about minor crimes. Nobody's going to be thrown out or deported for minor crimes. And does he think these crimes that are punishable by at least 6 months are minor? We're talking about assault with a weapon, sexual assault, robbery, break and enter. Does this member think that those kind of crimes are minor, and that people who commit those crimes over and over again, and it's not the fact that they're immigrants, it's the fact that they're criminals. Saying that we're stigmatizing immigrants is simply nonsense, is simply rhetoric, and simply out of place. Does he think those kind of crimes are minor?
Member for Hamilton Centre.
Well, Mr. Speaker, I'd have to think that this member believes they're minor. Otherwise, he'd have private members in here that put everything into penitentiary penalty. I mean, the fact of the matter is there's a difference between speeding and a minor offense that gives you a 4 to 6 month sentence versus somebody who's been sent off to penitentiary for 20 years. There is a distinction there. And yes, we want to have a discussion about whether or not that should justify that kind of unilateral action. That's the whole point.
Questions and comments. The honourable member for Pontiac.
I think that I thank my honourable colleague for his speech. I know him to be a veteran in politics, and I always appreciate his candor. I wish I could be as forthcoming in my opinions as he is in such a eloquent way. What I'd like to ask is, I think that his main point was about, with all due respect to a Conservative colleague on the other side, I think his main point was about the concentration of power. And if we look at the pattern of this government over the years, it's been a pattern of the concentration of power in the PMO's office or in a minister's office. So I'd like my honourable colleague to perhaps expound on why that is a problem.
For Hamilton Centre.
Well, thank you very much, Speaker. I thank my colleague for the compliments and for the question. I mean, we do have good reason to suspect. I mean, my friend can play games with being a conspiracy theorist, fine. That's fine. I'll fully confess that after spending 8 years in a conservative House, one becomes very concerned about conspiracies. Absolutely. I have no problem with that. But what I really want to focus on is that the issue is, should the minister get more powers? And do we have a right? Well, we have the right. But is it reasonable that we would be so concerned about giving them that power? Let's remember, I mean, we don't have enough time to talk about the litany of abuse of power of this government, starting with our very democracy. This is the government that passed a law. They love laws. They had a law that says there will be an election here on this date. That's it. Final. We've decided. There's the law. And the first thing they did, ignored that law, set it aside because it didn't suit their purposes. That's the kind of thing we're worried about, Speaker.
Questions and comments? The honourable member for Edmonton Strathcona.
Speaker. Mr. Speaker, I'd like to raise a related question to the one raised by my colleague previously. And it's to this movement by this government increasingly to give all power with no criteria, complete discretion to ministers or some other authority to make decisions which impact the lives of people in Canada. And one of the things that concerns me with the comment, and I know it was meant in all good faith by the Conservative colleague across the way, the reply was it wasn't their intent. Can you please elaborate for the House? The very reason why you pass laws is to provide legal certainty. That's why the law has to be very clear and provide clear criteria for how that that discretion is to be exercised. So that's the very idea why you make law. Once that law is passed, there's no way that you can go in the government and say, well, that's not what we meant by that law. The law is clear on its face until it's tested in the courts.
Honourable member for Hamilton Centre, a short response, please.
Oh, Speaker. You make it very difficult, sir. Yes, sir. Well, all I can say is that you've answered the question yourself, and the member's a lawyer, so she knows far more about things about this than I do. But I'll just say this as a layperson. When we pass a law that says to somebody, you've been guilty of this or you've been found wrong, and we're going to take an action, and there's going to be a penalty, and it's going to hurt. It's going to hurt in some fashion in your life. We are also big believers that that person should be given their opportunity to have an appeal, to have a second opportunity for justice to be had if they believe it wasn't in the first case. When you put all that power in one human being, as flawed as we are, you're looking for trouble. You're looking for trouble, and that's if you go at it with the right attitude, and we don't even think they bring that to this issue.
Resuming debate, the honourable member for Saanich, Gulf Islands.
Thank you, Mr. Speaker. I'm very pleased to have the opportunity to speak today at second reading on Bill C-43. It's described as an act for the faster removal of foreign criminals. I really don't think if we were debating the title of the act, there'd be anything to debate. I think that a lot of Canadians, I can't imagine any Canadian who doesn't think that a foreigner who's a dangerous criminal shouldn't be removed from Canada. The difficulty with the act is, and this has happened lately with a number of the pieces of legislation brought before this House since I've been a member, I've been surprised how far they've morphed from the kind of titles of legislation I once studied in law school. It used to be you opened a statute and you found the book, not just the book was dusty, the title of legislation was just plain description, just a blanket description of what was at stake, immigration and refugee statute, or a law to deal with the Fisheries Act. Now we have titles that seem to come out of they probably don't just seem to, they probably do come out of focus group testing for legislative titles that will be zingers in future election campaigns. As someone who studied statutes, I find this a dismaying trend. I realized the other day while watching that U.S. program on HBO called Newsroom that this was invented first by the Republicans south of the border. I don't watch enough U.S. TV to have known that if I hadn't been watching Newsroom. Anyway, back to the topic. This piece of legislation, which amends the Immigration and Refugee Protection Act, definitely has merit if what it is about is getting rid of dangerous foreign criminals who have no right to be in Canada. I assert that what we have here, of course, is always going to be a question of balance. We don't want dangerous foreign criminals with no right to stay in Canada to be here, threatening Canadians who have every right to be here. But we also recognize that under the Charter of Rights and Freedoms, residents and citizens of Canada, permanent residents, have charter rights. And the question then is, have we got the balance right here? Are we protecting Canadians who are not a threat, or permanent residents who are not a threat to our society, and sweeping them up in a vast and sweeping discretion to the minister, which could do serious injustice to individuals who actually are important parts of Canadian society, who actually contribute in positive ways, and that we would not want to be caught up in a sweep that didn't take account of individual rights, individual situations, humanity, compassion, and holding families together, and other aspects that have always been part of the consideration before a deportation takes place. Now, when we ask if the balance is right in this legislation, I'm going to turn to some of the recent comments by members of the Canadian Bar. Toronto lawyer Mendel Green is quoted in this story from the Toronto Sun as saying, quote, "I am concerned about the monumental effect this will have on the immigrant community if it becomes law. This will be a life sentence for many people," unquote, Mendel Green. Lawyer Joel Sanderlook, at the same press conference representing the Ontario Criminal Lawyers Association, said, "This will destroy families who've been here a long time. It will create more criminals if parents or other family members are removed from Canada." Further quotes from other lawyers, lawyer Gidi Maman also said, quote, that the potential Canadians or Canadian residents who could be swept up and deported with no chance of appeal and without any exercise of individual discretion include, quote, "These are young children brought to Canada at a young age as permanent residents, raised and schooled in Canada, but never took out citizenship. It is unconscionable that a country like Canada, which has always allowed for second chances, to now embark on a new one strike, you're out approach." And lastly, I'll cite lawyer Andrew Schreck, Vice President of the Ontario Criminal Lawyers Association, who said that this law is drafted in such a way that it could quite easily sweep up people guilty of minor offenses and have them deported. In his words, quote, "We're not talking about serial killers, murderers, or bank robbers." Now, let's take a look at what kind of people could be swept up and what kind of crimes could be committed to be considered as having committed a crime for which there's no right of appeal. They're just going to be sent out of the country. This can be as described as crimes where someone is convicted for a sentence of 6 months or more. Now, the current law deals with crimes where sentences are 2 years or more. So bringing it down to 6 months or more for a crime for which the ultimate sentence could be as much as 10 years in jail really is bringing in a series of crimes that don't actually threaten the security or at least the safety of Canadians. In other words, it takes in a number of crimes that don't involve any threat of violence. In other words, not anywhere in this act, before deporting someone if they've been guilty of a crime committed and sent to jail for 6 months or more, nowhere in this new legislation is it required that that crime be a crime of violence or something that threatens the security of Canada. The kinds of crimes that they've listed that I found that might in fact fit this definition, for which you could get a 6-month sentence but a 10-year maximum, would include you could be, as a permanent resident, deported for possession of a stolen or forged credit card and use of that credit card knowing it had been canceled, unauthorized use of a computer or forgery, and a host of other offenses that carry 10-year maximums. Now, in that case, we're talking about no discretion, no appeal, and that in fact what could easily happen is that it could be a younger member of the family, a parent. So the fact that you're part of a fabric of a Canadian family, children born in Canada, relatives participating in Canadian society, any one member of a family guilty of something which is not in any way a crime of violence, if it's a 6-month sentence with up to a 10-year maximum, you're gone. You don't have a chance to plead your case. Now, I'm going to quote one other lawyer on this matter, and that I'm very proud to say is the current nominated candidate for the Green Party in Victoria in the by-election. His name is Donald Galloway. He's a founder of the Canadian Association of Refugee Lawyers and is also a professor of refugee and immigration law at University of Victoria. And in looking at this, he suggests that what we have, and I'm paraphrasing a bit, but there's an inherent legal balance built into the current Act, into Section 34. So the courts have accepted broadly defined prescribed grounds of inadmissibility that are found in Section 34.1, based on the assumption that these same sweeping inadmissibilities are balanced by the provisions of 34.2. What this new law, what C-43 will do, if enacted, is to fundamentally destabilize the legal balance by removing the layer of individualized, personalized, case-by-case review, guided by, in some cases, humanitarian concerns and compassion, that acted as a safeguard against the breadth of prescribed grounds for inadmissibility found in Section 34.1. Beyond issues of compassion and fairness, this ill-conceived change will force the courts, as they have already indicated, into a position where they are going to need to intervene and fix this Act to provide a reinterpretation to ensure that this Act remains constitutional. Otherwise, it's going to violate the Charter. Now, I want to just turn my attention, before I run out of time, to another section that I find particularly egregious, which doesn't deal with criminals, and it doesn't deal with people already in Canada. But if the minister, under the new Section 8, which changes Section 22 of the current Act, is dealing with a foreign national who has applied to become a temporary resident of Canada, the minister has unfettered, under this new provision, very unusual, unfettered discretion to make a decision to refuse that person the right to be a permanent resident of Canada with no criteria whatsoever, no objective criteria that can be measured. There's, let me just read the language. Section 22.1, which you find under Clause 8, Mr. Speaker, under this new C-43, allows the minister, on the minister's own initiative, to declare a foreign national that may not become a temporary resident if the minister is of the opinion that it is justified by public policy considerations. And this banishment can last for up to 3 years. Now, going back to my time in law school and legal drafting and statute interpretation, you don't find anything that gives you more freewheeling power to make up your mind which way you want than the language, minister is of the opinion. No court's going to be able to step in and say, well, we don't like the way the minister exercised his discretion or her discretion, because this will apply for all time. I'm not speaking of the minister at the moment. This is a permanent change to our legislation and a dangerous one. This says the minister is of the opinion, and then what? What is the minister of the opinion? That it's justified by public policy considerations. Again, you couldn't come up with something that gave you more freewheeling discretion, not bound by anything in particular. What kind of public policy considerations? Well, maybe the public policy consideration that we think we have too many of a certain kind of person in a town. Who knows? It's without objective criteria. So, Mr. Speaker, I hope that when this legislation goes to committee and is studied in committee, we can rebalance the balance that must be there. I stand here before you as leader of the Green Party, not in favor of keeping dangerous foreign criminals in Canada, but in keeping the Charter of Rights and Freedoms in Canada. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires? L'honorable député de Vaudreuil.
The honourable member for Vaudreuil-Soulanges.
I share many of the same concerns with the member from the Green Party. I do have the question, I'm not clear whether she will support this bill going on to committee. For instances, say if a war criminal was found, convicted war criminal, and questions like that. And would she not also agree with me that there's a question of priorities here with the government presenting this bill before the House when there's so many other problems that exist? The underemployment of new Canadians costs us $5.9 billion a year in losses because of their underemployment. We've hollowed out our foreign engagement, eliminating culture as a pillar of foreign policy, so we don't meet them on their soil anymore. We've hollowed out the system to integrate professional new Canadians, and now we've hollowed out Canadians' trust in new Canadians. So does she not agree with me that perhaps the government's priorities are misplaced, that even though we are supporting this at second reading, and we hope that she will join us in order to improve the bill at committee, does she not see a question of priorities?
The honourable member for Saanich Gulf Islands.
And I thank my friend from Vaudreuil-Soulanges for the question, Mr. Speaker. Yeah, with not just some, but with a lot of concern and mixed feelings, I will support sending this bill to committee. I'm not a member of that committee, and I will reserve the right I have as a member of the representing the Green Party here and representing Saanich Gulf Islands to submit amendments at report stage if I'm not satisfied that the bill has been rebalanced appropriately to reflect the Charter of Rights and Freedoms and respect for it. His question about war criminals is a good one. I mean, it sounds pretty much like a no-brainer. If someone's a war criminal, you don't want them in Canada. If someone's defied their government and committed crimes and spent time in jail. But every now and then a person like that gets honorary Canadian citizenship, like a Nelson Mandela. So the move under this legislation and other legislation, such as the mandatory minimums under C-10, the move is towards an authoritarian, automatic discipline which is unforgiving forever and lacks any compassion or humanitarian or even a thought process. And that I will always oppose.
Questions and comments. The honourable member for Edmonton Centre.
Well, thank you very much, Mr. Speaker. And I'm sure she didn't mean that, but I don't think she meant to refer to Nelson Mandela as a war criminal. But beyond that, and I'm sure she didn't mean that. You know what? When I talk to immigrants in Edmonton or anywhere else, they are some of the ones who are the most upset at others who come from abroad to be part of Canada as landed immigrants or permanent residents, whatever. They're some of the ones who are most upset about the people who get away with serious crimes. You know, get away with murder is the expression. That is true in some cases, a little extreme in most. But they're some of the ones who are the most upset about others who don't play by the rules, others who take advantage of Canada's generosity. Some would suggest over-generosity. Nobody suggests taking away somebody's rights or somebody's ability to appeal, but not to appeal endlessly for 7 to 10 years, time after time after time, when the evidence is clear. And it's simply the immigration industry prolonging this process. And it's immigrants themselves who are the most upset when I talk to them. They play by the rules, and they expect everybody else to play by the rules. Existing Canadians, natural-born Canadians, or new Canadians.
Honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. I thank my honourable friend for Edmonton Centre for catching me on that. I certainly didn't want to refer to Nelson Mandela as a war criminal. My point is that his history is written by the victors, and quite often you could find someone accused in another country called a convicted terrorist, called something that we would not want in Canada. But if you lose your ability to examine the particular circumstances, you lose your ability to think, you lose your ability to be truly Canadian. And I believe that what we want to do with this legislation is consider all of the ways in which it can go awry for what I'm sure is the minister's intention of bringing this forward. A family that's been in Canada for a long time with kids who've been in Canada for a long time, and someone finds themselves convicted of misuse of a credit card or of a forgery, this is no more chances, you're deported. And that can't be the Canadian way.
Before resuming debate, it's my duty pursuant to Standing Order 38 to inform the House that the questions to be raised tonight at the time of adjournment are as follows. L'honorable député de Alfred Pelin.
The honourable member from Alfred Pelin. Royal Mounted Canadian Police. The honourable member from Saint Charles, Employment Insurance. And the honourable member from Malpec, Ethics.
Member, l'honorable député de La Salle-et-Mar.
Honourable member from La Salle-et-Mar. Well, thank you, Mr. Speaker. Today I stand to speak in the House in order to speak of Bill C-43, which is a bill amending the Immigration and Refugee Protection Act, which we also call an act for the faster removal of foreign criminals. But before we speak, before I move on to the bill specifically, I'd like to talk to you about my riding. My riding, the riding of La Salle-et-Mar, and La Salle, which is currently celebrating its 100th anniversary, and was founded by Robert Cavalier-La Salle, who moved there hundreds of years ago, and was the ancestor of the one who moved here 300 years ago. Well, you can correct me. Perhaps I'm not quite right, but anyhow. The French established themselves there, after which the British did as well. Now, My riding presents a picture of Anglophones and Francophones who have managed to build this community together. But for the last several decades, La Salle-et-Mar has also hosted many newcomers, new Canadians. We have one of the largest Italian communities in Montreal, amongst the largest, including, there are some larger ones in the Isle of Montreal. These are well-established immigrants. We also have a sizable Chinese community and a sizable community from Southeast Asia, which is to say people who come from India, from Pakistan, and from other countries in the area. We have also had the good fortune of receiving immigrants from Northern Africa as well as other regions in Africa. So La Salle-et-Mar is a place that is very representative, I would say, of Canada, of many communities in Canada, which is to say it's a welcoming place. It's a place where communities share their daily realities and live together on a daily basis. Let me tell you that I'm very proud to represent that riding, because this riding provides me with the opportunity of meeting people from everywhere, people of all types, Quebecers, Anglophones, people of British and Scottish, Anglo-Saxon ancestry, and finally, people who come from communities across the whole world. As an MP, I have also set up a team that can welcome people and offer them services. Now, these services have a great deal to do with immigration in the case of these people. Mr. Speaker, for years now, our immigration system is terribly stretched. We are closing embassies, closing consulates. We are offering fewer and fewer services. It's more and more difficult for people to apply for visas or submit applications for citizenship or immigration, whatever the case may be. What's also happening here at Citizenship and Immigration Canada, once again, cutbacks, lack of resources, lack of human and financial resources in order to meet a never-growing demand. So what happens? These people come to their MP's office to see how, first of all, they can obtain information, obtain answers to their questions, which are perfectly legitimate, as are their applications and requests. So every week, Mr. Speaker, we meet with people who are whose situations may be quite simple. There may be a wedding in the family, and they wish to have their parents come and attend the wedding. And their visa requests are being refused. All the information's been sent, all the requested documents have been submitted, and yet the visa has been turned down. The visa application has been turned down. Why? Other people come to us with more complex problems. They're waiting for a loved one to come and join them. Or they might be refugees, but they've received a deportation notice. So this is the situation that's going on in all of our ridings. And every time, Mr. Speaker, every time it is an extremely human story that is brought to our office. People that Canadians cannot even, situations that Canadians can't even fathom. We Canadians have all our papers in order. It's easy for us to obtain a passport, a health insurance card, but some other people in the world are leaving these incredible situations that we can't even imagine. Famine, people who have lived in refugee camps. We cannot even imagine how you could come up with any type of permit or documentation of any sort. All of these difficulties, all of these tribulations, which sometimes and now too often end up on our desks in our writing offices. So now we are faced with this bill that aims to amend the Refugee Act. And once again, let me repeat the title. Removal of foreign criminals, rather, because now we're talking about foreigners in this bill here. Allow me to reiterate. The NDP recognizes the need to have an effective and efficient judicial system in order to be able to deport serious criminals who are not citizens. The NDP, although it is possible to work with the government to prevent non-citizens who have committed serious crimes from abusing our system of appeal without attacking human rights. So here's what I would like to say about Bill C-43. But, Mr. Speaker, here we are in Parliament, and there are rules. So the question that we're wondering, the question we should be asking when we are the government is, what is the foundation? What is the basis of this bill? Why is it being introduced? The question one must ask is this bill necessary? In our criminal code, do we have do we not already have in our criminal code the benchmarks that would allow us to prevent such situations? That's what I wonder, and that is the question that the government should be asking itself before introducing such a bill. The other thing is, does this meet an urgent, pressing need? A catastrophic situation that's going on right now in our system? So that's another question one might ask. Does this bill fill a vacuum? Is it justified? Is it justifiable as a bill? The other thing I want to emphasize, and this is a frequent tendency with this government, as many of my colleagues have emphasized, they prefer to take things out of the hands of the judiciary and move it into the political sphere. So they're going to transfer powers to the Minister of Citizenship and Immigration. I explained the situation to you. I explained the situation I face in my writing office. And I wonder if the fact of transferring these powers to one single person and bring them outside, make them extrajudiciary powers, would this not slow the system down even further? Are we not venturing into terrain that is far less objective, that would be in the hands of one single person? This is a concentration of power. These are all questions and issues that have been raised by this bill, and I would be very pleased to answer any questions. And I thank you for your attention and your patience. Thank you. Questions and comments? Parliamentary Secretary for the Minister of International Cooperation.
The member spoke at length about her riding and the wide range of people groups that she represents. I, too, in Newmarket Aurora, represent a community that has changed very, very quickly over the last 10 years and have been pleased to welcome into Newmarket Aurora people from every corner of the world, people who have come to Canada because in many situations they are, or in many cases, they are looking to escape from places in the world that have been plagued with difficulty and corruption. And so they've come to Canada because they are looking to raise their family in safe communities. And my question to my colleague is,
Why does she want to expose the constituents in her riding to people who have been deemed foreign criminals, dangerous to our society, dangerous to our communities, and these very people who have come here and played by the rules want to live in safe communities, which is what we are trying to establish? Why does she want it to be different?
The Honourable Member from de la Salle-et-Mar. Thank you, Mr. Speaker, and I thank my colleague for her question. In fact, I am in complete agreement with her in the sense that we all want safe communities in which people can live peacefully. What I'm wondering, however, is whether this bill truly fills a vacuum that exists in the criminal code, or problems that we're having in our criminal system right now, or our immigration system, in order to recognize people who are major criminals. Once again, this isn't clear to me, and will these things be will be cleared up in committee? What do they mean by serious criminality? Because I'm told that any sentence of 6 months and over is considered part of serious, under the category of serious criminality. Someone else talked about a violent crime. So I think we need to clear all these things up, quite simply.
Member for Winnipeg North.
Yes, Mr. Speaker, the Conservative member in her question illustrates why it is that this is an anti-immigrant bill, at least in good part, Mr. Speaker, because what she keeps on wanting to use is foreign criminal, these dangerous people. Well, Mr. Speaker, what we're talking about is permanent residents, and most of those criminals that she's referring to are not child molesters and murderers and drug addicts and so forth. To get a 6-month fine, you could have a 19-year-old that's lived in Canada for 17 years, never got their citizenship, and got caught with 6 plants of marijuana in their home, and they're going to be deported. The rest of the family stays, but they're going to be deported to another country, even though they've been here for 15 of 17 years, Mr. Speaker, because they didn't get their citizenship. And it's because all you have to do is read your own legislation. My question is the wording not important in terms of how the government is even labeling this issue, much like they use the term bogus refugee?
La députée de la Salle-et-Mar.
The Honourable Member from La Salle-et-Mar. I'll just quote an article that I was reading on this very subject.
Had the authority to strip landed immigrant status from a permanent resident convicted of a serious crime. But Bill C-43 would allow appeals only to those sentenced to less than 6 months in jail, down from the current threshold of 2 years. Alors, il y a déjà dans la loi.
So that authority already exists in the law. So is this act, is this bill really necessary? This is what I was wondering. Resuming debate, the Honourable Member from Louis Saint-Laurent.
Thank you, Mr. Speaker. I rise today in this House to speak to Bill C-43, an act to amend the IRPA. This is related closely to immigration, and some of these points are interesting, but some not so much. To give a brief summary, it gives the minister more discretionary power and the ability to decide on the admissibility of applicants for temporary residence. It means he does not have to examine humanitarian and compassionate circumstances. It modifies the definition of serious crime for the purposes of an access to the appeal process on a decision of inadmissibility. It increases the penalty for misrepresentation. And lastly, it clarifies the fact that entering the country through criminal activity does not automatically mean the person will be admissible. And Mr. Speaker, I just want to say something. I'm always a bit uncomfortable when we talk about immigration. For a simple reason, I'm not an immigrant myself. I live in the country I was born in. I don't have to wonder about things. I am here among the people I was born with, and my cultural references are the same as those around me. I've never had to consider emigrating as a possibility. If I went to live elsewhere, it would just be for a short time, and it would just be for a temporary stay. I know what I'm talking about because I lived abroad. I was the one who had to adapt. I had to make major efforts to learn how to function in a foreign language that I did not really know. The new social reflexes that I did not know about slowly became my own. In Russia, I changed. I became a little bit Russian. This subtle chemistry that operated means that I came away from Moscow being a bit more Slavic, and that will always be rooted deep within me. Other times, other places. But by having to adapt to this, I became more of a Quebecer and more Canadian. I understand more clearly what it means to be born in Canada. I could only observe that my relationship with my own country was one of confidence. I knew that Canada would always be there for me. And this gave rise to a feeling of pride. And I think everyone here knows what I'm talking about. I'm talking about my time in Russia today because I want people to think about things. By debating C-43 here in the House, I would like us to challenge ourselves on the relationships we have with foreigners. We're talking about the immigration system, and we have been since fall. I'm talking about C-4 and C-31. I'm pleased to speak to C-43 because it allows me to criticize the government. I'm dissatisfied with the tone they take to talk about immigration and refugees, but I'm even less satisfied with how they talk about things on the committee. I'm not trying to lecture anyone, but I need to distance myself sometimes from the unenlightened things people say. Pride in one's country should not lead to scorn for others. It should neither lead to excessive fear of foreigners. It's reductive and idiotic. I think that the government's interest for minority communities established in Canada is purely mercenary. The government is not at ease with immigration, even less so with refugees. I think that they see jihad warriors and smugglers everywhere. These are not accusations, but it's something I feel, and I apologize. This being said, C-43 is, among the government's 3 immigration reform bills, the least controversial. It talks about faster removal of foreign criminals. Now, who can be opposed to that? Not the NDP and not the Canadian public. We don't want to take in fallen tyrants, multimillionaire despots, and mafiosos. To support this bill, the government wants to show us lists of expert witnesses who agree that we should prevent access to this country by dangerous criminals. Well, yes, of course. Now, I can tell the government that no one wants criminals here, but I'm wondering what the government really wants to do. Is it to crack down on criminals and protect Canadians? This is the killer question because the answer is disappointing. Overall, C-43 gives discretionary powers, more of them, to the Minister of Immigration. He will decide who can stay and who must leave as soon as possible. So he becomes a kind of James Bond with 28-hour days who's protecting Canadians from the big bad foreigners. C-43, like C-4, increases the minister's arbitrary powers. I'm aware that we need to crack down on criminals who want to come here and endanger the tranquility of our communities. No one would ever deny that or be opposed to it. But why should it be the minister again who decides? The answer is clear. To cut short the appeal procedures that are launched by those who are accused of crimes. So the minister can decide to kick out anyone who goes to appeal, or everyone who goes to appeal. This is supposed to save us time and money and put the problem off indefinitely. If we make the problem disappear, we're solving it, right? This is worrying because it says that it's attacking a specific and urgent problem, but it creates a legal void in the possibility of arbitrary measures. Where do the minister's powers stop? I simply want to say to the government and to the minister that the awarding of discretionary powers is not the solution to all problems. The minister can't orchestrate everything all by himself in his office as soon as an exceptional case arises. That's not a system. That's despotic. Here's something else important. They want to prevent all members of a family of someone who is accused of a crime from visiting Canada. They want to cover everything. The idea is perhaps that the family of a mafia or a gang would not have access to the country and therefore could not bring their problems with them to our country. Sure, that's a good idea. But these are exceptional and rare cases. Whereas the minister's discretionary powers are not episodic. They'll be enshrined in law and will create a permanent legal void. This is a daunting task. We'd have to index all the families of criminals and stop them. But the departments have made cuts, and it would have to be done quickly with reduced staff. The government wants to clear up the backlog in the immigration system by creating major research tasks for the employees in the immigration officers. So I think that the foundation is sound, but the structure is weak. We want to create Canadians and better control immigration. The NDP believes that immigration is an unheard of, unprecedented source of a resource for this company, and we want our system to be effective, professional, and swift. The NDP also recognizes that we must act to make sure our system is not abused. The government is trying to solve problems, but it's going about it the wrong way. We believe this bill is good and should be moved to committee. It has many good things that need to be supported. The NDP is particularly happy that this bill would be exempting victims of smugglers and that their status of victim will be guaranteed, so they're not going to throw the baby out with the bathwater. I listened to the Minister of Immigration's speech when he presented this bill, and I feel rather alienated when I hear him peppering his speech with the word foreigner to designate people who have not officially received their Canadian citizenship, even though those people have their permanent resident status. We are all descendants of immigrants, without exception, and I'm tired of seeing them dismantle things that has taken decades for Canada to build. Canada has a reputation as a country that is compassionate, fair, and just. It knows when to stand up, when to say yes, and when to show people the door. Now, the government can say that it's tripled this or that budget, but the truth is that in a department like immigration, it is not money that changes things, because we're not dealing with figures. We're dealing with human beings, people who have had less fortune than us. And so I think the government should stop hiding behind its columns of figures. In closing, Mr. Speaker, I'm aware that the Conservative government is trying to reform the immigration system, but it doesn't seem to be too interested in that. Because as soon as the word immigration is uttered on the other side of the House, they also use the word economic. They don't understand that certain departments have obligations towards the public, and they are not companies that simply are made to bring in profits. You don't run a country like you do a corporation, but with them I'm wasting my breath. Some institutions are there for reasons other than systematically economic reasons. The immigration is an inevitable world phenomenon and will rise with the years to come. It would be advisable that Canada should organize its immigration system with people who are not purely focused on economic interests. Thank you, Mr. Speaker.
Before we start the questions and comments, I just observed that there are many times when many members wish to pose questions, and we only have 5 minutes for questions and comments. So I would ask honourable members that wish to pose questions, and I'm sure that's the case, that they keep their questions and responses, I must say, to no more than about a minute, so as many members will have the opportunity to pose questions. Questions et commentaires. L'honourable député, the honourable member for
questions and comments.
Mr. Speaker, I thank you for that, and I'll do my best. I can indicate, this bill, and I've made reference to it before as being an anti-immigrant bill. I've stated that, even in the title, using a faster removal of foreign criminal acts, and I would say that just because it implies something in the name doesn't necessarily make it a good bill. A lot of Canadians have serious concerns in regards to serious crimes that are offended or take place, and they want to see some sort of a consequence to those crimes. We recognize that. My question to the member is, does she have any difficulty with the government using words like foreign criminals as opposed to permanent residents, much like they used bogus refugees to try to send an indirect message that's very negative towards immigrants?
The honourable member for Louis Saint Laurent. Thank you, Mr. Speaker, and I'd like to thank my colleague from Winnipeg for his question. I agree wholeheartedly, and I even said so in my speech. When I hear people on the other side, on the government side, using the term foreigners to talk about people who live here, who are permanent residents, I feel horrible. And especially when we talk about the Minister of Immigration, who should be the champion, the person who's defending the cause and who's there to help these people. And then when we're talking, for him to use the word foreigner, and especially in French, the word means, it comes from the word strange. And so we don't want to be associated with that. So it is very troublesome to hear them using these terms, just like when we talk about serious crime. On many occasions, someone who is considered a dangerous criminal. Well, in some cases, we're not sure that that's the case.
Comments? Question and commentaire. The Honourable Member for Edmonton Strathcona.
Thank you, Mr. Speaker. I'll try to be short. But I have to, at the beginning, commend my colleague for incredible speech. She always grounds her speeches in personal experience. And if she was still an immigrant, I would happily, if I were the minister, immediately make her a citizen. Two issues through the Speaker to the Honourable Member. The first one is we've had a frustrating situation in Edmonton and all of northern Alberta where the minister has delayed for over a year to reappoint a citizenship judge. I am getting letters and calls and crying applicants waiting more than 18 months simply to have their application considered. So does she think at the same time that the government is reaching out to make things even more difficult for landed immigrants? Perhaps they could put more programs in place to provide employment and support to youth who might get in trouble and avoid potential deportation, and perhaps those who potentially could be good citizens become Canadian citizens.
The Honourable Member for Louis Saint Laurent. Absolutely, Mr. Speaker. First, I'd like to thank my excellent colleague from Edmonton Strathcona. This issue, you know, when there are situations like the one my colleague explained, these people are in a situation that is so difficult to understand for people like us who we're in our own country, we've grown up here, we've lived here, and all of a sudden you've got people, they arrive here, they perhaps don't know the language very well, they're completely disoriented, and instead of helping them and supporting them so that they can contribute to our society, to our country that we love, instead we tell them, well, you know, it might take a long time, and we try and discourage them. We really put a lot of obstacles in their way. And so the message that they want to send is, well, we're not sure that we really want you. So it's very difficult for these people. And, well, instead of sending them towards crime, we should help them.
For a third short question,
the Honourable Member for Marc-Aurèle-Fortin. We noticed in this new bill that there is a great deal of discretionary power given to the Minister of Justice. So could the member tell me about the importance of separating the legal, executive, and administrative branches? The Honourable Member. Well, I think the risk in this situation is that there will no longer be any kind of judicial independence. It will be a completely arbitrary decision, and it will be according to the minister's criteria. He may change them from day to day, who knows? So we need something with established criteria, and it should be up to the judge, not the minister.
Debate. The Honourable Member for Nanaimo-Cowichan.
Thank you, Mr. Speaker. And I'm rising to speak on Bill C-43, an act to amend the Immigration and Refugee Protection Act. And in the brief time I have before me, I, of course, can't go over chapter and verse of the act, but I want to mention a couple of sections because there are these aspects of the act that I want to focus on. What Bill C-43 does is concentrate more power in the hands of the minister by giving him new discretionary authority over the admissibility of temporary residents. It relieves the minister of the responsibility to examine humanitarian circumstances, changes what constitutes serious criminality for the purpose of access to an appeal of a determination of inadmissibility, increases the penalty for misrepresentation, and clarifies that entering with the assistance of organized criminal activity does not on its own lead to inadmissibility. And Mr. Speaker, in case there's any confusion, New Democrats are supporting this legislation to get it to committee. And I want to quote from the member from Newton North Delta, who, as our immigration critic, as the NDP immigration critic, has done a tremendous amount of work on this file. And in her speech on September 24th, she indicated that she wanted to make it clear that as New Democrats, we recognize the need for an efficient and responsive judicial approach to the removing of serious criminals who are not citizens. All Canadians want a tough approach to non-citizens who commit serious, often violent crimes in our communities. Newcomers in our communities, the vast majority of whom are law-abiding and follow the rules, would be among the first to agree with this sentiment. But she does go on to say that we do have some serious concerns about the bill being proposed. One of the concerns that she outlined in her speech was that it, again, concentrates powers with the minister. And part of the concern that the member raised was the fact that our immigration system, she says, does not need to be more politicized than it already is. And, of course, whenever we start seeing increasing concentration of powers in a minister's hands, what it does is remove parliamentary oversight from some of those activities and removes it actually from the department itself, who often operates at a more arm's-length way. There was a couple of other things that she raised in it, and one of the other items was that another troubling feature for us in the bill is that the bill relieves the minister of the responsibility to examine humanitarian circumstances, taking into account the interests of children affected. In our view, ignoring the interests of children is not something ministers should be relieved of. I want to touch just very briefly on the issue about war resistors. Now, of course, war resistors at the time weren't permanent residents, but it's been an issue that has come to this House a number of times, including a motion that supported allowing war resistors to remain in this country. And we recently had the case of the war resistor Kimberly Rivera, who asking the government to grant permanent residency status on humanitarian and compassionate grounds. And the NDP British Columbia caucus had written a letter to the minister indicating that we join prominent Canadians and international advocates, including Nobel laureate Archbishop Desmond Tutu, in calling on you to allow Ms. Rivera to stay in Canada and stay with her family. And it goes on to talk about the fact that Ms. Rivera had children in the country while she was living here, and that there were many other factors to consider. I want to mention another war resistor who unfortunately was deported from my riding a couple of years back, and it was a young man named Cliff Cornell, who had been living on Gabriola, a quiet young man. He joined the forces in the United States. It says that Cornell grew up in Mountain Ark Home, Arkansas, and in 2002, after leaving high school and with few employment prospects, he accepted a $5,000 signing bonus for a career in the U.S. Army. And a few months later, the U.S. went to war against Iraq. He deserted and came to Canada in 2005 to avoid combat. Mr. Speaker, it was a case of a young man who grew up in very, very poor circumstances and ended up not perhaps really understanding what he was getting into, and ended up coming to Canada, was well liked and well supported by the community on Gabriola. He found a job there, was a responsible citizen, and yet ended up being deported. With regards to Bill C-43, there was a recent article in the Star that said it started off with Bill could exile thousands of permanent residents for minor crimes. And in this article, it indicated that under a proposed new law, thousands of permanent residents could lose their status and be deported for minor convictions from shoplifting to traffic offences and drug offences, warns Canada's top immigration lawyers. These are young children brought to Canada at a young age as permanent residents, raised and schooled in Canada, but never took out citizenship. They go on in this article to say that the federal government has always had the authority to strip landed immigrant status from a permanent resident convicted of a serious crime. But Bill C-43 would allow appeals only for those sentenced to less than 6 months in jail, down from the current threshold of 2 years. And as the member from Newton North, our immigration critic had pointed out, was the fact that with some of the changes in the conservative crime legislation with the mandatory minimums, you now see people getting sentenced for some minor crimes to more than 6 months, and so they won't be eligible for any kind of process under this new legislation. They also talked about the fact that people may have misrepresented themselves when they applied for immigration. They point out that there could be honest omissions on a person's employment history, or incorrect dates of certain events written down on an immigration application could come back to haunt the immigrant years later. And they've also indicated in here that it's very likely that this could face a court challenge under the Charter of Rights and Freedoms, given previous Supreme Court of Canada decisions directing that authorities must consider humanitarian risk factors before deporting a person. So, Mr. Speaker, I think you can see that you know, again, I want to reiterate the fact that New Democrats are in support of getting this bill to committee, but what we are calling on the government is to consider looking at some amendments that could actually make this bill a better bill. So I'm going to end on that note, Mr. Speaker. Thank you very much.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Finance.
Thank you, Mr. Speaker. And I'm a bit shocked by what I just heard by my honourable colleague. I was a police officer for quite some time in the city of Winnipeg and dealt with what my colleague referred to as minor offences on a number of occasions. And so I'm quite shocked when I hear my colleague refer to these offences that are punishable by at least 6 months as being what she termed minor. Offences like assault with a weapon, sexual assault, robbery, break and enter. These to me are not minor in any way, shape or form. These are crimes that involve victims. And so I would ask my learned colleague if she would clarify, does she really stand by what she just said when she says that these crimes, sexual assault, assault with a weapon, robbery, these punishable by less than 6 months crimes, by at least 6 months crimes, that they are minor?
For Nanaimo Cowichan.
I'm perfectly happy to correct the record. I was quoting from Canada's top immigration lawyers who said, under a proposed new law, thousands of permanent residents could lose their status and be deported for minor convictions. This was the immigration lawyers who were saying this, Mr. Speaker. I was not saying it. I was quoting from an article. I want to quote, however, from the member from Newton North Delta, who says that I want to make it clear that as New Democrats, we recognize the need for an efficient and responsive judicial approach to removing serious criminals who are not citizens. So I want to be clear. I'm going to repeat that. New Democrats want to see a responsive judicial approach to removing serious criminals. So I hope that's clear enough for the Parliamentary Secretary, Mr. Speaker.
Questions and comments. The Honourable Member for Pontagny.
Thank you, Mr. Speaker. I was a correctional services office for some time, and the comments made by my honourable colleague are very good. I saw the situation. Our position is clear. Victims are always important, but we can't forget about the people who come here, the conditions that they live in their own countries, what they faced. We've heard a colleague talk about malnutrition, about illness, about torture. So taking our problems and sending them somewhere else isn't a problem. And inviting people here and saying, oh, no, we don't want you anymore, that we're an exclusive club, we'll be sending you back, without taking the time to share the wealth of our society, the well-being of our society with them is a serious problem.
Well, thank you, Mr. Speaker, and I want to thank the member for that question. And of course, part of the concerns that New Democrats have raised is that it concentrates far too much discretion within the minister's hands, and it also modifies that issue around humanitarian and compassionate grounds. And of course, Canadians have long been known for their approach around examining humanitarian and compassionate grounds, and it would be a shame if Canada stopped looking at that in the context of reviewing these kinds of decisions.
Questions and comments. The Honourable Member for Winnipeg North.
Thank you, Mr. Speaker, and I'll be brief with my question. When we talk about the individuals that this legislation could potentially impact, what we're talking about is a lot of young people, young families. So you could have an immigrant family that came to Canada 15, 16 years ago with a child that's 5 years old. 18 years old is caught doing something that's inappropriate, such as growing marijuana in the garage or something of this nature, more than 6 plants, which automatically says it's a 6-month minimum sentence. And this individual would then have to be deported. The rest of the family can stay, but where this particular individual youth would actually have to be deported, no chance for an appeal. And I'm wondering if my colleague would comment on issues of that nature, which are very real.
Member for Nanaimo Cowichan.
I want to thank the member for that question, and he hits on a very good point. And in fact, the immigration lawyers who have raised concerns about this have raised that very issue. The lawyers are saying that the law will target permanent residents, many of whom arrived in Canada at a young age and were raised, educated, and established families and businesses here. And it would seem reasonable that those kinds of circumstances were taken into consideration when a file was being reviewed. So the member is absolutely correct. And again, the New Democrats are supporting getting this bill to committee with a hope that these kinds of clauses in the bill can be amended so they more reflect what has been a tradition in Canada.
Resuming debate. Reprise de débat. Is the House ready for the question? Yes? La question est la suivante.
The question is as follows. Mr. Kenny, Calgary Southeast, seconded by Ms. Abloncy, moves that Bill C-43, an act to amend the Immigration and Refugee Protection Act, be now read a second time and referred to the Standing Committee on Citizenship and Immigration.
To adopt the motion. Yes? All those in favor of the motion will please say yea. All those opposed will please say nay. No! In my opinion, the yeas have it. Call in the members. Oh, the Chief Government Whip is rising on a point.
Mr. Speaker, there have been discussions among the whips, and I believe if you seek it, you will find agreement pursuant to Standing Order 45-7 to defer the vote of this motion to the end of government orders on Tuesday, October 16, 2012.
We just go ahead. Does the Chief Government Whip have the consent to propose the motion? Yeah. The honourable members have heard the terms of the motion. Is it the pleasure of the House to adopt the motion? Yes. So accordingly, the deferred division stands deferred until Tuesday, October 16th, at the end of government orders, if I recall. Is there agreement to see the clock at 5:30? Agreed? Agreed and so ordered. It being 5:30, comme il est 17h30,
It being 5:30, the House will now proceed to the consideration of private members' business as listed on today's order paper.
Private members' business, consideration of motion M388 on firefighters. In the name of Mr. Goodale.
Mr. Goodale, seconded by Mr. Kuzner, moves that the House hereby affirm its support for the following measures to support Canada's firefighters, which, in the opinion of the House, the government should act promptly. Act upon promptly. A, the creation of a National Public Safety Officer compensation benefit in the amount of $300,000 indexed annually to help address the financial security of the families of firefighters and other public safety officers who are killed or permanently disabled in the line of duty. B,
B, the recognition of firefighters in their vital role as first responders, as an integral part of Canada's critical infrastructure, and as healthcare workers under the Canada Influenza Pandemic Plan, entitled to priority access to vaccines and other drugs in cases of pandemics and other health emergencies.
The specification of firefighter safety as an objective of the National Building Code of Canada, and D, a review of the National Building Code of Canada in conjunction with the International Association of Firefighters to identify the most urgent safety issues impacting firefighters and the best means to address them. Debate. The Honourable Member for Wascana.
Thank you very much, Mr. Speaker. It is
my great pleasure today to begin debate in the House of Commons on my private member's motion M388 about firefighter safety. After years of patient and persistent presentations to various parliaments by firefighters from every corner of Canada, M388 draws together in one motion the three specific requests that Canadian firefighters have been making over the years to achieve greater acknowledgement of the risks inherent in the work that they do. None of us can doubt for a moment how valuable these courageous men and women are. On a routine basis every day, they put their lives on the line so the rest of us can live in safe and secure communities. And it's not just about fighting fires, as crucial as that in itself is. It's also about being first responders, the people most likely to be on the scene first in response to all manner of emergency situations. It might be a traffic accident. It may be a hazardous spill. It could be a heart attack or a drowning. It could be a house fire or an industrial blaze like the one that lit up Winnipeg just a couple of nights ago. Whenever Canadians reach for the phone and dial 911, they expect top-notch rescuers to be on the road in seconds to help them out of a dangerous situation. Lives are at risk. The circumstances could be and likely are perilous for both the victims and the rescuers alike. But we know that we can count on the skill and expertise of Canadian firefighters to respond quickly, in the most effective manner humanly possible, and with the bravery and the compassion that these situations often demand. And here's a sobering statistic, Mr. Speaker. Every year in Canada, on average, some 18 firefighters give their lives in the line of duty. On the one hand, some may say that that sounds like a low number, but think about it. It means every 3 weeks, somewhere in Canada, a firefighter dies on the job. Every 3 weeks, the ultimate sacrifice in service to the public so others can live and be safe. I think it's appropriate and proper for the Parliament of Canada to examine ways in which the Government of Canada can respond constructively to the three simple ideas that Canadian firefighters have been advancing for years to better promote their safety. It is a matter of common sense. It's a matter of fundamental respect for the invaluable service performed by these members of our society. These are issues that cut across all party lines, and I am grateful for the support and encouragement for 388 that has come from all sides in this House. Let me also thank the International Association of Firefighters and a great many other individual firefighters, both professional and volunteer, along with many other public safety officers in this country who have endorsed this motion and urge all Canadians to get behind it. The 3 points that are covered in 388 are these. First, the motion recommends to the government the creation of a public safety officer compensation benefit. This would be a one-time payment of $300,000 to be paid by the Government of Canada to the family of a firefighter or any other public safety officer who is killed or permanently disabled in the line of duty. In principle, this is not unlike the Community Heroes Fund that was in the public domain for debate a few years ago, and it was a very popular concept. The idea acknowledges the service and the sacrifice of those whose jobs inherently put them at risk to protect the public. It helps to ensure their families are well taken care of. A public safety officer compensation benefit parallels certain provisions in some federal collective agreements for the military and for the RCMP, for example. But sadly, for most Canadian firefighters, they are simply not in a position to bargain for a provision like that, or their employers, usually municipal governments, are not in a position to provide it. So M388 offers a way to treat all public safety officers equitably while fully respecting every level of government jurisdiction. And the estimated cost of this measure is in the range of just $10 to $12 million per year. On an annual federal budget of more than $250 billion, the annual cost of a public safety officer compensation benefit is equivalent to the tiniest of rounding errors. It is also worth noting that a similar benefit has been in effect in the United States for decades, since 1976, a federal benefit provided to all U.S. firefighters at every level as a gesture of national responsibility and respect. The second major feature of Motion 388 deals with the priority lists that are prepared by governments to serve as guides, not binding legal edicts, but guides for the distribution of sometimes limited volumes of vaccines and other drugs during pandemics and other public health emergencies. The basic question, Mr. Speaker, is who gets the vaccine first? It's a tough judgment call. Difficult choices have to be made. In broad terms, when you look at the protocols from previous pandemics, there are three general categories of vaccine recipients. The first, of course, is those Canadians who are most vulnerable and at the greatest risk of getting sick, the primary victims, if you will. The second category, with virtually equal priority, is those primary health care givers who take care of those vulnerable people and those at greatest risk. And then third, there is the general public. Within these broad groupings, there are certain subsets, but the concern of firefighters is that this general hierarchy of priorities for receiving vaccines during public health emergencies appears to rank firefighters in the third category, that is, with the general public, or at the very bottom of the category about caregivers. Firefighters submit, and I agree, that as guidance to those who carry the serious responsibility to implement vaccine sequencing during emergencies, firefighters should consistently be at the top of the grouping of caregivers, as is the case in the United States and in many other jurisdictions. And I say this for two reasons. First, at all times, and especially during times of public stress like a pandemic, Canadians need to know that their crucial public safety agencies, like fire departments, are fully functional, fully staffed, up to strength, and ready to go no matter what. We don't need and we don't want a compromised firefighting system on top of a pandemic. But secondly, and even more importantly, most firefighters are first responders who function as frontline healthcare workers dealing in raw circumstances with people in trouble, in traffic accidents, and so many other emergency situations. They do the initial rescue, the assessment, the first aid, the primary treatment. During a pandemic, they will undoubtedly be exposed to people in respiratory distress and suffering other ailments. Firefighters need to be able to do their frontline, first responder, health care worker jobs with full confidence and the full assurance that they are as secure and functional as humanly possible. If firefighters cannot do that job at the scene of a public emergency, then at least some of those suffering from pandemic diseases will simply not make it to the doctors and the nurses who will be waiting for them in the emergency room. Finally, Mr. Speaker, M388 deals with the National Building Code of Canada. It makes the simple and logical point that firefighter safety should be included among the objectives of that code. It's not already there, you ask? That's a question that a lot of Canadians have asked. And the answer is, well, in the United States it's there, and in many other countries it's there, but not clearly in Canada, especially with the advent of rapidly changing construction techniques and building materials. 25 years ago, a typical building might take 15 to 20 minutes of burning before it became a full-fledged blaze. And that left a fair bit of time. Obviously, an urgent situation but a fair bit of time for firefighters to arrive on the scene and to rescue people and property from the scene of the fire. But today, what used to take 20 minutes 25 years ago may now just take 3 or 4 or 5 minutes. And it's not good enough to say building code standards designed for, quote, occupant safety serve just as well to achieve firefighter safety. The two are not the same for this fundamental reason. While occupants will be doing their very best to get out of a burning building just as fast as they can, firefighters, by the nature of their jobs, will be going into the building, into the teeth of the blaze, to work as long as they can to rescue victims and fight the sources of the fire. And that's why firefighter safety needs to be specifically included in the code. And that's also why the government needs to review the code urgently, and to do so in cooperation with firefighters themselves and other experts that can identify the areas that need to be addressed and work on the best possible solutions. Well, Mr. Speaker, that's it. 3 simple things in motion M388. First, an affordable benefit for the families of public safety officers killed or injured on the job. Secondly, an appropriate high-priority ranking for firefighters to receive vaccines during pandemics, particularly in their critical role as first responders and healthcare workers. And thirdly, the inclusion of firefighter safety in Canada's National Building Code. These measures have huge support among firefighters and most Canadians across the country. They are practical, modest, fair, and reasonable. They are consistent with international standards. They are important gestures of respect from the Parliament of Canada to the firefighters of Canada. And I would ask all of my colleagues in the House of Commons to support these measures during this debate and to support 388 when it comes to a vote later this year. Thank you.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Public Safety.
Thank you very much, Mr. Speaker, and I want to thank my honourable colleague for his comments. I have 2 specific questions. The first one, I'm sure he's maybe he would be expecting this question. When he was the Minister of Finance back in 2005, a very similar bill was brought forward, and he would, I'm sure, recall voting against it. And I think it would be good, we would all appreciate knowing why he voted against it then and why he would be introducing it now, which would appear to be a contradiction. And I also am wondering if my honourable colleague could also explain his definition of a public safety officer is very broad. Would he want to see included CBSA officials, RCMP, municipal and provincial police, conservation officers, CSE, Correctional Service Canada, basically any, is he wanting to include any public safety officer within the purview of this motion? Thank you, Mr. Speaker.
The Honourable Member for Wascana.
Mr. Speaker, on the first question, priorities change over time. And I'm happy to inform the Honourable Member that my view on this situation, on this particular proposal, has changed, especially in relation to the fact that M388 now includes all 3 of the proposals that the firefighters have been making and puts them forward as a package. And I think that's the proper way to deal with them. I certainly appreciate the fact also that on both sides of the House, to the extent there are members here who were there in 2005, I think was the last time the motion was called, have voted overwhelmingly in favour of measures very similar to what are in bill or in motion 388. So I'm encouraged that there is, I hope, a decent opportunity for this measure to get through. On the question of public safety officer definition, I have specifically not defined it in the motion because, for one thing, as a technical matter, it would take a motion of some length in order to include all of the appropriate references. From my perspective, clearly, Firefighters fall within that definition. Police officers fall within that definition. Emergency medical technicians from our EMS systems fall within that definition. There is in the Income Tax Act a definition of public safety officer, which to some extent would serve the purpose of this motion, but I don't think it exactly fits the situation because it was written for tax reasons and not for all of the reasons that are included in 388. But I have left the job and the opportunity to the government of the day to craft the right frame around those words, public safety officer, to make sure that it is given the professional and detailed expertise that the government would have available to it that an individual member would not. And I think that's the fair way to do it, so that the government would hold the pen on the drafting of that.
Questions and comments? The Honourable Member from La Salle-Mar. Thank you, Mr. Speaker. I would like to thank my colleague from Wascana for having tabled this motion. I have, in fact, met with the Firefighters Association, and they did mention some of the recommendations that were included in his motion. Some of the concerns that were raised during the course of my meeting with them. I congratulate my colleague for having put forward the recommendations made by that association especially. I would like to know if you could tell us more about the notion of making buildings safer. Could you tell us a bit more about that, please? I would listen with great interest.
The National Building Code of Canada relies upon the National Research Council as its centre of expertise, and the NRC has been providing that expertise for a very long number of years. But one of the specific items that firefighters have raised with me is the design techniques in buildings that tend to use lighter materials, materials that burn more quickly, and materials that, particularly in the floor construction, may be prone to earlier collapse when exposed to flame, and sometimes even just to heat without the flame. So I think it is that sort of thing that firefighters are concerned about. Building materials that burn hotter, faster, more intensely, which is part of the explanation for why a fire 25 years ago might take 20 minutes to get into a blaze, whereas in this day and age it might only take 5 minutes. And I think firefighters would want that issue seriously examined, and they're prepared to cooperate with the government to provide expertise to make sure the right technical answers are found.
Resuming debate. The Honourable Parliamentary Secretary to the Minister of Public Safety.
Thank you very much, Mr. Speaker. I'm pleased to have the chance to speak to the motion that's been put before us today from the member from Wascana. The motion covers a lot of ground with implications for the Department of Public Safety, Industry Canada, and the Public Health Agency of Canada. Part A of the motion, which falls under the purview of Public Safety Canada, calls for the creation of a National Public Safety Officer compensation benefit to help the families of firefighters and other public safety officers, which is not defined, but who are killed or permanently disabled in the line of duty. Part B requests the firefighters and other public safety officers be provided with priority access to vaccines and other drugs in cases of public health emergencies. This would fall within the responsibility of the provinces and territories for implementation. And Mr. Speaker, one of my colleagues will be addressing this point in more detail. Part C and D, which falls within the focus of Industry Canada, calls for changes to the National Building Code, including specifying firefighter safety as an objective of the code and reviewing the code to identify urgent safety issues for firefighters. I will focus my remarks today on the public safety aspect, namely that of creating a public safety officer compensation benefit. Mr. Speaker, our government has been a strong advocate for our first responders and particularly for our firefighters. All of us in this House agree that our firefighters deserve our respect and support, as do our police officers, paramedics, and all other emergency and first responders. Sacrifice, bravery, and courage. These are the words that come to mind when we think of these individuals. Every shift, Mr. Speaker, they make a conscious choice to save lives, to protect their communities, to make a difference, and to put their own lives at risk. When the beeper goes off, when the fire alarm sounds, there is no hesitation. Day or night, firefighters are willing and ready to go to work. They know, Mr. Speaker, that they can face moments of extreme danger where the lives of citizens, their colleagues, and certainly their own are at risk. Mr. Speaker, they also do experience great moments of pride when they rescue someone and they know that the work that they've done has made such a huge difference. Firefighters have just the right amount of mental toughness and courage that's required in these moments, and when they put themselves in harm's way for the rest of us, we all stand in gratitude. We respect their courage and their professionalism, and our government has proudly supported the work of our firefighters, along with all of our public safety officers, through a variety of initiatives and programs since 2006. For example, Mr. Speaker, in Budget 2007, we included a contribution of $2.5 million over 5 years to the International Association of Firefighters to support and implement hazardous material training. This is a very worthy investment that has provided thousands of hours of hazmat training to firefighters and many other first responders right across Canada. And Mr. Speaker, we're very proud that in Budget 2011, our government introduced a volunteer firefighters tax credit to support the volunteer firefighters who perform at least 200 hours of service for their communities. There are more than 85,000 volunteer firefighters across this country, serving in both urban and rural settings. And Mr. Speaker, in my riding of Portage-Lisgar, there is no way our communities could be protected if it was not for the volunteer efforts of firefighters, brave men and women who volunteer their time. Our government has been listening to firefighters, we listen to their concerns, and that's why we introduced the Volunteer Firefighters Tax Credit. The credit recognizes and supports the critical role that these volunteers play in all of our communities. We also support first responders through the development of national policies and by supporting consensus-based national code development processes and response systems and standards. For example, Mr. Speaker, our government actively participated in the development of the chemical, biological, radiological, and nuclear and explosives resilience strategy and action plan for Canada, which was launched in January 2011. This plan sets out clear guidelines for policy and decision makers at all levels of government on how to better prevent, prepare for, respond to, and recover from any CBRNE event. These guidelines ultimately protect our first responders, including our firefighters. And, Mr. Speaker, we also launched the Communications Interoperability Strategy and Action Plan for Canada in January 2011. The goal of this action plan is straightforward, and again, something that first responders have been asking us for, and we're listening. The goal is to help first responders to respond rapidly to any emergency by allowing them to communicate more effectively and efficiently across jurisdictions. As part of this, Public Safety Canada and the first responder community have urged Industry Canada to set aside dedicated bandwidth for public safety use in the 700 megahertz spectrum auction. This past June, we announced that an initial 10 megahertz has been secured for this use, and this news was widely applauded across the first response community. Mr. Speaker, we are proud that we have helped to push this issue forward. We're proud that as we work in collaboration with our first responders and firefighters, we are getting results for them. Our government is firmly committed to supporting our firefighters and indeed all of our public safety officers. However, Mr. Speaker, we are also committed to respecting Canada's Constitution and the various authorities that fall within the federal, provincial, and municipal levels of government. And as the member from Wascana must certainly be aware of, because as I mentioned earlier, the Liberal Party argued in 2005 that many of the measures that he's proposing today in this private member's motion are more relevant to provincial areas of responsibility. Certainly, the creation of a public safety officer compensation benefit being one of them. As honourable members likely know very well, provinces and territories already have a legal framework in place for occupational health, safety, and workers' compensation to provide benefit to the families of workers who are injured or killed on the job. Mr. Speaker, in the United States, labour laws are the jurisdiction of the federal government. In Canada, that jurisdiction lies with the provinces. In many cases, benefits received under these workers' compensation programs are supplemented through collective agreements or group insurance plans that provide compensation for losses incurred due to workplace accidents or death. Mr. Speaker, our Conservative government stands up for our frontline public safety officers, especially firefighters. But, Mr. Speaker, in the current climate of fiscal restraint, establishing a fund in excess of $60 million, and, Mr. Speaker, there's really no way to determine because the definition of public safety officers is so broad, the amount is pretty well impossible to determine, but this amount would not be feasible. It is very interesting that when the member for Wascana was Minister of Finance, he realized this fact, which is why he voted against it in 2005. And when he talks about changing circumstances, we are in a time of even greater financial restraint and economic uncertainty. And I'm very surprised that he's changing his mind without really a lot of very credible reasons. I think it would be important that he actually stand and speak a little more clearly on why he voted against this in 2005, and now he finds it expedient to introduce this motion. Mr. Speaker, our government will not be supporting M388. Now, Mr. Speaker, I think as is evident by what we have done in the past and what we continue to do, we support our firefighters with tangible efforts that help them do their job, efforts that recognize the volunteer work that they do. But, Mr. Speaker, we will not go into jurisdictions that are not ours. We will be consistent with our jurisdiction, which is federal and federal responsibilities. The proposed changes found within this motion are more relevant to provincial jurisdiction, and that is why we will not support changes to the areas that would fall under the authority of provincial and territorial governments. I therefore respectfully ask that all members would oppose this motion. Let's continue to work for firefighters, for first responders, but, Mr. Speaker, this motion is not the way to do it. Thank you very much.
Resuming debate, the honourable member for Burnaby, New Westminster.
Well, thank you, Mr. Speaker. And I'd like to praise my colleague from Wascana. I don't do it very often, but in this House, even though we have a long association, the member from Wascana does say I should do it more often. I will in this particular case, Mr. Speaker, with the caveat that I am praising him for presenting a motion that is very similar to the motion that I presented in this House, October 2005. At that time, he voted against firefighters and public safety officers, but he has obviously gone through the Liberal Rehabilitation Program, Mr. Speaker, and as a result today, I praise him. Even though it is retroactive, he is now making amends for his vote that I think was misplaced 7 years ago. There is no doubt, Mr. Speaker, there is no doubt that this is needed, and the House made the decision 7 years ago when members of Parliament voted 161 to 112 to bring in a public safety officer compensation fund, Mr. Speaker. Now, I'm praising my colleague from Wascana. I unfortunately cannot praise my Conservative colleagues across this floor because, to my mind, they have done a tremendous disservice for the nation's firefighters and public safety officers by having voted for the NDP motion in 2005. Having refused steadfastly since that time to bring in the Public Safety Officer Compensation Fund, Mr. Speaker. I know this because every year, Mr. Speaker, nation's firefighters and police officers come to the Hill to speak to members of Parliament. Every single year they come here. And in the case of firefighters, it has been 15 years, asking a very simple thing, Mr. Speaker. All they're asking is that the federal government provide some support for their families if they die in the line of duty, Mr. Speaker. And we're asking today, is that too much to ask? Is it too much to ask when Conservatives already, prior to a federal election, said that they supported the principle of a public safety officer compensation fund, and now, 7 years later, have steadfastly refused to keep their commitment to firefighters. Is it too much to ask, Mr. Speaker? Well, I have yet another letter from yet another cabinet minister, 7 years after the fact. I've been writing to the ministers every year as firefighters and police officers gather on Parliament Hill to ask one simple thing, that we take care of their families. And yet again, this time the Minister of Public Safety is saying, while I value the extraordinary contributions made by these first responders, we will do nothing to take care of their families. I'm paraphrasing, Mr. Speaker, but that is the incredible reality of this punch in the face to the nation's firefighters and police officers, Mr. Speaker. Now, I can tell you, having brought this motion to the House 7 years ago, that there is a desperate and real need out there. I've spoken to firefighters' families, spoken to police officers' families. I've heard about what happens when you can't buy insurance, when there is no provincial or municipal support. What happens is when that firefighter dies in the line of duty, their family then has to cope not only with the terrible loss of their loved one, but also the incredibly severe financial consequences that come from that. I've talked to families who've had to sell their homes because their firefighter, their loved one, died trying to save others. I've talked to families where the kids, instead of going on to a university career or a college career, have had to try to take a low-wage, minimum-wage job, have given up on their careers because their firefighter or police officer loved one has died and the federal government does nothing to support them. These are compounding tragedies, Mr. Speaker. You can understand, like we do in the NDP caucus, that when that loved one passes away, the incredible shock that the family, the grieving, the intense grieving that the family lives through, and it is compounded by the incredible neglect of the Conservative government for 6 years refusing to implement what Parliament told them to put into place, Mr. Speaker. I'm sorry, but regardless of the beautiful speeches about standing with our responders and standing for our nation's firefighters and police officers, no Conservative will have credibility in this House of Commons until they bring forward the Public Safety Officer Compensation Fund and they support those families. That's what they need to do, Mr. Speaker. Now, we are talking about an amount of $300,000, Mr. Speaker. This is not an enormous amount. It is an amount that will allow the family to cope financially with the incredible grieving and the incredible shock of losing their loved one. In the United States, they've had it in place for a decade. They take care of the nation's firefighters and police officers who can't get insurance, who don't have access to these magic provincial and municipal programs that the government likes to talk about. It is a shameless passing of the buck for this Conservative government to say to the nation's firefighters and police officers, we're not going to take care of you. Somebody else may, but we're not going to take care of you. And particularly in light of the motion that was adopted with Conservatives saying they were going to support firefighters and police officers, it is a shameless and irresponsible dereliction of duty. Mr. Speaker, we owe it to our nation's firefighters and police officers to put in place the compensation fund. I've heard Conservatives say it really costs too much money, and we've heard this refrain since we got back, Mr. Speaker. We can't have food safety because it costs too much money. We can't have transportation safety because it costs too much money, Mr. Speaker. But this is the same government that is willing to spend up to $40 billion for the F-35s with an untendered contract. It is absolutely shameless when this government has been so inept at managing the nation's finances. You have a record deficit because of these massive spending projects like the F-35s, and yet they cannot take care of the nation's firefighters and police officers, Mr. Speaker. Well, in this side of the House, we disagree. In this side of the House, we believe that motion passed in 2005 is a moral obligation and duty on behalf of every single Conservative member to make sure that Public Safety Officer Compensation Fund is put into place. We believe it is a duty and a promise that must be kept, Mr. Speaker. And that's why every New Democrat will stand in support of this motion in hopes that when this motion passes, because I fail to see how Conservatives could possibly let the nation's firefighters and police officers down yet again. I think that would be a profound insult that I hope the public would punish severely Conservative members for doing. But we will stand in this House and vote for this motion. We hope that Conservatives will stand in the House and vote again for the motion, and vote again for the Public Safety Officer Compensation Fund, Mr. Speaker. But much more importantly, we are hoping then that finally, after 6 years of broken promises, 6 years of meaningless words talking about the nation's firefighters and police officers, that Conservatives will finally walk the talk, and they will make sure, Mr. Speaker, that this is put into place, and that when those families are grieving, they can also count on having a minimum of financial benefit to assure that their families are taken care of, Mr. Speaker. The firefighters and police officers of Canada ask not for a lot. They put their lives in the line of duty every day. Every day they hope to save lives and save Canadians. And the public, Mr. Speaker, the public is with them, because the public understands that we have a moral responsibility to take care of their families when they pass away in the line of duty, Mr. Speaker. I am hoping that every single Conservative will vote for this motion, they will keep their commitment, and in the next month we will have in place a Public Safety Officer Compensation Fund for Canada's firefighters and police officers.
Resuming debate, the honourable member for Cape Breton-Canso.
Thank you very much, Mr. Speaker, and I'm very pleased to stand and speak on this particular motion. I want to start by congratulating my friend and colleague from Wascana for putting this motion on the floor and giving us an opportunity to speak to it. I have to admit I've been both surprised and pleased with some of the comments that have come forward in the debate thus far. To have my friend from Burnaby Douglas actually commend the member from Wascana. I was surprised, I was pleased, and I was surprised with that one. Almost as surprised as I was when I listened to the parliamentary secretary from the government side actually address the House and not hear the words $21 billion carbon tax, job-killing carbon tax. I'm sure she's in the woodshed behind the PMO's office now, not having taken the opportunity to throw that one out there. Nonetheless, and again, I was pleased but surprised that it wasn't there. So, okay, whatever I could do. Mr. Speaker, this is absolutely an important bill, and certainly for the last number of years, the International Association of Firefighters have done an exemplary job putting their views and their issues before parliamentarians. And each week we come here on the Hill, or back in our offices, back in the constituencies, groups and organizations. You're in a constant state of meeting with various groups and organizations. But as has been mentioned before, the firefighters have been consistent. They're truly professional in how they approach their when they come to meet with members of Parliament. And it's been consistent year after year, and they've seen small victories, they've seen little victories, but each year the game continues to sort of move down the field, almost like my golf game, a little bit side to side, but hopefully we're making progress. And I see that in the presentation and putting forward of this particular motion here. This is an opportunity to really to recognize that their efforts over these past years have not gone unnoticed, because they have been consistent in their messaging, obviously because it means so much to so many. Mr. Speaker, you know, when we hear the debates about any legislation that comes forward with regard to first responders, firefighters, you know, many people mention the fact that they're so involved in the community. And I come from a fairly rural community. I've got about 50, I have 50 volunteer fire departments in my riding, you know, a great number of smaller communities. And they're all really the core of those communities. You know, Dominion Reserve Mines, Port Morion, Port Hood, Port Hastings, you know, and whether it's a community festival or a community event, somebody in need, those are the people that you go to. And that's all well and fine. That's all well and fine. But there are many organizations within communities that do that type of thing, that do honorable things for their fellow citizens. Where these men and women stand apart is the risk that's inherent in what they do. Where they stand apart is, as has been mentioned, they're the guys that are running into the building when everybody else is running out. And they lay it on the line for their fellow citizens. They're tasked with a job, a career in some cases, although, you know, in many cases, like in my own situation, many of these people are volunteers. But there's so much expected of these beyond what's expected of other people in communities, and it's physical, it's mental, it's emotional, it's spiritual. You know, and physically, whatever we can do to help these, there's a great deal of physical exertion, of course, when you do this, but, you know, one of the aspects of this bill, the changes to the building code, or at least being engaged in building code development that properly takes into account first responder safety issues in building designs and materials. Mr. Speaker, that would go a long way in ensuring that at least they have a chance of making sure that the materials used, that when they go into a building, or at least the recognition of the materials that are being used in particular buildings, that they know what they're going to battle when they get into there. So that would be one aspect of the physical part of what's expected of them that could be addressed through the adoption of this particular motion. But, you know, mentally and emotionally, and what I'll ask the people here in the chamber today, if you want to get a real good sense of what it is firefighters go through, I'll ask you that you pick up a copy of a book written by Russell Wangerski, and it's called Burning Down the House. And I can lend a copy to my friend and colleague from the Conservative Party. It's a great read, and it's about a firefighter who his whole life he dreamed about being a firefighter. And he got involved. He went to Acadia University, and he started to volunteer down there. And he went through his training and what have you. And you know, he took his various levels and became a firefighter. You know, we sort of sometimes they delineate between a volunteer and a professional. I'll tell you, when the alarm goes off and the truck is on the way, there's an expectation of those volunteers that they know what the heck they're doing too. So, you know, quite often the training is pretty much the same as the professional firefighters, because there's an expectation that you know, they're well trained and ready to perform when they get to the scene of a fire or whatever they're asked to do. But Russell Wangerski says in his book, he said, you know, it wasn't too bad when he was down in the valley and going to university and volunteer down there. When he went back home, it was really tough. He remembers being called into a situation. He was a first responder, and his best friend, his father, was having a heart attack, and he showed up at the scene and had to go through and try to revive his friend's father. And just the you know, the emotional impact of that, the emotional impact of going through a situation like that. Sometimes we don't take that into account. You know, you look at these firefighters these first responders, when they show up at the scene of a vehicle accident, of a car accident, and you're asked to scrape a 17-year-old kid off the dash of the car, that's not anything normal for any other citizen other than these first responders. That's not normal. You can only imagine what they go through emotionally, what they go through mentally, and even spiritually. When they're on the back of a truck and going to a fire, and the pager's going off, and they're getting more information over their pager, and they hear that it's a house fire, and that there's kids in this house. And you can imagine the heart rate going up on everybody in that vehicle on the way to put out that fire. So that's something that we don't ask of other citizens. But we expect that, and we expect our first responders to handle that type of thing. That's why they stand alone. That's why they stand apart. And the first part of this, the Public Safety Officer Compensation Fund, if their family knows that there's going to be some kind of help, that there's going to be some kind of assistance, should everything go wrong, should something inexplicably, they're just not work out the way that they were trained to work, they were trained to accept and deal with the situation, and we lose a life, we lose one of those first responders, then at least we can give them comfort in knowing that their federal government is going to be there with them, to stand with them in appreciation and in support. So, Mr. Speaker, I would hope that each and every member of this chamber searches their soul and finds a way to support this motion. Thank you.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Human Resources.
Thank you very much, Mr. Speaker. And I'm pleased to speak to the motion put forward by the member from Wascana. This motion focuses on an area of great importance to the government: the protection of the health of Canadians and the role firefighters play in this. Mr. Speaker, today I would like to use my time to speak to Part B of Motion M388. Part B of this motion calls on the Government of Canada to recognize firefighters in their vital role as first responders, as an integral part of Canada's critical infrastructure. It calls on the government to recognize firefighters as healthcare workers under the Canadian Pandemic Influenza Plan, entitled to priority access to vaccines and other drugs in cases of pandemics and other public health emergencies. Before I begin, I also want to thank the Standing Committee on Health for having adopted a motion to undertake a study that will enable Canadians to better understand how various jurisdictions deal with their vaccine priority lists during pandemics. The study is taking place this week, and I understand the committee has heard from several witnesses, including representatives from the provinces and territories, as well as from firefighters. Clearly, Mr. Speaker, our government recognizes the crucial role firefighters play in protecting Canadians. Firefighters serve our communities and our country with incredible dedication. They put their lives at risk to protect Canadians. This government and myself are very supportive and appreciative of all that firefighters do for our society on a daily basis. As a trauma surgeon myself, I've been on site with these individuals when they've done their heroic tasks, and I've infrequently, and quite frequently, unfortunately, been the recipient of the patients they've brought to the emergency room. People like Wayne McKean, the town of Blue Mountain, or Bob McKean, the deputy in Clearview, Michael McWilliams, our chief in Wasaga Beach, or Trent Eli, and Carrie and Terry Weatherup, both from Everett, who serve as volunteer firefighters, individuals who benefit from the volunteer firefighter tax credit this government has put forward. From a public health perspective, every one of us plays a role in working together to protect the health and safety of Canadians. Infectious diseases, for example, do not recognize borders, religions, culture, politics, or jurisdictions. They impact every one of us, whether we're infected or not, and our responses to these emergencies must have the same broad scope. Whether we're part of a community, a business, a school, or a hospital, whether we're a first responder like a firefighter or a policeman, an emergency medical service individual like myself, or whether we're government officials, we all have a role to play. The federal government's role is one of leadership, We work closely with other jurisdictions to develop national guidelines to help inform provinces, territories, and community responses. It is the first responders, the hospitals, nurses, and physicians, and the communities that deal first with the public health emergencies. Our national guidelines must provide them sufficient flexibility to allow for a tailored response that takes into account a community's specific circumstances as well as the characteristics of the emergency. This flexibility is extremely important. I can tell you firsthand. Local authorities prepare and respond to emergencies using the resources that they have available at that moment, and appropriately so. When an emergency exceeds local capacity or it becomes too large in scope, provinces and territories as well as the federal government assist in response efforts. In a pandemic, an important role for the federal government is to provide advice and guidance to provinces and territories to provide pan-Canadian frameworks for preparedness and response. Provinces and territories develop their own plans and implement their own plans based on their priorities and the needs at the moment. For example, the Government of Canada provides guidance to assist provinces and territories in determining priorities to antiviral and vaccines in influenza pandemic situations. Our recommendations are then used by the provinces and territories to make decisions on priority access. All of this is done on a local and unique basis in pandemic circumstances. Mr. Speaker, we believe that the country's ability to come together in the face of dire circumstances is exceptionally strong. We've done it before. We saw this particularly in our success in the response to 2009's H1N1 pandemic, during which all sectors of our country pulled together. Working in a hospital myself at that time, I can tell you firsthand that it was truly amazing the work that everyone did coming together. Put simply, a one-size-fits-all approach to something as multifaceted and complex as a pandemic simply wouldn't work. At that point in time, I was working in 2 different centres. We had different responses at both centres. We had to be flexible. We had to accommodate local needs. Only people in the province, territory, and those local areas can make those decisions. In short, during H1N1, it was all about working in tandem, hand in hand, with local authorities, provinces, and all other partners to manage this global public health crisis, recognizing our connections and shared roles. And we succeeded. And we've learned from the SARS outbreak in 2003. The Government of Canada now knows that we have some of those right tools in place. We needed to quickly produce and distribute vaccines. We have ventilators and stockpiled antivirals at the ready to support the provinces, territories, and municipalities responsible for those first responders, like firefighters and police officers, so those on the ground can make the decisions they make at the moment. And we knew we needed to keep building on that plan, to keep it in place, adapting in a real-time way. Like much of the reality firefighters face in their day-to-day work, each day during H1N1, jurisdictions had to respond quickly to emerging situations. Having a plan and the relationships in place allowed us to collectively focus and address these issues. I can tell you, comparing 2003 and 2009, the difference in the response was overwhelming. It was coordinated in 2009. In 2003, some of us were pretty scared on the ground on how that was going to be addressed. We're very fortunate to have a solid network that links all of these players with provincial, territorial, and federal governments together with stakeholders. As part of our public health structure in Canada, the Public Health Network provides a tool unique in the world for improving collaboration across jurisdictions, for keeping us on the same page and working towards the same ends, integrating policy with practice. It's a means of helping us navigate the various jurisdictional waters by bringing together all jurisdictions to the same table on the same public health issues for consistent messaging to Canadians, something that was essential for our response in 2009. A big part of the network's success is that its structure embraces the basic notion that public health is about the power of the collective. As I've said, we've all had a role to play when responding to emergency public health events. The Public Health Network has enabled planning and collaboration between federal, provincial, and territorial governments. It has supported our collaborative decision-making processes in all aspects of pandemic preparedness and response, from investing in vaccines and antiviral stockpiles to surge capacity to prevention and early warnings to research and critical science. H1N1 was an important test for our response capacities on all levels, and our country responded effectively. Mr. Speaker, from the beginning of the outbreak, this government committed to an inclusive national pandemic response to mitigate the risks to Canadians. This government, provincial and territorial governments, national Aboriginal organizations, health professional associations, non-governmental associations, members of Canada's influenza academic research community and private sector representatives all pulled together. We can be proud that Canada's H1N1 immunization rate is among the highest in the world, a sign of our collective ability to encourage all Canadians to be protected against the influenza virus. As I noted today, the involvement of all government and stakeholders is critical to the successful mitigation of the effects of any pandemic, which knows no borders and can spread quickly. The Canadian Pandemic Influenza Plan for the health sector, developed in collaboration with provinces and territories, outlines the roles and responsibilities of all levels of government during a pandemic. Canada's response to the H1N1 influenza pandemic was guided by this plan. The implementation of any recommendations on priority access would fall within the jurisdictions of the provinces and the territories. This is very clearly outlined. And I have to say from personal experience, extremely important that the provinces and the territories, local communities, make these decisions. Mr. Speaker, this needs to be carefully considered in the context of this motion. Furthermore, recommendations on priority access to vaccines and antivirals have to be based on sound principles. The immediate priority is to target those who are at the greatest risk and those who can benefit the most from the vaccine and antivirals. In some cases, it may be seniors or young children or pregnant women. In other cases, it may be healthcare workers or other first-line responders. These recommendations cannot be determined out of context. They have to be made at the time when you're standing with the patient. While the response of the 2009 H1N1 pandemic was an overall success, our government is committed to maintaining and improving our ability to prepare and respond to these emergencies. Lessons learned from H1N1 are important considerations. A number of reviews have been conducted. These reviews are reflective of the high priority this government has placed on our preparedness. It's why the Minister of Health asked the Senate Committee on Social Affairs, Science and Technology to undertake a review on pandemic preparedness. In closing, Mr. Speaker, I'd like to reiterate that this government appreciates the important role firefighters play in protecting Canadians. They are an integral part of Canada's critical infrastructure, and they are respected for the job they do every single day. But I'd also like to stress that the federal government provides advice to provinces and territories. It's the local implementation, the decisions that have to be made on the ground at the moment of the crisis that are the most important, and those need to be made by the provinces, territories, and communities. Every jurisdiction is different, and we need to respect those jurisdictions. Thank you very much.
Okay. La période prévue.
The hour provided for consideration of private members' business has now expired, and the order is dropped to the bottom of the order of precedence on the order paper. The motion to adjourn the House is deemed to have been adopted pursuant to Standing Order 38. Therefore, the question is that this House do now adjourn. The Honourable Member for Alfred Pellant on the RCMP. Thank you, Mr. Speaker. I'm very happy to have an opportunity to raise an issue that I'm very concerned with. Unfortunately, we've heard about it many times in the media recently and in recent months. As the Deputy Critic for Public Safety for the official opposition, I recognize and acknowledge the excellent work done by police officers who risk their lives on a daily basis to make us safe. There have been allegations with respect to the RCMP. In fact, recently the RCMP has faced a number of scandals dealing with sexual harassment that many officers have stated they are victims of. Some 230 women have expressed an interest to sign on to a class action suit to have dealt with the sexual harassment they're facing in the National Police Force. Janet Mello, Corporal Catherine Katz, among others, have had the courage to put their foot down and to denounce the sexual harassment they faced in the RCMP for years. Every day, those women had to overcome obstacles. It was a challenge, and today I congratulate them for having taken up the courage that they needed to draw light and attention to this issue. Catherine Galliford, corporal, was the first to denounce the fact that she had been a victim of sexual harassment. This complaint came forth in March. And dozens of other women are expected to do the same. Some 200 women, former and present members of the RCMP, are signing on to the collective agreement. The allegations run from sexism in promotions to accusations of sexual harassment, and the comments come from all across the country. On May 10th, I asked the government to start walking the walk and to take action to deal with sexual harassment in the RCMP. Last week, I participated in a debate on Bill C-40, which is an act to amend the RCMP of Canada Act and to make amendments to other related acts. It will give greater powers to the Commissioner for Discipline and the opportunity to put in place a process to deal with harassment. However, the RCMP cannot be responsible for changing the culture to deal with the specific allegations of sexual harassment. In fact, the bill doesn't go far enough to deal with the concerns of women working in the RCMP. They are calling for action to promote a more open and safe workspace. Unfortunately, the government failed. It did not take the initiative and show the leadership necessary on this issue. Since 2006, it has been in power, but despite recommendations from Justice O'Connor in 2006 and David Brown in 2007, proposed changes to the RCMP, but 6 years later, it's simply starting to look at the situation. Why did the government take so long before taking any action to resolve this issue? Why didn't it take the issue seriously and put in place concrete steps in the past to put an end to this situation?
The Honourable Parliamentary Secretary to the Minister of Public Safety.
Thank you very much, Mr. Speaker, and I want to respond to the question put forward to this House by the member for Alfred Pellan regarding the issue of sexual harassment in the Royal Canadian Mounted Police, the RCMP. Mr. Speaker, this is an issue that all of us are very concerned with. We're all concerned definitely with the issue of sexual harassment within the RCMP, certainly in any workplace. We're also concerned with the issue of general harassment within the RCMP. And as my honourable colleague will recall, yesterday we heard testimony from Commissioner Paulson where he talked about the fact that men and women both, women about 33%, men about 26% feel that they have been harassed. And then in terms of sexual harassment, there are about 3% of women who feel that they have been sexually harassed. All numbers, Mr. Speaker, that certainly we're all concerned with. And I take I disagree with your premise that our government is not taking action on this. In fact, we're taking very firm action. We made strong statements on these issues. We took immediate action by asking the Commissioner for Public Complaints against the RCMP to take an in-depth look at how harassment complaints are managed in the workplace. We also have a commissioner who has also, from the time he's been appointed, all of us can congratulate him for the strong stance that he's taken on this issue. In addition to that, our government, we've had our majority. We've been in government for just over a year. We've brought forward a lot of initiatives, and one of the initiatives that we've just taken and introduced is Bill C-42, the updating the RCMP Accountability Act. And Mr. Speaker, as my honourable colleague heard yesterday testimony from the Commissioner, and we're going to hear more testimony, this is the foundation. Change in the RCMP Accountability Act and the legislation by which they are governed is the fundamental foundation to change the culture in the RCMP, which will change harassment, certainly help bring an end to sexual harassment. It will change the complaints process and modernize it, amongst a host of other things that are being done under C-42. So it's disappointing whether the member, heard the testimony that was given yesterday, where it was very clear from the Commissioner, please pass this legislation. He was very technical in the way he spoke about how right now accusations of any kind of harassment have to be dealt with
and how draconian it can be for them. And that's why he said, get this legislation passed. We've consulted with the provinces. We've consulted with other stakeholders. We introduced the legislation. It's good legislation. It's addressing a number of factors within the RCMP and how public complaints are made, how to deal with serious incidents by RCMP, making sure that police are not investigating police. But it lays the foundation to deal with issues like sexual harassment. So we would just encourage the opposition. They've read the bill, read it again, look at a foundational way what can be done when a human resource department is able to deal with issues like this. They are usually the best to help change the culture, but they need the tools. And right now, the RCMP, under the current legislation, do not have the tools. The Commissioner was clear yesterday. He said, we don't need more money. We just need these rules changed so that we can actually do the work that we need to do. He wanted his human resource managers, he wanted his supervisors to be able to deal with issues at the level that they appear. Sometimes it's education. Sometimes it's working together, mitigation, discipline. These are all things that the RCMP need the tools to do. It's in C42. We encourage our opposition. Let's get it through committee. Let's get this into law so the RCMP can work at these sexual harassment and other harassment cases.
L'honorable député d'Alfred.
The Honourable Member for Alfred Pellan. Well, thank you very much, Mr. Speaker, and I appreciate the response from the Parliamentary Secretary. But what I do find sad is that in Bill C-42, not once is there mention of sexual harassment. It's very sad when you think that we're trying to make this bill something that's going to deal with the problem of sexual harassment. Now, with regard to the harassments, the Minister confirmed at committee during the presentation on C-42 that there was no consultation of members before putting forth Bill C-42. So it's sad to see that there wasn't any kind of formal consultation with members before that legislation was introduced, that bill was introduced. Now, I'm sure that all parties involved understand that dealing with sexual harassment in our National Police Force is an important issue, but we need something more here. We need a policy, an anti-sexual harassment policy. We need an in-depth approach. I'd ask the Parliamentary Secretary why there isn't an anti-harassment policy contained in Bill C-42.
It's a very big bill, but it's a bit of a, with all due respect, a bit of a simplistic argument that the term sexual harassment should be literally in this piece of legislation. We're talking certainly about all kinds of issues that may arise when we're talking about serious incident. It's very simplistic to name every type and form of whether it's harassment or serious incident. Mr. Speaker, what this bill does is it gives the RCMP the ability to deal with all harassment. And I think that's what we want. When we start segregating it, I think that's where the problem is. Let's deal with all harassment. And when you deal with all harassment, it will help you deal with, the RCMP will be able to deal with sexual harassment and other forms of harassment. That's what C-42 does. It also helps deal with serious incident. And I mean, if we want to start listing what serious incident is for the RCMP, again, not a good way to deal with issues that might arise with the RCMP, who, by the way, we respect immensely. 99% of the RCMP are doing a fantastic job. We respect them, but we're dealing with it under C-42. Thank you, Mr. Speaker.
L'honorable député de Charlesbourg.
The Honourable Member from Charlesbourg-Saint-Charles. Mr. Speaker, I'd like to take advantage of my time today in order to come back to a question that I raised in the House several weeks ago about employment insurance, rather. More specifically, my question deals with the use, with the notion that was recently defined by Conservatives, but which doesn't necessarily be about its application. During this question, I also had raised the issue of loss of salary. If the Conservatives went forward with this ill-advised reform, we know that the government is reserving the power to establish through regulation what will be reasonable work as well, or adequate work, as well as obligations with respect to looking for work. announcements made on last May 24th by the Minister of Human Resources and have let us understand the citizens who are unemployed will be classified under 3 different categories and subject to new regulation. After a certain time, they will be forced to accept any job, as no matter what the pay. It can go as low as 30% of their previous income. More specifically, depending on the category, a beneficiary would have to accept a 90%, 80%, or 70% reduction of their previous salary. For example, a seasonal worker who initially earned $15 an hour before being laid off during the low season would have to accept a job for $10.50 after 7 weeks of benefits, which is barely more than minimum wage in Quebec. As for the NDP, the government intention is clear, forcing beneficiaries to take a job as quickly as possible, no matter what the levels of pay and conditions and working conditions, as well as orchestrating the promotion of a massive movement of Canadian labour wherever their jobs are, no matter what the region or the province. This is practically forced work and deportation. We will be uprooting entire regions. Furthermore, these workers that are going to be forced to accept certain jobs that are not necessarily skilled for will lose their knowledge and skills bit by bit, which will devalue their skills and their qualifications. These are counterproductive measures both for society and individuals, and no one is a winner. Seasonal employers will also lose highly specialized employers. For them, it will be increasingly difficult to find workers who will satisfy themselves with jobs who will not be satisfied with jobs that don't pay them all year round. These alternate employers will find themselves with an unmotivated and difficult to retain workforce. All of this reform will have definite consequences on our economy, its stability, and its diversity. Certain people, certain groups will pay a higher price than others. Let's think about seasonal employees. And certain regionals will be emptied out because of these measures. Provinces will be affected as well because the length of benefit periods will be reduced. The buying power consumers will also go down, and entire regions will suffer from economic deflation. Vulnerable employers will also be poorly treated. The new reality of the labor market is a true explosion of part-time or contractual occasional works, which leaves the worker in a very precarious situation. I would like to hear what the minister has to say about these nefarious consequences of her reform. The obligation of the government to come back on its definition of reasonable work, as well as information concerning the regulations that are to be announced.
Mr. Speaker, I'm pleased to respond to the honourable member from Charlevoix, Saint Charles, on the subject of employment insurance. Our government's top priority remains job creation and economic growth. The approach
adopted by our government in order to twin these measures with available work is reasonable. Mr. Speaker, we're talking about providing Canadians with the tools that they need in order to successfully reintegrate the labor market.
Unable to find employment, employment insurance will be there for them as it always has been. In addition, unemployed Canadians will not be required to relocate to another part of the country for fear of losing their EI benefits. Mr. Speaker, the government will provide targeted, enhanced labor market information to help unemployed Canadians make informed decisions about the future. We will also better coordinate the EI program and the temporary foreign worker program to ensure that Canadians have access to all jobs in their community first. Let me talk more about the labour market information. Right now, through job alerts, EI claimants receive up to 3 job postings when they apply and complete their online report every 2 weeks. This isn't enough. In fact, many claimants do not receive any listings at all because Job Banks carries only 1 in 5 jobs that is advertised online in Canada. Under the changes, job alerts will be improved to send claimants daily job postings for their chosen occupations in communities or regions from a broader range of sources, including those from the private sector job boards. The alerts will also include information on wages and demand for selected occupations. Having access to this information will allow claimants to make informed decisions about how best to conduct and expand their job search. As for the factors that will determine suitable employment, Mr. Speaker, these include personal circumstances. For example, people receiving EI will not have to accept work if they have a health problem that prevents them from taking a particular job, if they have a family obligation that prevents them from working certain times of day, if they have limited transportation, or they're not physically capable of performing the work. Vacant positions must not be directly related to strikes, lockouts, or other labor disputes, and the driving time must be within 1 hour commute, perhaps higher, taking into account the claimant's previous commuting history and the community's average commuting time. Suitable will also be determined by hours worked and the type of work to be done, responsibilities, tasks, wages, and experience. As time spent on EI claims increases, claimants will be required to expand what they consider suitable in terms of work type and hourly wages. As we've faced unprecedented labor and skill shortages, it's important that the Employment Insurance Program is working effectively for Canada and Canadians. These changes will strengthen the EI core insurance principles, making it more efficient and fair for everyone. Thank you very much, Mr. Speaker.
L'honorable député.
The Honourable Member for Charles. This would go against lower wages and worsen working conditions for all. It will also impoverish the unemployed. Will a worker be forced to accept a job at 70% of his initial salary if they were to lose their second job? How can you decide what the salary of a new employee will be without attacking their true skills if the employers are basing it on the previous salary, which was already reduced by to 70%? This reform will stigmatize the unemployed even further by ceaselessly repeating that the unemployed are lazy and that they must accept their responsibilities. Conservatives are contributing to the stigmatization. We're even wondering if this is not an attack on fundamental human rights. In fact, in the Universal Declaration of the Human Rights, it says, every person has the right to work, to freely choose their employment, and to be protected against unemployment. Mr. Speaker, I remind you that we are members of the ILO. What is this government waiting for in order to protect our workers and offer to our workers a true job creation plan?
As I've mentioned before, our government's top priority is creating jobs, promoting economic growth, and getting Canadians back to work in their communities. The government will make that connection easier, Mr. Speaker, by providing targeted and enhanced labour market information, linking unemployed Canadians with available jobs in their communities. In return, EI claimants will have a defined set of criteria that will help them in their search for suitable employment.
For us, providing useful tools to help the unemployed seek employment and find jobs. We also, however, emphasize that they have the responsibility to search for reasonable work in order to find an appropriate job. It's simply an issue of common sense.
Better connect them with available jobs in local areas that are appropriate for their qualifications. These are common sense and reasonable changes that are in the best interests of Canadians and the economy. Thank you.
The Honourable Member for Malpeque, Ethics.
Thank you, Mr. Speaker. On May 2nd, I asked the following question to this ethically challenged government. It was, Mr. Speaker, a year in, the government is showing how tired and corrupt it really is. The CEDA minister who believes taxpayers are there only to support her lavish lifestyle, the Minister of Industry who believes industrial development is keeping the Ethics Commissioner's office at work, investigating himself 3 times, a Treasury Board Minister of gazebo fame, and the Minister of National Defence who has helicopters as his personal limousine, and of course the $9 billion fib. I asked, how can the Prime Minister condone such a crew of tainted ministers? At the time, I pointed a troubling trend of this government, namely that Conservative ministers, from the President of the Treasury Board to the Minister of National Defence to the former Minister of CEDA, all seem to regard government assets and taxpayers' dollars as their own personal property to be used whenever it suited them. This is a crew that somehow believes that they simply say things like transparency and accountability, and they mean something. The obligation on ministers is to represent an ethical standard by which this government is gauged, and they've failed sadly in that standard of accountability. It would appear any standard of expectations is something Conservative ministers have difficulty with. But, Mr. Speaker, that was last May. It's now October. Now we have to add to the list of ethically challenged ministers the Minister of Health, who has gone missing in action on the E. coli outbreak, and that repeat offender, the Minister of Agriculture. The Minister of Health, through her offices and that of the Public Health Agency, have a duty, an obligation to engage the Canadian public when it comes to a health care issue. Either this minister has no understanding of her duties or has been instructed to sit in her place and ignore what is happening across this country. This is the biggest recall in Canadian history, and there are Canadians who have become ill as a direct result of the meat which reached store shelves. Consumers want assurance, and the Minister of Health has a responsibility to give them that assurance and lay out the plan where government is dealing with this crisis. But then there's the Minister of Agriculture. His latest performance with respect to E. coli outbreak has resulted in the largest recall of beef in Canadian history, in which we witnessed the spectacle of this minister telling the House that none of the infected meat reached store shelves. Well, we know differently, Mr. Speaker. We know it reached store shelves. And yesterday we had the spectacle of the minister calling a press conference not too far away from XL plant. And we've seen the minister practically run from the media. And not only did he run from the media and go into hiding, but his staff then hauled the president of CFIA, the Canadian Food Inspection Agency, off the podium when that man, who is responsible for food inspection in Canada, was trying to answer a question from the media. But today we've seen the minister shamed into another press conference, and at least he answered a few questions, but he only gave excuses. Mr. Speaker, this government is a government that time and time again on issues large and small has shown a contempt for Canadians. So ask again the question I posed last May. How can the Prime Minister condone such a crew of tainted ministers?
The Honourable Parliamentary Secretary to the Minister of Human Resources.
Thank you very much, Mr. Speaker, and I'm pleased to rise today in the House to respond to the Honourable Member from Malpeque. I must say I find it quite ironic to rise. The Honourable Member seems to have completely forgotten the days of the sponsorship scandal, a scandal that his party and his Liberal government allowed under their watch. It was a scandal that saw millions of tax dollars wasted on egregious kickbacks and party favours to Liberal donors and friends. On this side of the House, we respect the hard-earned tax dollars of Canadians, and that's why our government has maintained the highest level of accountability when spending tax dollars. Since taking office, our government has reduced the cost of travel by 15% and accommodations by nearly 8% for ministers from the high levels it was the norm under the Liberal Party when they were government. We're a government that respects the Canadian taxpayer, and we've delivered results. Whether it be helping young Canadians with access to labour market through our youth employment strategy or stimulating small business growth through the extension of the hiring credit for small businesses, our government is committed to ensuring that Canadians get value for their money. We respect their hard-earned tax dollars. With respect to the comments regarding the ministers of the House, I want to state also again, as I did several times last evening, this government acts to protect Canadians. The health of Canadians is the government's first priority. We have increased the number of food inspectors by over 700 individuals, in fact, over 170 meat inspectors. This is something that we've acted on, we've moved forward on to protect Canadians and their health. The opposition members have voted against all of these increases. Suffice it to say, the member has it wrong. I encourage the member to remember the sponsorship scandal, the reason why we're a government, because we are accountable and we take account of Canadian taxpayers' dollars. They seem to have forgotten how to do that.
The Honourable Member from Malpeque.
Mr. Speaker, clearly the Parliamentary Secretary hasn't addressed the question. She goes back through history and tries to lay an attack, but it doesn't hold water anymore. There was a public inquiry. That was settled. There wasn't a Liberal elected person charged under that. But she wants to talk about scandal. Fact of the matter is, what this member is doing tonight is the kind of doublespeak that we've seen all along. She tries to fluff away the current E. coli crisis, when in fact we all know there's the biggest beef recall in Canadian history. Something went wrong. What are those 700 inspectors doing? Are any of them in a primary slaughter beef plant? Was there really new people added there? And what is really needed is for the Minister of Health and the Minister of Agriculture to come together and give some assurances to Canadians so that consumers can have confidence in all the good beef coming from operations.
The Honourable Parliamentary Secretary.
Thank you very much, Mr. Speaker. And I guess speaking to the question that the member originally put forward, Mr. Speaker, the member opposite certainly has a lot of courage to stand up in this House and make those remarks about the Liberal Party, which totally disregarded the Canadian taxpayers' hard-earned dollars during the sponsorship scandal. On this side of the House, we respect Canadian taxpayers and maintain a high standard for the use of taxpayers' dollars. With respect to the specific plant that he refers to, in fact, there has been an augmentation of the number of inspectors, in fact, also the number of veterinarians at that site. I encourage him to look at those facts when he makes comments as he did in this House. Now, we'll continue to stay focused on the creation of good-paying jobs, full-time jobs, continued economic growth, those things that Canadians are focused on, as well as making sure that food in this country is safe. That's why we've augmented the number of inspectors. That's why we've augmented the number of veterinarians at this plant. That's why we've augmented the numbers overall. I encourage him to take a look at the facts. Thank you, Mr. Speaker.
La motion portant que la Chambre s'adjourne.
The motion to adjourn the House is now deemed to have been adopted. Accordingly, this House stands adjourned until tomorrow morning at 10 a.m. pursuant to Standing Order 25-1.